Please.
Milord, I pray for leave to file by the server copy. Yes, Lieutenant.
Maybe permit to mention, I'm mentioning for inclusion the first appeal I have
What?
mentioning for inclusion the FAT against the matrimonial discourse.
Application or
FAT, yes, sir, application.
FA or application? FA is the appeal hearing.
Application. Can
This is
one,
the application number.
can one and can two.
Yes.
With a kind leave of your lordship, may I mention a specifically assigned matter before your lordship? It's an appeal against
It's
a
not appearing in the list.
no lordship. It's a
Just hand over the slip. We'll ensure that you'll
My lord, let them serve a copy on me. I am appearing for the respondent.
It's an urgent matter, my lord. It's a refusal. It's an appeal against a refusal.
whatever,
of
give a
the-
copy to them.
My lord, it's been
I've been doing
pending
the
since
course
10th of
I-
September 2024.
Pardon, ma'am.
It's a refusal against the section.
Whatever
nine
it is, you have to give a copy to them.
I'll serve it during the course of the day. I was praying for
Do that,
urgent
do that.
listing of
It
your
will come up
lordship.
as soon as the file comes. Yes. Yes, ma'am.
I'm petitioner of FMA
That's
2447. I want to submit the original documents of my enrollment as advocate. Kindly see this.
No. Please do that when the matter is called on. Keep them with you. Those are precious documents. Keep them with you. It will get misplaced in the court. When we call on the matter, then hand over.
Actually, this that day I could not speak.
Not now, when the matter is called on. Next.
No, your lordship, kindly allow me 1 minute.
Oh,
Item number 1.
yes. Who is appearing in item number?
Your Lordship, I am for the respondent. I have
And I appear for the plaintiff. Yes, appellant, your lordship. On the last occasion, the lordship was pleased to
The records are
directly serve
missing.
note.
Records are missing.
Lordship records are missing.
We'll direct reconstruction, whatever paper.
Your Lordship, we do not have any records as
Whatever
well.
We are also
We
lordship.
have written a letter to them to provide us with the
We
records.
also don't have any records, your lordship, mostly.
We have applied for the certified copy from your Lordship.
What is available here?
Mostly, your lordship, the trial court records are.
Certified copy cannot be provided like that. Record is missing. What certified copy will provide? In the first place, because the record is missing, we are asking for papers from you. What is the use
We
of
don't
filing?
have any papers, your Lordship.
The first appeal.
Lordship, this is the first appeal from the order of the learned civil judge in Alipur, your lordship.
If you
But-
don't have the papers, we cannot hear the appeal ever.
Lordship, kindly fix a date after vacation. Whatever papers we have, we'll produce.
Very well.
That may be also supplied to us.
Yes. Upon query of court, learned counsel for the parties submit that they are handicapped in view of very few papers being available to them. Full stop. Next para, we find from the records, we find from the noting of the office and the ancillary papers that the records of the matter have gone missing. Full stop. Next para, the registry is directed to further check whether any records of the matter are available. Full stop. In the meantime, the parties shall gather whatever papers they are and circulate copies among themselves. Full stop. Such papers shall be brought on the next returnable date for passing further directions for reconstruction, if possible. Full stop. Let the matter be listed accordingly under the heading to be mentioned on November 4th, 2025. 1 day after reopening.
I'm
Whatever
grateful.
papers you have from your client anywhere, just try to.
I'm
because
grateful, your lordship. I'm grateful.
You are for the state.
I'm for the Metro Railway, your Lordship.
So you should have the papers. Your office should have the papers. Check up the
19,
papers.
we have checked up.
Don't
we
take
don't-
advantage because it's there.
Your Lordship, I have written a letter to them stating that we don't have.
Let
these
us won't
papers.
do. Press them to
Your Lordship, we
tell
will
them the
try.
court is asking for the papers.
We will try.
I'm grateful.
God bless you.
And
Item number 2.
Lord, I was under an impression that the service has not yet been completed. The private respondent number 6 and 7, so far as the service is concerned, postal receipt saying that that is in the SO. Assignment is in the SO. But my learned friend is appearing for
7.
6
Are you
and
ready?
7. No, I am
Or on
not
that
ready.
presumption you.
No. Only will fix it on Monday, Lord. I one go because voluminous document, Lord, I have to place it.
Well, counsel for the petitioner seeks an adjournment. Full stop. Let the matter stand over till September 22, 2025. Come back on.
Great.
Item number 3.
Lordship, I am appearing for the appellant wife. Mr. Basu was appearing
Yes.
for the husband. So there are 3 applications. The first one is for enhancement of the maintenance granted. Second one is for the implementation of the earlier order. And the third one is perjury.
Perjury application has been filed by them.
I have filed. The facts of the case in a nutshell is that the husband obtained an order of divorce. I am the appellant herein. The 125 court has granted maintenance of 20,000 rupees. When the appeal was moved, I filed an application section 24 and was granted.
What is the perjury? Nature of perjury?
Perjury is that in the statement, in the affidavit of assets, the husband says that his income is 1,37,000, but he says that he has no other income but pays EMI of more than 2,50,000. This is the first ground. And secondly, he has also filed another supplementary affidavit disclosing two income tax returns of 2017, 2018, 2018, 2019, and says it is not taxable. But from the annexure, it is clear that he has paid taxes and it was assessed or based on the TDS already paid. Because the TDS already paid at the last, when the computation was done, it says the tax payment is zero, the balance amount is zero. So he says that it is not taxable, but TDS was never refunded. This is the second point. And thirdly, the third point is that the balance that has been disclosed in different bank accounts, in no account the balance is more than 20,000 to 30,000. It was in the affidavit of assets. But before that, he transferred nearly, in installments, an amount more than 3,50,000 in my account itself. So within 2 months, he discloses that he has only 20,000 in the account, but he transfers from the same account 3,50,000 into my account. So where does the money come from when he says his income is only 1,37,000 without any other disclosure? These are the 3 points in the perjury application.
Yes, Mr. Basu, what are you?
No, but I have first.
It has been admitted. None of these allegations has been dealt with or denied in the opposition. The only case that has been made out is that everything was written based on a financial advisor's advice, and no name has been disclosed in this regard.
But first of all, there are three applications. First is CAN4.
We are taking up the perjury first.
Yes. Perjury, Millard. That first of all, Millard, in the bank
He has
account.
made
Millard,
3 allegations, Mr. Basu.
yes.
First
Millard,
allegation is your EMIs apparently are more
Yes,
than your.
he is right. He is right.
Third, then we are not
Yes,
repeating.
no, Millard, he is
So
right.
answer the 3
Now,
questions.
Millard, I have said that I have taken Millard loan, personal loan, from different banks.
There
Number
are 3
one.
questions, Mr. Basu. Let us repeat first.
Yes.
One is that your EMI is more than your income.
Yes.
It's not credible. Second is that 2017, 2018 and 2018, 2019, you said the income is not taxable, but your assessment shows TDS was deducted with regard to those, the entire thing. Third is your account balances, all the accounts have balance about 20 to 30K, 30,000.
Yes, Millard. First of all,
But
Millard, yes.
that you have transferred 3,50,000 to her account from the same account just previously.
Millard, yes.
Deal
Millard,
one by one,
yes.
please. Don't confuse the 3.
No. Millard, first of all, Millard, the bank account, Millard, the supplementary affidavit.
EMI more than income. First
Yes,
deal with
EMI more than income, supplementary affidavit কই আমার যেখানে দেখিয়েছি ওটা অ্যাকাউন্টস তো
And well, 2 supplementary affidavits have been affirmed. One has been filed, other has been not filed because I have taken this point. The first supplementary affidavit in which the income tax returns have been disclosed, that was served upon my advocate on record, but it has not been filed because yesterday I was checking the records, I found it out.
filed for not filed.
whatever copies you have filed, please file it. Whatever copies you have served, file it.
There the income tax returns are there, but not filed.
আরে এফিডেভিট তো দেন
Those IT returns show these TDS being deducted and all these.
TDS being deducted, but above is that there is not taxable.
আরে একটা কপি দিচ্ছিস কেন এটা কথা বলছি
নোটটা দে।
But first of all,
Yes.
it is true, Millard. Mr. Chatterjee has said, Millard, in the first affidavit in opposition, Millard, the bank accounts, the number of bank accounts, and Millard, the actual incomes were not disclosed. By an order dated 7/7/2025, before he pointed out, Millard, I mentioned this matter, your lordship granted leave to file an affidavit, supplementary affidavit, correcting, Millard, the mistakes that were.
That is not his allegation.
No, number one.
The allegations first.
No,
one is
first of all, Millard,
income.
ওটা দে, যেটা দে,
You have given it 3 specific allegations. Please answer those.
Millard, this answer, না, যেটা দর্শক বলছে, লোনটা যেটা নিয়েছিলাম,
EMI more than income, how can it be?
EMI more than income. ওই affidavit to the- affidavit to the-
যে এফিডেভিটটা দেখালাম যে ইনকামটা কি করে হচ্ছে।
Medical cert.
Well, this is the supplement affidavit in opposition. এটাই দিয়েছিলাম তো, ইনকামটা যেটা দেখেছেন।
So what is your answer? Give us the answer. We'll
Yes,
look into the
Millard, I
affidavit later.
said, Millard, that my income is 1,37,000. I gave EMI Millard more than 2,50,000. I said, Millard, that in my affidavit that I have taken loan from the various institutions, financial institutions, and Millard, suppose I took loan from Millard, Mr. Chatterjee, and then Millard, a repayment Millard comes from Mr. Dey, and I Millard pay it off to Mr. Chatterjee. It is not my income. It is Millard, I took various loans and borrowed money from the different financial institutions.
Those loans have not been reflected in the affidavit of assets.
Millard, these loans,
Those are liabilities.
Millard, the loans are, yes.
Those loans.
Total loan, yes, total loan I have said.
How much?
That is Millard, as per my statement of accounts, my statement of liabilities as on 31st March 2025 is 89 lakhs 74,284. Page 2 of my affidavit.
What is the breakup?
The breakup, Millard, the details of bank account I have given, that is the Millard statement of accounts, Millard, that I have said, Millard, that is it is in my accounts.
How much?
89 lakhs 74,284 92 paisa. That is at page 4, paragraph 4, total loan amount. And as per my statement of accounts,
Affidavit in opposition to which one?
to Millard,
To which
to
application?
the supplementary affidavit on behalf of the respondent, Millard, that is Millard,
We have one
on
supplementary.
6th August 2025. Affirmed on 6th August 2025.
6th August. Where is that? You have not filed it?
6th August. Kal this is 6th August.
That was filed in connection with which application? Your learned junior arranged the papers.
কালকে তোকে তো বললাম লিভ নিয়ে ওটা করার জন্য।
That is
The
in
affidavit in
respect of
opposition,
Can
this is in connection with Millard affidavit. Affidavit in opposition and assets on behalf of the respondent. কিছু কিছু লিখিস নি, কাল তো বলার পরে জজের লিভ নিয়ে বললাম তো করার জন্য।
পরপর সাজিয়ে দিয়েছি, পরপর সাজিয়ে স্ক্যান করে পরপর স্ক্যান করে অ্যাপ্লিকেশন দেন অপোজিশন।
তো বুঝবে কি করে?
While we are
Because
arranging,
supplementary affidavit is there in Can 4. Affidavit of compliance. That.
affidavit of
Millard,
compliance,
affidavit in-
thereafter there is a reply
No,
and
no.
also
Which
supplementary
page
affidavit.
4 of which affidavit?
Millard affidavit affirmed on Millard 6th August
So date
2024.
1 2. What is the caption?
The caption Millard, the supplementary affidavit on behalf of the respondent husband only. Can applicationটা লিখলি না কেন?
এটা
কালকে
তো
আমি
18th
বললাম তোকে। তা লিভ চাইলাম তো, তোকে তো বললাম লিভটা কর, আমি তো
এটা তো এখানে নেই। এটা কোন অ্যাপ্লিকেশনে কানেক্ট করা? অ্যাপ্লিকেশন তো লেখেনি।
এই তোমার answer।
Mr. Dey, you arranged yesterday. Which one?
Yes,
But
Can 4
after Can 4, the reply, there are two supplementary affidavits.
নেই তো।
We find only one in this copy.
Millard,
Application for
file that.
enhancement. Affidavit in compliance is there. Then
Millard, may I?
In the supplementary affidavit, the Can number is not written. That
no,
is why
none of the supplementary affidavits can number is.
Rashid will find its the number is S44521.
You don't find it in my copy.
Millard, may I?
It was arranged by Mr. Dey yesterday.
Yesterday, Millard, kind.
Sorry.
কাল
Only
ছিল?
one supplementary affidavit we filed.
কাল ছিল?
Please don't disturb the arrangement.
No.
The way in which it is arranged. No. Di, গোটা ফাইল করতে হবে তো দু কপি।
ফাইল করেছিস?
হ্যাঁ বলছি এই তো এটা হচ্ছে
এইটাই তো করিস।
6
একটা কাগজ
একটা লিখিস। কাল আমাকে বললাম লিভ নিয়ে করার জন্য। না, can নাম্বারটা লিখে
করেছিল আমার সঙ্গে ছিল। Can 5 এই তো Can 4
না। তারপরে দুজনে সাজা দিতে হবে।
পজিশন এটা পরেই
নেই তো।
রিপ্লাই
আরে উপরটা দেখ না, 6th August দেখ।
এটাই এই
6th
মানে
August।
দিস
এইটা একটু দেখ। Millard, I'm sorry, Millard.
No, it's sorry. What can you do? Okay, मुझे दिएছে। Yes, page 4.
Yes, Millard, paragraph 4.
Paragraph
Page 2. It is not Mr. Chatterjee's case that this statement is contrary to my ITR returns. As per my statement of my accounts, my statement of liabilities as on 31st
So
specific date.
this chart is corroborated by documents. Your
Milord, no, I have taken
your
it.
statement won't do. We don't believe your client.
Milord, account number.
Making false statements continuously. Your client.
No,
You
Milord,
affidavit no-
Milord, as
We don't believe your client. Where are the supporting papers?
Milord, these are in as per my statement of
And
accounts.
then if these are not supported by papers, Mr. Bose, your client is guilty of perjury.
No, Milord, because this is Milord, this is has not been controverted by any evidence. He did not.
They need not controvert. It's your special knowledge.
Yes,
That
Milord,
this
I
is
have
106
said.
for you.
Milord, as per my statement of my accounts, my net surplus, I have said 1 lakh.
Where are those statements? Show us from the statements.
Milord,
You say as per your statement of accounts, these are the picture. Where are those statements?
Milord, these statements are not with me, but it is Milord that is in
Your
control.
bank statements will be with him. Her.
No, my bank statement, Milord, he did not.
You are saying this is your affidavit. We don't believe your affidavit
Milord,
at all. Where are the supporting papers, Mr. Basu? Please show us the supporting papers. Your client has been telling lies left and right.
Milord, I tell you, Lordship.
Every time you are caught by him and you are doing it.
First of all, Milord, before he points it out, Milord, I mentioned this matter.
Where are
Milord,
the supporting papers?
Milord,
We want the
Milord,
supporting
Milord, I will produce the ITR then.
We'll know future tense. It's sufficiently long drawn
Milord,
already.
Milord, I tell you, Lordship, Milord, this bank account.
You
was-
say that as
I-
per my statement of accounts following on my liquid assets. Where are your statement of accounts?
Milord, it is pointed out by me. Before he points it out.
You are pointing out these may be lies, utter lies.
Milord,
Where are the statements of accounts? I ask you a simple question, Mr. Basu.
Milord, I will produce tomorrow.
We'll produce. There is no scope of further production. It's a perjury matter. You are not even entitled to a hearing. We have given you sufficient opportunity
Milord,
to
this
file
is, Milord,
affidavit.
this is the
Mr.
statement.
Basu, 1 second. Let us complete.
Yes.
Perjury, you have no right of hearing as a matter of right. No. Second, we have given you ample opportunity to file opposition. You have filed opposition, supplemented affidavits, 2 supplemented affidavits. If it is not there, it's not there. We are passing final orders today against your client.
Milord, kindly.
No
Milord,
further opportunity to
Milord,
produce
there
any
is- there
document.
is no
Every time we
evidence.
confront you, we are producing a
No,
document.
Milord, kindly, Milord, says there is no contrary evidence before your Lordship. I said, Milord,
Need not be.
Milord, before your
Mr.
Lordship.
Basu, sorry.
Milord,
You are, no, sorry.
Milord,
You are,
kindly-
no, sorry. You are stating an absolutely wrong proposition of law with due respect to you.
Milord,
They need not rebut this evidence because you have not even proved your evidence. It's your burden and your burden and your initial onus, Mr. Basu, to prove your statement as to your income because it's your special knowledge.
right.
They have no onus to rebut. They need not say anything contrary. We don't believe this. Where are the supporting papers? You prove it.
Milord, I tell you, Lordship, Milord, when Milord first affidavit, Milord, when I disclose my account,
We want to see these statements.
I produce it.
Where are those?
Milord,
Those are not there in papers?
Milord,
No.
I will produce it, Milord, kindly, because it has a severe ramification, Milord.
A severe allegation. Every time you are giving you opportunity, you are filing a
Only
new
one day,
affidavit.
Only one day,
No.
Milord. Tomorrow I will produce, Milord.
Mr. Basu,
Milord, at
sorry.
2 p.m., Milord.
No,
At
no.
2 p.m., Milord,
No,
kindly,
no, no.
I will ask my
We
client.
have given you sufficient opportunity
Milord,
in a perjury proceeding. This is enough. Enough is enough.
Milord,
Every time they confront you with something,
Milord,
you are producing a
First of
document.
all, Milord, first of all, before they confront me, Milord, I disclose out of my own volition.
This was served in 2nd of July, and this is
Did
affirmed
not
on
disclose of your own volition.
No, Milord, yes,
2nd of
absolutely.
August.
No, Milord, I am before the highest court of the state. Milord, kindly see 7th July 2025 order. Milord, first of all, Milord, I mentioned this matter. I pointed out that there is a suppression. And
You have
Milord,
suppressed. You are pointing out. What is the fun in that?
No,
I am the Muslim. I protect. Give you
no,
protection against myself.
No, Milord, I am saying that there is.
Don't be holier than thou.
No, Milord.
Sorry, your client is not holier than thou.
No, Milord, I tell
No,
you.
he's not at all holy.
Milord, I
Very
tell
sorry.
Milord,
You are pointing out and you are producing the
No,
documents.
Milord, I produce the
You
documents
suppress,
because
you
before they
point out.
it
You, no, not before. It's not a question of before them. It's between you and the court.
Yes.
You produce you suppress a document. You then point it
I
out.
said, Milord,
What
I
is
said.
the sanctity about it?
No, I am not claiming any sanctity. I am saying that, Milord, before, Milord, anyone in the proceeding, Milord, points it out, I mentioned this matter, the leave was granted.
Very well. So why didn't you annex the supporting
Milord,
document?
I tell you, Lordship.
You have filed your affidavit of assets, Mr.
Hey,
Basu. One second.
Yes.
You have filed your affidavit of assets.
Yes.
You have not disclosed these documents. Is that not perjury?
Milord, the omission, Milord, I am producing.
Your statement of accounts are not produced. Is that not perjury as per Rajneesh versus Neha? Have you complied with Rajinish versus Neha?
Milord, I tell you, I will show your lordship the Supreme Court judgments. And Milord, I say, Milord,
Don't show judgments to us. First, you purge your perjury.
Milord, Rajinish versus Neha, Milord, kindly see.
Affidavit of asset, you have not disclosed this even.
I have affidavit of assets, I have disclosed, Milord. I have said.
These
Milord,
account statement of
no,
account
this
was from
account
your
was
affidavit.
not there. That is why, Milord, I sought for
Aren't
leave.
you supposed to disclose every statement of account?
Yes, yes, Milord. I said, Milord, that.
Why are you so loud about that?
No, Milord, I am not loud. I am saying, Milord, that.
You are so loudly defending your client, Mr. Basu.
No, Milord. I
Your client's head should hang in shame.
No, Milord.
You have suppressed the statement of accounts in your
Milord,
affidavit of asset.
Milord, I tell your lordship, Milord, that this is, Milord, this omission.
And you are so loud about your client.
Milord, I never. Milord, because I tell your lordship, if I did so, Milord, I tender my apology. But Milord, the question.
Your apology, we are not about you. It's not about you at all.
No,
As counsel, Mr. Basu, you are sufficiently respected.
No.
We are speaking through you to your client.
Yes, Milord. Milord, I tell your lordship, Milord, my highest obligation to the court, not to my client, Milord. He, Milord.
We know you, Mr. Basu. We don't have any qualms about your practice.
No, Milord.
Everybody knows your ethics structure.
No, Milord.
But what about your client?
No, Milord. I tell your lordship, Milord, since Milord, the court's mind is, Milord, enveloped with certain doubts, it is my duty, Milord, to point it out, Milord, the entire statements of accounts, and it is corroborated.
Every time you cannot.
Not every time. 2 p.m. Milord, or 3 p.m. I will come back, Milord. 2 p.m.
This is a statement of accounts.
Yes, I will ask my client.
2 p.m. we have a single bench.
Milord, tomorrow in the morning, 2 p.m. or 2 p.m.
Tomorrow do you have division bench? You are not supposed to know. You are not.
No.
Much higher up.
Monday at 10:30, I will produce all accounts.
After Monday, Mr. Basu, whatever documents you have,
Everything I will.
During
Everything
here,
I will.
we'll
If
get
only
that.
one thing,
Milord, yesterday-
only one thing that my learned senior friend was so long saying that he was the first person to point it out. I filed an affidavit in reply in Can 4 where I took all these points. This was served on 2nd of June 2025.
And this was affirmed.
Leave was taken on 7th of July 2025 and affirmed in first week of August 2025.
Leave was, it was mentioned, Milord, before that. Number one.
Leave was taken
Number two, yesterday also,
on
Milord,
7th of
virtual
July
mode.
2025.
Milord, on the virtual mode, I mentioned that there was an office report that my advocate on record, Milord.
It's completely different case.
No.
Because
I'm
there was
saying
no
that-
NOC of a learned advocate on record. That's a different case.
No, she filed NOC. Your lordship.
That's a different case altogether.
Milord, here, Milord, I will show, Milord, one after another, Milord, there is no element of perjury. There is an omission.
After I pointed out, now
no.
this
I will show. And if I fail to prove, Milord, whatever, Milord, I leave it to your lordship's conscience, Milord, that the statement I have said that the 89 lakhs to 34,794, the amount, Milord, I took loan from the different financial.
Get an affidavit affirmed for filing those documents. Do that by tomorrow. One page affidavit, just that these documents are true. Do that. Give a copy to him by tomorrow, and we'll take it up on Monday. During
3 points are there. Let him, Milord, if such is
we have repeated thrice to counsel 3
Yes,
points.
yes.
If they fail to take note, we have nothing to do.
No, Milord.
We have pointed out to Mr. Basu thrice. He was not listening twice. That's why we pointed out the third time.
No, Milord. I'm sorry.
Now it's on him and his client. During hearing on the perjury application, learned counsel appearing for the respondent husband contends that the details of the bank accounts and their respective branches of the husband were disclosed in a supplementary affidavit affirmed on August. This is 4th August.
Yes.
August 4th, 2025.
6th
Question-
August.
6th or 4th.
the 6th of August.
Our officer's handwriting is equal to mine. 6th August.
6th August.
On August 6, 2025. You know the date when it was?
Yes, 6th August.
6th August 2025. Full stop, next para. However, we do not find any statement of accounts of the husband to substantiate such statement made in paragraph number 3 at page 2 of the said affidavit. Full stop, learned counsel for the respondent husband undertakes to file the supporting statements of accounts to substantiate the said statement during the course of the week. Full stop, next para. Accordingly, the respondent husband shall affirm a further affidavit annexing the relevant statement of accounts and give an advance copy of the same to the learned advocate for the appellant wife by tomorrow. Full stop, next para. The matter shall be listed next under the same heading on September 22, 2025 for passing further orders. Please come.
22nd
না না সকালে
সকালেই লাগবে 10:30
এটা ওপরে থাক, বাকি সব যা আছে এটা ওপরে থাক। আর এটা
ডিপি
এটা আজকে হচ্ছে 18 তারিখ।
Item number 4.
এটা দেখেছি না, এফিডেভিটটা ফাইল করেন না পারজারি।
Petitioner led by learned advocate Mr. Prosenjit Mukherjee.
We're not interested in that. You move the matter. Whoever is leading you, leading you.
Lordship, yesterday we were directed to serve a notice upon the state.
Yes, they are here, so move the matter. Now hand over the notice. Then
Lordship, we have
what extension? Extension of what have you sought?
extension of Lordship on the last occasion passed to maintain status quo regarding the nature, character, and possession of the party. The Lordship, we are praying for the extension of the same order.
When was the order passed?
7th January, my lord.
7th January. This can 1 is for that. Can 1 is for that.
Yes, Lordship. Lordship, we are praying for the order for extension till the appeal is pending before the concerned DL LRO, Lordship.
Oh, Mr. Adok, apparently Justice Chakraborty's bench had directed the appeal to be disposed of within a limited
What
period.
has happened, my lord? The matter was already disposed of, my lord. What is matter, my lord? This is the pond, my lord. Land is pond, my lord. Without any conversion, my lord. Any, my lord, permission from any authority. My lord, they constructed a, my lord, commercial building and they, my lord, started for business, my lord. After that, my lord, BLRO was rejected this, my lord, conversion.
So whatever,
After that,
an
my lord,
order
he
has
preferred an appeal is pending. But, my lord, this is the conversion portion, my lord. Here stated, my lord, my
no,
lord.
no, DLRO was directed to address the issue. Therefore, DLRO now sees with them. He expected that while considering the case such and such, it would be appropriate to direct the parties to maintain status quo, nature, character, until the matter is considered and disposed of. Has he disposed of the matter, DLRO?
I don't
Lordship,
have, my lord.
it is still
Yesterday, my lord, I have come, my lord, because, my lord, I have no instruction, my
So
lord.
we'll extend the interim order till the matter is disposed of.
My lord, kindly, my lord, kindly, my lord.
No, no, you cannot take advantage of your own fault. The DLRO,
My lord, my lord,
state
kindly,
DLRO is
Monday,
not
my lord,
disposing of.
make it Monday, my lord, kindly, my lord.
What Monday? For what? We'll extend till disposal of the DLRO order, the DLRO disposal. The receipt filed today be kept on record, which indicates that notice has been served on the state as per our previous direction. Full stop. In any event, comma, the petitioners as well as the state respondents are represented. Full stop. Next para. Can 1 of 2025 has been filed by the petitioner for extension of a status quo order dated January 7, 2025, passed by the coordinate bench, then in season of the matter. Full stop. Next para. The said bench had recorded that since the matter has been referred to the DL and LRO Birbhum for consideration and disposal within 2 months from the date of communication of the order of the coordinate bench, comma, the DL and LRO is now seized of the matter, and it is expected that while considering the case, the DL and LRO will also address the issue of whether the BL and LRO was duly empowered to act as the collector when passing the order under section 4 capital C within bracket 5 of the Act of 1955. Full stop. Next para. Furthermore, comma, the division bench, comma, considering all the aspects and in the light of the jurisdictional issue raised, comma, directed the parties to maintain status quo regarding the nature, comma, character, and possession of the property in question until February 28, 2025, or until the matter was considered and disposed of by the DL and LRO, comma, Birbhum, whichever is earlier. Full stop. Till date, comma, the petitioner alleges, comma, the matter has not been disposed of by the DL and LRO. Full stop. Next para, we are unable to understand why the DL and LRO could not comply with the order, although a 2-month direction was specifically given. Full stop. Next para, be that as it may, comma, merely due to the inaction on the part of the DL and LRO in compliance of the direction of the court, comma, the petitioner cannot suffer unnecessarily. Full stop. Accordingly, can 1 of 2025 is allowed on contest, comma, thereby extending the order of status quo imposed on both parties by the order dated January 7, 2025, comma, regarding nature, character, and possession of the property in question, comma, till disposal of the matter by the DL and LRO. Full stop. Next para. The DL and LRO shall positively dispose of the matter as early as possible, comma, preferably by November 7, 2025. Full stop. There will be no arrest to costs. Till disposal of the matter, there will be status quo. Mr. Aduk, please ensure that it is done. Because now status quo unnecessarily public property is being. Yes.
Item number 5.
Two defects are there. We have already cured 2 defects. Mr. Aniruddha Chatterjee, I think.
Yes,
with respect to item number 5, my lord, kindly keeps it next week anytime.
Why?
I was down and out, my lord, completely. Just gives me this week's time, my lord. I'll do it, my lord, next week anytime.
It is evident that he is down and out. Out, we don't know, but down, yes. Very good.
Mr. Mukherjee, I'm sure knows, my lord, but doesn't want to tell your lordship.
No, very good, very good. On the prayer of learned senior counsel appearing for the review applicant, let the matter stand adjourned till September 22nd, Monday, Mr. September 22, 2025. Please come back, Mr. Mukherjee.
Item number 6.
Yes, Mr. Mukherjee. All Mr. Mukherjee's today.
Yes.
Yes.
My lord.
What is the matter, Mr. Mukherjee?
My lord, this is ex parte dismiss my suit on the ground of cruelty and disaster.
Your suit was dismissed?
Ex parte. Because.
Why, what did you do to have it dismissed?
No, my lord, the fact.
Non-joinder?
Fact.
Addition
remains, no, my lord, fact remains. The
Mr. Mukherjee, you're too tall for the microphone. Please help him to.
The learned advocate and the junior advocate did not give the documents which was handed over to him. Did not plead the factual facts, such as that, well, I say, on 4th.
This is before the trial court.
Yes. Well, what happened, I am telling you, Lordship. On 22nd April 2022, the marriage was common. And Bohuvat ceremony on 25th April 2022. Now, on 14th September 2022, she went South Dinajpur, this our paternal's house, on occasion of Durga Puja. Thereafter, she never returned, took all the ornaments, and actually the negotiator of the marriage, this is a negotiation marriage, of the marriage was one distant relative who is staying at Dinajpur.
File a suit for specific performance against the negotiator.
Now what happened? Now, when on thereafter, the only
suit was filed on what ground? Desertion?
Cruelty and desertion.
There was barely any time for cruelty.
When on 9th September, how serious the matter I will not going. 9th November 2022, after the Puja vacation, mother and the son went to South Dinajpur. They took out their house, snatched all these mobiles, surrounded her, and being a lawyer, and get a document signed with not in an agreement that 10 lakhs rupees have to be paid, and then mutual divorce will come. All these are torture inflicted, but they did not sign.
But why was the suit dismissed? You could not prove these documents.
They have not, my lawyer,
as you said,
a junior.
So what are these applications for?
Now, my lord, we have subsequently it also appeared from the Facebook, my lord, from this far from this Howrah to Dinajpur,
yes,
how it was difficult to connect. She has married, she had any affairs, she married, a baby has also been born. That was, my lord, subscribed in the Facebook. And I have got even the marriage was also exhibited in the display in the Facebook. That is under Order 41, Rule 27. We have filed this.
Can 1 is Order 41, Rule 27, can 2 is amendment.
And one, my lord, for addition of this, my lord. This is an adultery, my lord. He who has
Addition of whom?
The
New husband.
new husband, present.
No, he's not an adulterer.
My lord, actually, our divorce has not.
Oh, the divorce suit was dismissed, you say?
Yes.
Acha, very well.
So, and they also did not appear in the court below. We had to, my lord, take records of Order 5, Rule 20.
Serve copies of this application?
That's, my lord, very difficult to serve. They will not
Yes,
accept.
how can you pass?
Yes, I understand, my lord. Because we have no other
Cannot
alternative.
implead a party unless we allow the amendment application.
Yes.
Order 41, Rule 27 we will take up along with the
Yes,
appeal.
yes. So,
But
my lord,
we cannot implead a person
no,
of these allegations.
my lord, kindly direct us to serve, my lord,
Do that.
giving a, my lord, short returnable date. This
Short,
means
how short can it be?
after 1 week.
Yes, immediately after vacation.
Because by this time it is not possible.
Not possible, yes.
From South Dinajpur.
Very well. The present appeal has been preferred against an ex parte decree whereby the appellant husband's suit for divorce on the grounds of cruelty and desertion was dismissed. Full stop, next para. Learned counsel appearing for the appellant contends that subsequent to the filing of the appeal, certain important developments have come to the knowledge of the appellant, necessitating the present applications. Full stop, next para. It has been learned that the respondent wife has, although the marriage between the parties have not yet been severed, contracted a purported new marriage and has a child from the said marriage, which came to the notice of the appellant from a social media post of the respondent wife. Full stop, next para. Moreover, it is alleged that when the appellant husband and his mother went to bring back the respondent wife at her parental home, they were assaulted and their goods, their articles snatched. Full stop, next para. Hence, can 1 of 2025 has been filed for production of additional evidence, can 2 of 2025 for amendment of the plaint in the suit, that is matrimonial suit number 1183 of 2000 of 2023 or 2023 must be.
What? Okay.
Matrimonial suit is of 2023. It's wrongly written in the cross-set of 2023, can 4 of 2025 is for addition of the second alleged husband of the respondent wife, and can 3 of 2025 is for appropriate orders, in the nature of calling for the records and passing other directions. Full stop, next para. In view of the serious nature of the allegations sought to be brought on record, we feel that service of the applications are required to be effected on the respondent. Full stop, next para. Accordingly, we direct the appellant to serve copies of the above four applications on the respondent, indicating that the applications shall be listed for hearing should we put it in the monthly list of November? The monthly list? In the monthly list of November 2025, full stop, the appellant shall file an affidavit of service to that effect on the returnable date.
And my lord, leave may be granted to correct the PIN code of the, my lord, Dinajpur by
in which application?
In the memo and the application.
Leave is granted to the learned advocate on record for the appellant to amend the memorandum of appeal and the applications by incorporating the appropriate PIN code of the address of the respondent, of the respondent wife, as well as to amend the cause title of Can 2 of 2025, indicating the correct year of the suit.
But that has been given 72212R4. It would be 733124.
What?
That is
PIN code?
PIN code.
The pin code and also can 2 year junior has understood this, that 2003 has been.
Well, should we serve also the proposed?
No, we are not asking you because
Well,
these are serious allegations.
Yes,
Unless
yes.
we add him, we won't
Yes,
direct.
yes.
If we add him, we'll direct notice to be served.
Yes.
Item number 7.
My lord, I am paying for short passover, my lord.
You are competent enough. You move the matter.
My lord, kind. Oh,
Appear for sufficiently long before us.
my lord,
You are capable of moving, move the matter. What is the matter about? No passover.
my lord, my lord, a shoot was
This has
continuing.
come up for the first time. Did you direct service of copy?
Yes, my lord, I have served, my lord. APD service.
No, was there a direction? We don't find any direction.
My lord, I have served, but
There are certain defects in the appeal.
defects I have removed because the Loajima code I have removed, my lord. Only we in the preamble portion.
Well, we are granting you time. You are asking for time. You remove the defects in the meantime.
My lord, I have rectified, my lord.
You have rectified?
Yes, my lord. By the order, by the order of the registrar. My lord.
What is the nature of this application?
My lord,
What is the appeal against?
Against the order of the single judge, my lord. Honorable judge.
Order of?
Single judge, my lord.
What did the single judge do?
He has not.
What do not do?
My lord, liberty is not granted me to prefer any forum.
What? Liberty to?
Single judge does not allow me to prefer any forum when I have been aggrieved, my lord.
Check up. Filed by the petitioner. Take any serious.
At page 54.
One.
Page 54.
1 minute. Yes, Leonard, single judge is correct. On the premise that you withdrew a suit on the ground of amicable settlement of disputes without liberty to sue.
No, my lord, my petition is not there. That there is amicable settlement between the parties.
What was the order of the suit court of the trial court?
My lord, at page 43, my lord.
What page?
Page 43, my lord, in stay application, in my stay application. Recorded photo. Though it is written that, my lord, before that my petition, I have papered before the learned court below, learned at a civil court, at page 40, my lord. But it is wrongly typed by the clerk of the learned court, below the clerk of the advocate, my lord.
Where is your application? You filed an application before the
My
trial.
lord, page 40, my lord. Only our direction was that learned court have no jurisdiction.
Your application states you have signed your application that says with no liberty to file fresh suit.
No, it is wrongly written by the learned.
Wrong reading. Please come to page 41.
Yes, my lord.
Your application before the trial court.
Yes, my lord. I have.
It will impose huge costs on you.
No, my lord.
Client.
My lord, no application. But
please come to page 41. Read out.
Yes, my lord.
Your application states you want to file the withdraw the petition with no liberty to file fresh suit.
Yes, it is wrongly typed. But
you were examined on the dock. The learned trial judge was so kind as to put you on the dock and ask you, and there also you deposed.
My lord,
you did not want to proceed.
My lord, kindly realize my.
This was a divorce suit.
No, my lord.
What sort of suit?
I am a poor cultivator, my lord. I have been.
You know the magic word before this court.
No.
Poor cultivator, so you are absolved of
my lord, my client has been deprived by the learned court by the advocate.
Client has signed the document.
Yes, my lord. Yes,
you know how to read, at least to sign your name. So Maybe a poor cultivator, but you cannot withdraw suit without liberty and file afresh.
He is an illiterate person, my lord.
Cannot say that. He signed this application before us also.
Yes, he
Maybe
come.
uneducated, but cannot be illiterate. He has signed his name.
Signed, but due to my lord, by the literacy conducted by the Indian government,
Then you have
he
to
learned.
approach the trial court for rectification of that. If
Yes.
something has been recorded on facts, what happened before the court,
Yes, my
you
lord.
have to approach that court only for rectification of the order.
Yes.
Appellate court cannot, we have to proceed on the premise of whatever the trial court says. We are dismissing the appeal, we are giving you liberty.
My lord,
Liberty, please listen. Liberty to approach the trial court which dismisses the suit as withdrawn for correction of that order. But that officer cannot be there now. Ideally, you should move before that officer, that judicial officer.
Yes, my lord. He has no other way but to dismiss the appeal, dismiss the suit. Yes, it is right, my lord. But
your application was filed.
Yes.
You were examined on doc. The trial court examined you on doc. Your client was examined and you corroborated that you want to withdraw without filing afresh.
He has been.
No, we don't find any reason to.
My lord, kindly liberty, give me liberty to.
We will say this will not prevent you from doing that. We will not grant any liberty or anything of
Well,
that.
he is very much. His father has been allotted the patta, but he was continuously more than 12
What was the relief sought in the suit? Have you got a plaint of the suit?
Or having.
Is the plaint of the suit which was withdrawn? Does it operate in the same footing? Let us see if there is some difference between the relief sought there and in the writ.
No, in the plaint, I am praying for
plaint.
Plaint, yes, my lord. I am praying for.
We want to see the plaint.
Issue me patta for. Objection. Objection.
পাটটা দেওয়ার জন্য সুট লাই করে যদি সুট লাই না করে তাহলে ইনহেরেন্ট ল্যাক অফ জুরিসডিকশন তাহলে তো বাইন্ডিং হবে তো অর্ডার 23 টা কি
Reading objection on objection. My lord, I have not at present, my lord, kindly adjourn for today, my lord only. My lord, allow me, my lord.
Who is leading you?
My lord.
Who is leading you? Who is your senior in this matter?
My lord, Mr. Noni Gopal Sarkar, my lord. But just he is coming, my lord. But,
1 minute.
Due to her.
1 minute.
Reading the plaintiff. এটা WS টা ইউনিটটা কই
Have you got a copy of the plaint?
No, WS is there, my lord. I could not find.
Your own plaint is not there. WS. Give us the documents. Give us your enter file. Din ton file ta. No, we can. We are doing this all the time. Give us your entire file. যা আছে দিয়ে দিতে হবে, সাজিয়ে দিতে হবে না, সাজিয়ে দিলে আরো গুলিয়ে
প্লেনটা কোথায় গেল?
প্লেনটা আছে না
প্লেন পুরো দেন প্লেনটা
What was the number of the suit? 109.
109, yes, my lord.
এটা ফেরত দিয়ে দিন অন্দিতা, এটা ফেরত দিয়ে দিন। What interim relief have you sought here?
My lord, I want to have give me liberty to file the before to file the before appropriate forum for having for issuing act.
Have you given a notice to the other side?
Having a direction.
Have you given a notice to the?
Yes,
Where is
my
the
lord.
notice? File that affidavit of service.
By telephone, I have told.
Telephone.
By
File the telephone along with your affidavit of service.
no, my lord. I have served, but yesterday I also told.
Give us that.
Only private respondents are served through post.
What about the state?
State.
Find out whoever appears for the state and catch hold of him and we'll regularize his service. Look behind you. Immediately behind you.
My lord.
Yes, you have served on all.
Yes. At first, before my lord's bench, I have served.
No, you have served on all the respondents.
Yes, all I have served in the previous bench when it was in the
previous bench. There was a direction for service.
No, my lord.
You are appearing for whom?
Mr. Owen Banji appears for the state, my lord.
State, right. So state we have got.
Yes, my lord.
They appeared before the learned single judge. The other side, private respondent.
Yes, my lord. No, private. No private respondent. Not for.
Yes, appeared. Ratul Vishwas.
State appears. Oh, yes.
No, Ratul Vishwas appeared for respondent number 10.
Oh,
with Soham Sannal.
Yes, my lord. My lord, can you allow me time to serve again, my lord?
Affidavit of service filed today be kept on record. Full stop. It transpires that all the respondents have been served. Full stop. Although the state respondent appears is represented through counsel along with the petitioner, none appears for the private respondent. Full stop. The limited conspectus of the appeal is whether the learned single judge was justified in dismissing the writ petition of the respondent of the appellant seeking grant of patta in favor of the appellant on the premise that a previous suit filed by the appellant was dismissed by the civil court on the ground that the same was withdrawn by the appellant without liberty to sue afresh. Full stop. Next para. Although learned counsel for the petitioner seeks to impress upon us that the appellant is a cultivator, not having knowledge about the not having know-how about legal procedure and could not appreciate the significance of withdrawing the suit without liberty to sue afresh, we are not much impressed with such submission. First up, we find from the judgment of the learned trial judge recording such withdrawal that the learned civil judge had examined the plaintiff/appellant in the witness box, and only after being satisfied that the contents of the application for withdrawal of the suit without liberty to sue afresh were correct, dismiss the suit as withdrawn without liberty to sue afresh. Full stop. Next para. Thus, there cannot be any qualms with the dismissal of the suit as withdrawn without liberty to sue afresh. Full stop. Next para. However, there is another question involved in the present appeal. Full stop. We find from a copy of the plaint in the suit bearing title suit number 109 of 2012 before the Second Court of Civil Judge Junior Division at Uluberia, Howrah, that the principal relief sought in the said suit was a decree for declaration that the plaintiffs/appellants are exclusive occupiers of the scheduled property having possessory title in the same. Full stop. Next para. Two questions crop up in the said context. Colon, niche Roman 1. Whether the civil court had the jurisdiction to pass a decree in respect of the grant of patta, comma, which was the subject matter of the writ petition, which has been dismissed by the present impugned order. Question mark. Tar niche 2. If the civil court did not have jurisdiction, comma, whether the rigors of order 23 of the Code of Civil Procedure would be applicable, comma, since a court, comma, in order to grant liberty to a party to waive his reliefs, comma, has to have competence to decide the subject matter of the lease. Roman 3, whether the subject matter stroke reliefs sought in the suit are different from those in the writ petition, comma, in view of the fact that the suit was for declaration of possessory title, whereas the writ petition sought a direct mandamus to be issued for grant of patta in favor of the appellant, which might be construed to operate in different spheres. Full stop. Next para. Thus, comma, in view of the short questions involved, comma, we intend to hear out the appeal along with the connected application together with by dispensing with filing of formal paper books or the records. Full stop. Next para. The learned advocate for the appellant shall serve a copy of this order from the website of our court on the learned advocate for the respondent, indicating that the matter shall be listed under the same heading, with the understanding that the appeal will be disposed of with the application. The matter shall next be listed on September 24, 2025. Oh, nobody is appearing for. Yes, somebody appeared for the respondent.
Yes, sir.
State is appearing. Somebody, Mr. Ratul Ghosh probably was appearing.
Yes, I shall serve.
Ratul Bishwas and Shoham Sannal.
I shall serve. Yes.
Please serve on either of them.
Yes, grateful, man. I shall serve.
And we are returning this to you. Please take out at least 4 or 5 copies of this on the next day.
Grateful, man.
2 for the court,
yes,
2 for the other 2 sides, and 1 for you.
Grateful, man. Deeply.
Next.
Item number 8 with 9.
8 and 9 are latest patent appeal by the state of West Bengal.
Yes.
Well, I have taken the objection of maintainability of this.
Yes, yes. Why did you say that, Mr. Agrawal? Please.
My lord,
oh, we are recorded. Why not appealable?
My lord, this is kindly see the prayer.
Prayer
in the memorandum of appeal, my lord, he has challenged the order of recalling only, not the parent order, my lord, has been challenged.
He may say that it ought to have been recalled. Then we'll have to confine to the recall application.
Recall only, my lord.
Whether that was maintainable.
That is maintainable or not. Only to that extent, my lord, I am submitting.
Why 2 appeals then? Why 2 appeals?
Different, my lord.
You did not advise them to challenge the main order also?
My lord, actually, my lord, may I, my lord?
So Agarwal has to advise you for the response.
I will satisfy, lord. My lord, I am grateful, my lord. I always knew that latest patent appeal is maintainable, even if it is not provided under the CPC. The reason, my lord, I didn't know.
What have you challenged? What?
I am challenging an order passed in a recalling application.
In connection with the writ?
In connection with the writ proceedings. My lord, because of
recall application is substantive rights have been decided at least prima facie. Then it will be a judgment under latest patent.
My lord, I found, my lord, I came across this order of a reference bench, which says, my lord, even if it, my lord, the CPC does not provide, section 4 and 4, my lord, acknowledges.
How would the CPC apply in a writ petition?
My lord, that was the submission of my learned friend. That he said it is not, there is no provision of appeal.
Order 43.
Order 43.
That is.
No, I am coming, my lord. There are judgments. I said, place your lordship. Until the parent order is challenged, recalling.
He's on a different foot.
Yes. That is my lord thing. That and you lost.
This judgment, my lord, has
Relying
taken
upon
note that
several
any
judgments.
Mr. Banerjee, Mr. Chatterjee, instead of proceeding like this, just give us a brief backdrop of the matter. Then we'll hear Mr. Agarwal first and he'll cite his judgments. Then we'll come to you on the maintainability.
I'm so very grateful.
Just tell us what is the
My
matter
lord,
about.
kindly come to my stay.
But we are not hearing you on merits.
I follow. Your lordship, I'll take your lordship to one document at least. My lord, page 31 is the notification. Page 31 of the stay application, my lord.
Notification, yes. There's a section 5 also.
Your lordship's pleasure was to allow it.
Your lordship, condemnment.
My lord, this is the notification
Yes.
by virtue of which the writ petitioner has applied for a FPS dealership. Well, kindly come to clause 7, page 32. I'll be very brief, my lord. I'll try to be very brief, my lord. Well, clause 7 says the applicant in the case of individual or group of individuals should not possess any
Yes,
FPS
family
dealership.
we remember this from
Right,
other matters.
Right,
Yes.
right. Now, my lord, the impugned order was passed
Yes.
in the writ proceedings on 2 scores. My lord,
His FPS relationship was refused, rejected application.
by the reasoned order, we refused it.
The reason was that he has some relative.
True. My lord, we invoked 7 clause 7, my lord, and my lord, we say because of this clause, you are not entitled, and it is this notification that is deriving to the right to make the application. I will kindly.
He has to be governed by this. Yes.
Now, my lord, page 11 is the order passed in the writ petition. I will kindly not go into the details. I'll take 2 scores the impugned order was passed. First is, my lord, this notification, a like notification, not this one, a like notification has been set aside by a coordinate bench. Second is, my lord, this is where, my lord, I join issue. My lord, the court, my lord, my learned friends urges the court that state did not prefer any appeal against that order of the coordinate bench. So, my lord, at this score, my lord, I filed the recalling application. Of course, my lord, after filing of the contempt application, as your lordship knows, state is little.
You love contempts. Yes.
Always, my lord, in a state of slumber at times.
Yes.
My lord, we say in the recalling application.
Mr. Basu is leading you in this one.
Then
it will be dismissed.
I was afraid that he was my other side. Other than I lost.
Now you are not afraid with Mr. Agarwal. He gets more impetus.
I'm always afraid.
Don't agree. Yeah, never lost, never win.
Because he always
immediately it does not feel so. Afterwards, before and after it feels like that. Immediately it does not feel like that, Mr.
True. There are 2 scores. First is this has been set aside by a coordinate bench.
Different notification, similar notification.
Similar, identical, but different notification.
All right.
For a different place altogether.
All right.
Second is state did not prefer an appeal against that.
That is
order.
the continuation of the first, yes.
No, the prime consideration of the impugned order passed
That
in
is
the
a continuation of the first ground because appeal was not preferred, so that has attained finality.
Right. I'm sorry.
That is the same point.
I'm grateful.
Yes.
My lord, I join issue here. I say it is the same council who has, my lord, represented this petitioner in both the matters. In the appeal filed by the state government, same council had appeared. And
other matter. There was an appeal preferred.
There was an appeal.
That is pending.
And my lord, in fact, we will see the learned first court, with deepest of respect, I say, my lord, did not even, my lord, venture to go through the order. Simpliciter, he said, since this has been struck down, this clause has been struck down by a coordinate bench, and state did not prefer an appeal, I give dealership in his favor.
So why recall? Recall under which provision?
Recall is on the
should be treated as a review in a disposal matter. Recall scope is
recall also, my lord, is, my lord, entertainable. I'm sure.
No, you are not present when the order was passed.
I was present, but my lord, something that has been.
We have to treat it as a review then.
Well, we'll kindly take the parameters of recall. Budia Swain judgment, my lord, I'll show it behind.
Give a copy to Mr. Agarwal. If it's an unreported judgment, otherwise
it's reported.
Reported judgment that has been taken care of by the learned single judge.
My lord will further take care of it.
That is put very well, Mr. Chatterjee. But
Milord,
yes.
paragraph 6 and 7 are vital, Milord. Milord, 6, Milord. What is a power of to recall? Inherent power of court to recall its own order vesting in tribunal or courts has been noticed in such and such. It has been held that courts have inherent power to recall and set aside an order obtained by fraud practiced upon the court when court is misled by a party, when the court itself commits a mistake which prejudices a party. Now, Milord, I have judgments to, Milord, show that if you suppression of any material fact and using it to one's favor amounts to fraud on the court and the other side as well.
What was suppressed by them?
Milord, it was suppressed that an appeal is filed against the main order.
They appeared in the appeal. They had appeared in the
same councillor. Same
council may not remember. That will be attributed too much. Chatterjee, if I ask you the names of your clients, you appeared for the last few days.
I will kindly, your lordship will bear in mind the difference between Mr. Chatterjee and Mr. Agarwal. This is
we cannot distinguish between you and Mr. Agarwal. We have to proceed on our standard, and memory is 0.
Wow,
just above 0. Otherwise, we could not pass out.
Two lines.
Live streaming.
That paragraph.
Live streaming.
Paragraph
no future, Mr. Vasin.
That round appeal may be preferred. There's no memory of the court, so.
No, that will be reflected from the order.
That's happened.
Perjury may happen.
That's happened.
Guilty of perjury of our own court. If it's seen that we have memory.
Mr. Surajit told me he review application file in the live streaming court was in his favor. In the conclusion, dismissed. Why? How it can be done?
Then we'll make the order more complicated so that the appeal court has difficulty in it.
So this is a matter public interest litigation against the Chief Minister of Jharkhand. Now, my lord, the petitioners.
No, first let us complete this judgment.
This one. This two paragraphs.
So only this.
Only, my lord.
Para 6, Roman 3.
Absolutely, my lord.
And you say forgery, fraud also.
I do not, my lord, take it to that level. I said, my lord, it was.
Unless it is of that level, mere suppression.
Even misled, my lord, it comes to even if you misled. I will not, my lord, say fraud. A little harsher, my lord.
Right.
I'll use the word, my lord, misled.
And what did they mislead? You said
the state appeal. My lord, this is a matter where a public interest litigation.
Tendency of appeal, does it operate as a stay?
No, my lord, but is
that a material fact then?
It is material because, my lord, that was the prime consideration of the impugned judgment. The Honorable First Court did not even consider the judgment of, with responsibility. I say this, my lord, your lordship will not find one line on the judgment of the coordinate bench. The court did not even look into the judgment of the coordinate bench.
Whereby the other notification was set aside.
Absolutely, my lord. That I say, my lord.
Yes,
this, my lord, was a matter public interest litigation alleging very irregularities against the Chief Minister of Jharkhand. Jharkhand, my lord. My lord, there was a previous litigation in the year 2013, and this was in the year 2022. I will kindly come to paragraph 23 and 24. Petitioners were different. My lord. Should I place it before lordship?
Yes.
My lord, let us now examine the nature of the appeal which is before us. In such and such, the petitioner who is filed the appeal as well as the other appeal and the release in them have already been referred to. It is admitted case that in the year 2013, a similar petition was filed being such and such, which was dismissed by the division bench of the High Court on Atho with a cost of 50,000. Thereafter, SLP preferred order was SLP was dismissed. What is necessary for our consideration is that though the said petitions was filed by different persons, such and such was, but this was in the knowledge of the petitioner in appeal as the counsel of the petitioner in the earlier matter, such and such, and the counsel in the present petition are the same. Therefore, it can be reasonably presumed that the dismissal of the earlier appeal will be within the knowledge of the petitioner. Lord, I do not say much. I do not open my mouth much, my lord. I say, my lord, I am entitled to a hearing. I am entitled to the learned first court ought to have when the prime consideration of the impugned order is that state has not preferred an appeal, and state admittedly had failed to assist the learned first court with that fact. Nevertheless, the counsels of the states were different. The counsel of the writ petitioners were same. All I wanted to have a hearing on the matter. I wanted to place my case, nothing more, nothing less. If your lordship wants, if your lordship wants,
other judgment, Mrs. Tanushree art to printers, this we find on record. You have cited that also. You have said
No.
fine.
Yes, Tanushree art is the one day I handed over that latest patent appeal will be maintainable. This is the order of the reference bench of our High Court, it is.
Oh, that. Now, Mr. Chatterjee, there were two grounds on which your writ petition was dismissed. Right. One was that no appeal was preferred, right. But the substantive ground was that a different. If you have not challenged the parent order,
we have
recall what
the order of the.
We prima facie, subject to what you say, we don't find that there was any suppression of material fact, because we are telling you, even if there was suppression, we have to consider whether it is material. Since pendency of an appeal does not per se operate as a stay, the learned trial judge, the learned single judge also took into notice that the previous similar notification was set aside. Fact remains, in the appeal no stay order was passed, at least at that point of time. So if that be so, that is sufficient for the, it may be an erroneous order, the parent order. There may be a different notification, but then you have to challenge the parent order. We don't find any merit in the appeal against recall order.
Your Lordship will appreciate if the issue is pending before the division bench, the law cannot be said to have been settled by the courts. The issue is sub judice. Under such circumstances, court, I say ought to.
No, not even if you know, Mr. Chatterjee, even if an SLP is rejected at that stage, that is not a merger. So pendency itself is on a weaker footing.
Rejected. The Honorable Division Bench has allowed the Section 5.
So that is what we are saying. We are trying to draw an analogy. If a rejection, even the rejection of an SLP is not germane, not a merger, it is constituted to be still a High Court's order, because there is no merger. It's not a Supreme Court's order then. If the rejection also cannot tantamount to a merger, Mr. Chatterjee, how can the mere pendency of a challenge be treated on a higher footing?
Rejection, the issues are decided.
Not decided. That is what we say. In SLP rejection, issues are not decided. But that is also not treated. Anyway, that's a bad example maybe. But pendency by itself, Mr. Chatterjee, does not matter. That's not a material fact which is separate. And let us see the impugned, the present impugned or the recall or recall is not maintained.
That is page 17 of this stay application.
To challenge the parent order, Mr.
Allow me to come back with that also.
Come back with that first. Let us dismiss this. No, we'll say this does not prevent you from preferring a challenge.
This will prejudice. One will kindly adjourn it for
not prejudice. We'll make it clear.
This will prejudice. You'll kindly give me 7 this time. 7, not much. 7 this time.
No. After so much hearing, no. We are now going for the jugular.
I have already only troubled your Lordship. My learned friend did not.
No. Your trouble is sufficient for us. Our academic interest has been titillated. Now we'll decide.
My request, kindly keep it. Give me 7 this time. Look, I could have at the outset paid for.
But then we'll record prima facie that we are dissatisfied with your argument.
Yes, my lord.
My lord will kindly consider there is contempt petition is pending. Yesterday it appeared. And since it was appearing today, I have taken time that since it is before the appellate court, my lord, kindly adjourn it for this. Now, my lord, contempt is pending for so many days.
We'll pass an order, we'll record everything, but we'll just stop short of dismissing this. We'll grant
it. Please this Supreme Court judgment on fraud, 2-3 lines. Should I
do that and we'll decide this appeal?
No, my lord, then my lord kindly.
No, do that. Why not?
My lord will kindly lightly observe that it is not maintained. Will not very.
No. Why lightly? We are passing our orders in the appeal right now. You complete your arguments.
No, my lord will kindly allow me to come back in 7 days.
This is not fair. You took an option was given to you by Mr. Agarwal on the last occasion. Also, he argued the same point.
No,
now we have made up our mind.
We did not argue this, my lord.
No. He took a point of maintainability.
That, my lord, I am ready to address you.
That you are addressing only.
No, my lord, that is.
Oh, what? Oh. What are you
I
addressing?
thought, Milord, it was because
Maintainable.
legislative appeal is not maintainable. That was
No,
the
no,
argument.
not that.
I was not
not
there,
that.
Milord. My learned friend was there. So, Milord, may I pay?
I have also come fortified with my certain judgments since your lordship was on the last
Very
occasion.
well, we'll not decide, then we'll continue.
7 days, Milord.
After substantial hearing, learned now, at the outset, learned counsel appearing for the respondent takes a preliminary objection as to maintainability of the appeal on two grounds. First, that the impugned order rejecting a recall application in respect of a final order passed in a writ petition is not appellable, and secondly, that the that in the absence of any challenge to the parent order, the appeal is not maintainable. Next para, learned counsel appearing for the state appellants stands by the maintainability of the appeal and cites certain judgments. However, at an advanced stage of the argument, learned counsel for the appellants seeks liberty to challenge the parent order as well. In order to enable the appellants to do so, the matter is adjourned till September 24, 2025. In the event any appeal is preferred in the meantime, the same along with the connected application, if any, shall be mentioned for inclusion and being tagged with the present appeal.
So very grateful.
Sorry. Slip করে বেরিয়ে গেছে।
The my lord said, I shall be kindly grant me leave to proceed with the contempt.
No, that leave is always.
My lord, again he will take.
Put it.
Your lordship has granted him leave, and not he is unkind to me.
Not leave. To enable them, they have asked. We have to enable them to file. If file, if they don't file, we'll proceed with this and pass the order on the next day.
I'm grateful, Milord.
Item number 10.
My lord, kindly can it be one day earlier? Because
they won't be able to state.
State
know the affairs of the state and the state of affairs also.
Deep.
Yes, Mr. Basu, what is this matter?
Land acquisition.
Who is for respondent number 11? You.
Yes.
State is there. You said there is there, yes.
The Choron is here.
You are for the? Oh, yes, that matter. Right. Land reform, land acquisition.
But kindly take a note, the writ petition of 2000 is relevant.
2000?
2000, writ petition of 2000.
All right.
WPA 11488 of 2000. When the 2013 Act has not been born, it's of some relevance. That's why I.
Yes.
We challenged the proceeding in 2000. So there is no scope for pleading anything about 2013 Act or the consequence thereof. We have only challenged that. It appears that there was an interim order passed in an earlier proceeding maintaining stay. That stay vacated on 26th July 2002. And so-called award was passed on 18th April 2001. So in my humble submission, this award is a nullity in the eye of law.
Between same parties, the previous
the land acquisition proceeding was stayed. Under that number, there are different plots.
Can you give us the date of the stay order?
Yes, I will. But I have filed an application under order 4127.
Anyway, that's an order of court. If they just give us.
Kindly come to 179 of your lordship brief. The theater. Milbe to patata. No, I can ask. 179. Can you take the paper book? Paper book has been filed and prepared.
Paper book থাকলে সবসময় paper book দেবেন আগে.
But I don't. Direction was given for filing paper book without considering 4127. However, that has been included. I don't know how. 179. Well, kindly come to middle portion. I can show to your lordship here. Justice Kumar, can you look there? 166 LA 1996-97 dated 23rd December 1996. Can you mark that? That is the relevant LA proceeding. ওই তারিখটা হচ্ছে 23/12/96. Next page is the order. Interim order was passed earlier. Interim order was, he said interim order subsists during the pendency of the writ petition.
No, the interim order was restraint order are restrained from interfering with the right, title, and possession in respect of the property in question. Not exactly stay of that proceeding.
Well, there are other proceedings also where section 4(1) has been challenged, that has been stayed.
Where is that? This is an injunction order.
Yes.
Although broadly it may cover, but even then.
It is covering everything. If a proceeding initiated and my lord, their status quo has been granted, according to my humble stand,
The other status quo order you have annexed.
it covers everything.
No, this is the only order which was prevailing.
This is the order. Another order, my lord, it was disposed of on 26 July 2002. Kindly take 181. 26 July 2002.
But we don't have a copy of that order.
No, my lord, I will request your lordship to bring this file. Otherwise, either way, my lord, if I may be also wrong.
You could have taken out for server copies of
we are not getting 2002. No, this is we obtained.
No, we have.
I have a doubt. Must be candid.
We are uploading. We have gone back.
I have a doubt. Why I am saying, my lord?
Have you attempted to get server copy of this?
Yes, my lord. My instruction.
Did either you or Ms. Maiti attempted? If you have attempted, then we have our doubts.
Absolutely.
Regarding the attempt itself.
Not only after attempt also there is a doubt. But why I am doubting? Kindly come to 26 July 2002, and the justice is Justice Sugoto Mojumdar. Probably his lordship was not elevated, my lord.
So many ghost entries there. We are deleting those then. So we cannot rely on this.
No. This is the record, part of the record of a lordship's court. Well, this is the point I am canvassing.
This itself cannot.
So that's why lordship can call for these records to ascertain when this was deleted, when this was disposed of, and the interim order was subsisting or not. If the interim order was subsisting and the award has been passed, I have a case.
The award was passed even before this date.
Before this date, whether actually it is the date, because it is, my lord, I must be candid, my lord. It does not appear this is correct one. At least the name of the judge is not correct.
This is not correct.
So kindly call for this record of this proceeding.
No, the state must know whether what happened to that appeal. State was the other side.
Difficulty.
Do you have any information about what happened to that injunction
Next
order?
hearing date is 6 July 2022. That is also cannot be.
We are not hearing you at length till now. We are just asking you about this. Do you have any idea about what happened to this injunction order? This writ petition, whether it is still pending or not? This page 180.
180. That is disposed of, my lord. In my affidavit in opposition, I have also stated.
You have stated it is disposed.
Yes, that is disposed of.
When was it disposed of?
That is, my lord. Disposed of on. That is, my lord. 16/4, the award passed, my lord.
Award
and
passed.
Disposed of, my lord, on.
Award passed on 18th January, Mr. Vasu says?
Yes, award was, my lord,
16/4,
18th April 2001.
16/4, 2001.
Or 16th or 18th, whatever.
16/4, my lord, 2001.
16/4, 2001, the award was passed.
Yes, my lord.
And when was that disposed of?
My lord, that is disposed of, my lord.
This cannot be relied upon, this document. The next hearing date is 6 July 2022.
No, we are not relying on that.
This is the document we obtained from the court.
Those are not reliable.
That is, my lord.
Can we call for the records of this proceeding and decide it?
Let us see first what they have said.
But this is the only point I can urge.
That is, my lord, 20th September 2000. In my affidavit in opposition, my lord, I have written.
Have you got a copy of that order?
No, my lord.
Very
When
good.
we wanted to get that copy, my lord, that was, my lord, disappeared.
Disappeared.
Yes, my lord.
Very well. The premise of the present, we'll call for the records. The premise of the present challenge is
Before that, my lord, we'll also see the impugned order. The honorable judge's view that I have not pleaded anything of 2013. How the after this I will come, I am in possession, award has not been passed, so section 24 applies. This pleading is not there. It cannot be there.
where is that?
Read
Which
in
page?
the judgment.
Which page?
Yes, my lord. Kindly come to page 10, paragraph 17 of the impugned judgment.
In the paper book, is it there?
Paper book. Yes, has to be there.
Which page?
Pata milbe na?
Must be there. Yes, 97.
19. Paragraph 17, my lord. Is my lord as paragraph 17? Admittedly, in the instant writ petition, there is no averment to the effect that either the compensation for the acquisition has not been paid by the respondent state, or the respondent state
No,
has
Mr.
not.
Basu, there are certain judgments that if the award was not passed, then for purpose of compensation, when 2013 Act comes.
Award was passed.
Oh, yes, sorry, here award.
And my lord, my learned friend
Yes.
now stated
No, that ground then is bad.
that is the
2013 ground is bad.
yes, my lord, I say. I submit before our lordship that ground is bad.
Which ground
And
is
not
bad?
only that, my lord, that is the ground which is taken, my lord, that our award, not that is the
No, Mr.
state,
We
my
are
lord,
telling
I
this, we are saying this. His premise of his challenge in the writ petition was that this award was passed in the teeth of a subsisting injunction order.
No.
After
My writ petition was that the acquisition is bad.
Otherwise also.
Otherwise, in that writ petition, after that we came to learn that the award was passed in the proceeding when the stay application was there.
Achha.
So that has been incorporated. Honorable Singh just says this effect of 2013 Act was not there. It cannot be there in
No, but
2000
that
proceeding.
award, passing of the award was brought to the notice of the learned single.
Yes.
So therefore, two grounds. One independent challenge to that acquisition proceeding, and the second is this. To resolve this, we have to definitely look into the records, whether it was actually disposed of or not. But if the learned single judge proceeded, Mr. Day, on the premise of 2013 Act, despite the award being passed admittedly in 2001, then that premise is the premise of the rejection of the writ petition was bad.
But that is not the only, that is not the.
On merits also it was there.
See, everything was, my lord, discussed in the judgment. And my lord, I submit before your lordship, the award is perfectly right. And my learned friend, what my learned friend said, my lord, submitted before your lordship, that is not correct. I must submit, I must show your lordship that.
Then since that is an additional ground of him, there are other grounds also. So we'll call for that records
Yes,
so that can be eliminated.
Yes. Yes,
And we'll proceed with the hearing.
Yes, my lord.
Should we put it immediately after the vacation, or we don't know whether the records will come before that?
After the vacation must be, my lord.
Must be.
As because, my lord,
my
this is
instruction
the
from my
motion type, motion period, my lord.
Yes, right.
Because-
So we'll.
I've been
No,
instructed
we are every day short of motions. We have to touch hearing. In the garb of application, we dispose of the appeal. You know that.
In every
Well,
other
division bench taking residuary matter, my lord knows.
Yes, obviously,
Last-
no.
Last 2 weeks, this bench has been changed. 2 matters was moved.
But in my land, my lord, there are so many moved every day.
কোথায় এই তো এখানে দেখতে পাচ্ছি
না, এটা
The hearing.
that is the not hearing, my lord. In
Motion কোথায়?
In motion in the
না, motion in
my
the
lord,
division bench.
there is so many matters is.
Right.
Well, my instruction
for
to
that
pray
is
your
my
lordship before vacation, if possible.
Who instructed?
My
Is
instruction.
Maiti.
Before vacation, my lord, this is very.
We'll impose personal
Will not break.
costs on Ms. Maiti by way of treating you all to some
She is not
sumptuous.
afraid of that. She is not afraid of that.
Yes, she's not.
Now I will take her to our table and I will get it.
She treats. The present learned senior counsel appearing for the appellant assails the impugned order primarily on 2 grounds. First, it is argued that the acquisition proceeding itself was challenged. The acquisition proceeding comma, which was initiated under the Land Acquisition Act 1894, comma, itself was challenged before the learned single judge. Full stop. However, comma, the learned single judge, comma, proceeding entirely on the premise that the appropriate provisions of the Right to Fair Compensation Act, পুরো নামটা একটু দেখে করে দেবেন এর থেকে, 2013, were not satisfied. Full stop. It is contended that the 2013 Act cannot be applicable since admittedly the award was passed.
She's having it.
On admittedly passed on April 16, 2001. Full stop. Next para. The second limb of the argument of the appellant is that the award was passed on April 16, 2001 during subsistence of an injunction order passed in connection with a different writ petition, but in respect of the self-same acquisition proceeding. Full stop. Next para. But Mr. Basu, one second, that injunction was, you are not a party to that injunction application, so that's not binding on you.
I'm
No,
not
my
saying
lord,
binding.
because my lord,
If in the teeth of
The
an
state is not bound against you.
in the teeth of an
No,
injunction,
that was not to proceed with the LA application, LA appeal. Sorry. That injunction was restraining them from disturbing the peaceful position or status quo regarding that property in respect of that party.
entire land acquisition proceeding was stayed. I will show to you.
But you have shown an injunction order.
So that is injunction. Another is there. This is in respect of this. That I know.
So next para, learned senior counsel further submits that there was also an order of stay in a different writ petition in respect of the entire land acquisition proceedings.
What my learned friend said, I can't understand, my lord. That the injunction order was, my lord, passed earlier on receipt of the aforesaid land acquisition case, my lord, proceed under that.
Full stop. As such, comma, it is alleged that the award passed in the impugned proceeding was also bad. Full stop. Next para, learned AGP appearing on behalf of the respondent state opposes the submissions of learned counsel.
Permitted to interfere only for a moment.
Yes.
My lord, the injunction order was vacated on 22nd September 2002. 2000. And my lord, award was passed on 16th.
Granted on.
What my learned friend said, my lord, I can't understand.
I don't understand.
Controverts the submissions made by the appellant. Full stop. It is contended that the injunction order, comma, which is relied on by learned senior advocate for the appellant, was vacated on September 22, 2000,
Yes, my lord.
comma, that is prior to the passing of the award. Full stop. Also, comma, learned AGP submits that the impugned order of the learned single judge is justifiable on several other grounds. Full stop. Be that as it may, comma, a question arise. Mr. Vasudhan, what is the use of calling for that record?
My lord, there is.
What is what is the writ petition where?
Both of us, my lord, is.
Yes. What is the question? That injunction we are not satisfied that prevented them from.
The other injunction is also there.
So then we have to call for that record. Where is that
I
other
will submit,
status?
my lord, the record of that proceeding I will also call for.
No, no. Where is that? Where have you referred to it?
That is another is there.
Injunction we are not satisfied that. We'll record that also. We'll not call for that record.
Which one, my lord?
Injunction record. That writ petition where injunction was passed. We don't feel that is binding on the state vis-a-vis.
That is their only that is their contention also.
No, no.
That is their only contention also.
That is the case number.
No, no. What about that? Where this? If you say this proceeding was stayed, show us that order.
In view of the original order passed, kindly come to 180.
Yes.
This court hereby or that there is an restraint order upon the respondent from processing on the basis of Annexure A.
But where is that original order? That might have been another injunction.
No, this is in respect. No, this is in respect of Annexure A means the proceedings, Section 4 notification.
Yes, but that is binding on the parties only between them. No, no, no. On the basis of Annexure A. Acha, yes.
That is, my lord, notice.
Entire proceedings was stayed.
My lord, if LAK is state, my lord, then
can be segregated.
What that?
That's why I showed you lordship 179 in the LA case proceeding number.
Next para. At this juncture, comma, on a perusal of the copy of the order dated March 17, 1999, passed in WP number 9114 within bracket W of 1998 within bracket with can 452 of 1999 bracket closed, comma, we find that apart from the grant of injunction, comma, the learned single judge referred to and within double inverted original order, double inverted close, passed on May 12, 1998, restraining the respondent's authorities from proceeding on the basis of Annexure A as appended to the writ petition, comma, which the appellant submits to be the notification in respect of the connected LA proceeding itself. Full stop. Next para. Thus, comma, a doubt arises as to whether there was any subsisting restraint order against the respondent authorities from proceeding with the LA case at the juncture when the award was passed, comma, which is one of the limbs of the arguments of the appellant in the present appeal. Full stop. In order to clarify the issue, comma, let the records of WP number 9114 within bracket W of 1998 be called for at the earliest and be tagged with the present file. Full stop. The matter shall be listed under the same heading in the monthly list of November 2025. Let it appear under the heading application. If you find that it's sufficient, we can hear it out. We'll dispose of the appeal as we do.
Yes,
If both of you are ready. Only on that point.
If I am
If you come ready,
succeeding on
we
that
know
point,
you are ready.
if I am succeeding on that point, position is with me. So 24 ingredients fulfilled.
If you win on that point, then everything goes.
That's what I'm saying.
But if you don't, then the other point.
I have no case. I will say I have no case.
Practically, he has not case.
This is the only point. Can it be, my lord, hard in part?
No.
Hard?
No.
Substantial hearing. Other day, my lord, taken up for hearing.
We'll have to
today
carry
also.
this. We don't know.
Not
what
to carry.
what will happen after the
Even
maybe 4 judges will come above us and we'll lose division bench also. That may also. Yeah, if 4 judges come above us,
can't come.
that happened to Justice Mantha. That exactly happened to Justice Mantha. 4 judges came and
then again go back to
not go back. We don't consider it to.
I am not.
I'm praying that. You lost
No,
pending since 2000.
no, Miss Bhatt, you have not heard it in part.
2000.
No, we have not heard it in part.
2000
No.
matter is pending for your lordship. Kindly consider it.
No.
Age of the.
Let us go to the washroom at least.
Age of the matter your lordship kindly.
No, miss.
So kindly do it.
Not hard in part. It will remain in the list. Whoever takes up the matter, it will remain in the list. We have directed to appear in the monthly list.
Can it be taken up next week? Any day suits your lordship, Miller?
Records may not come. Those old records. We know how the office is functioning.
Item number 11.
Lord, I appear on
Yes.
behalf of the appellant. My lord.
Right. Now, appearing for the state. Yes.
Well, this is my appeal against the order, my lord, dated 11th of July 2025, passed by the London single judge. I have challenged a part of the order passed by the London single judge. My lord, it is, my lord, the appellant number 1, my lord, before your lordship, was inducted as a tenant in respect of 21.
Just take the microphone a bit to that.
My lord, appellant number 1,
Yes.
my lord, he was inducted as a tenant in respect of premises number 21, Chitla Central Road, Calcutta 27, in the year 1982. My lord, thereafter, my lord, in respect of that premises and structure, my lord, constructed there, he was a tenant. My lord, thereafter, he purchased the premises in the year 2003. My lord, by virtue of that, my lord, deed, he became the owner of that premises. My lord, in the meantime, my lord, a proceeding under Urban Land Selling Act was initiated against the original owner. And that proceeding was, my lord, reached up to the stage of appeal, and appellate authority passed an order on 16th of November 1988. My lord, that appeal was, my lord, reached its finality. My lord, after the order passed by the appellate authority, my lord, after 20 about
What order was passed by the appellate authority?
appellate authority order was passed, your lordship, kindly come to.
What was the first authority order?
First authority what order that that premises, that was the vacant land, and my lord, accordingly, my lord, section 9 has to be, my lord, followed. Section 9 of the Urban Land Selling Act have to be followed.
Urban Land Selling Act.
Yes, yes, I have. Your lordship, kindly.
Thank you. No, we have. So section under section 9.
No, yes, my lord, your lordship, kindly come to first appellate authority's order. That is, my lord, my supplement affidavit. What are the order passed by the appellate authority?
Yes.
My lord, supplement affidavit, my lord, I filed.
Supplement affidavit, yes.
My lord, page 29. My lord,
29, yes.
internal page 24. The last ordering portion I am placing, my lord.
Appeal was allowed, yes.
যেটা rejoin that যেটা supplementary period দিয়েছে না কালকে সার্ভিস yes yes I've
Not served.
I'm just checking, Mala.
yes copy has been served.
So the measurement, your measurements were accepted and they were directed to issue a fresh notification.
I am only, my lord, last part of the order that an issue fresh 10(1) notification accordingly and take subsequent steps towards vesting of the excess vacant lands in accordance with law. That is, my lord, the direction.
Fresh notification on the basis of the new measurements.
Yes, my lord. But after this order was passed on 16th of November 1988, nothing was done. My lord, in the year 2015, a notice was issued to my client, that the appellant number 1, asking him to vacate the premises under subsection 5 of section 10 of the Urban Land Selling Act. That is the subject matter of the writ petition. I challenge that, my lord, notice. And Honorable, my lord, judge, single judge, my lord, quashed that notice and further directed to comply with the order passed by the appellate authority. That is the part, issue fresh notification under section 10(1). You will also kindly come to the relevant part of the order of the past by the learned single judge. You will also kindly come to page 219 of my stay application, second volume.
Yes.
I am agreed by that part only.
Why do you say that should not be there?
That should not be there, my lord, because that order was, that direction was given on my writ application, which was, that was not my prayer in the writ application. That was not the subject matter of the writ application. And that, my lord, not, I shall place my prayer in the writ application. My lord, that, my lord, direction,
that will benefit the state respondent who did not act, my lord, since 1988. My lord, they did not comply with the order of the appellate authority, did not take any steps and issued the notice. That's why my notice, my lord.
So that was the third case beyond the.
Yes, that is the third case has been made out. Moreover, my lord, that was not my prayer.
Let us see that portion of the order.
Your lordship, kindly come to page 227. Sorry, my lord. Your lordship, kindly 229. Sorry.
Why have you put in as different pages the stamps in
Well,
between?
yes, that is
very inconvenient.
yes.
Every time you have to look
Yes.
skip one page.
229, last.
Yes.
The respondent authority is directed to initiate proceeding according to the direction of the appellate authority. Since the stage of section 10 of the Urban Land Ceiling and Regulation Act 1976. I am agreed by this part only. My lord, after 36 years, my lord, this direction has been given to the, my lord, the respondent authority.
Under the law, can't they initiate that proceeding?
Yes, my lord. They under the
So
law.
for that, why should the intracourt appeal we should interfere, Mr.
My lord, your lordship, kindly.
Yes, it was a bit excess, but
my lord,
it is a court of equity also.
My lord, it is not, my lord, that they have not come with any writ application. They did not.
We
approach.
understand, Mr. Sinha.
My lord,
the court is a court of equity. I mean, the court, the learned single judge has balanced equities because there is no bar as such. They can at any point of time initiate a fresh section 10 proceeding.
They can, but they did not comply with that order.
Is there any time limit to do it after
there is
the
no time limit, but it should be a reasonable time. My lord, your lordship knows better than me. My lord, 36 years, my lord, is not reasonable time. That is my case.
Today, suppose they issue a fresh notice under section 9. They make a fresh, they initiate the entire proceeding.
But they cannot initiate fresh proceeding because
that is what we are asking. Okay.
It has been adjudicated by the appellate authority.
No, on the basis of the previous notice, they cannot.
Well, they cannot issue even fresh notice. That has been adjudicated after, my lord, pursuant to the direction of the Honorable High Court. I am agreed by that part. You will also kindly hear this appeal. Well, I am praying for stay of that part only.
Can dispose of the appeal. This is a little matter. Let us hear Mr. Bandyopadhyay. Yes, Mr. Bandyopadhyay. Yes, Mr. Banerjee.
Because he is the state, he can answer all these things.
He is to answer actually. Yes. You are for which party? You are for the KMD. Yes.
So it is mentioned in the KIT that is converted to KMD. Finally, take down to see the supplementary appeal.
Yes.
State is not maintainable for obvious reasons. I may be wrong.
This appeal is not maintainable.
No, the supplementary affidavit cannot be taken into consideration.
Why do you say that, Mr. Banerjee?
See.
Yes.
Page 5, paragraph 5. Supplementary affidavit. Have you got it, my lord?
Yes.
I further state that while affirming the said application for state of indictment is mistake, the aforesaid documents also direct with the said application which was concerned. But this is the appeal. So even in the trial court, if you not find, if you want to add something here, you must find a proper application for addition of it.
My lord, this is their rejoinder, my lord. Their rejoinder. It was not.
Your rejoinder.
Yes. It is their
the state's rejoinder.
State's rejoinder.
They have only, and this rejoinder was filed in the writ petition. It is not a new document.
And my lord, the document he wants to, because what is his statement?
That was a part of the rejoinder.
No, but
rejoinder was there before the writ court. State's rejoinder, he has annexed that only. That is in any event a part of the record, Mr. Banerjee. We can call for that in any at any. She has just helped us.
Statement way that has been made. As if a new document to be filed by mistake that was not filed in appeal court or about the 27.
In the previous paragraph, if you see, the states that for proper adjudication is very much accordingly the copy of the said rejoinder for the state while affirming the. They say it's a rejoinder filed by them before in the previous paragraph. That is rejoinder has only. Yes, Mr. Bandyopadhyay, what is?
KIT is not there. KIT is converted to KMT. 5 and 6.
By a statutory amendment.
Yes. That will be correct.
KMDA now.
Now KMT. Okay.
We'll grant them leave to you. We'll grant you leave to. Yes. Yes, Mr. Bandhavan.
Now, my lord, the appeal is based on only 2 points. The first point is that there was a delay of 37 years between 1988 when the appellate authority passed the order until 2015 when the impugn order was served upon them. And state did not act in the meantime. That is one point. And the other point which I have found, which they have not asked today, was that they were a tenant in the same premises from 1982. Second point is inconsequential because Urban Land Ceiling Act does not differentiate between a owner and a possessor or a occupant, etc. That fine line is not there at all. So second point is redundant. The point of 37 years is not a mere point of law on which they are preferring an appeal. It's a point of fact and law. So first, my learned friend will have to show that they had agitated this point before the Honorable Single Judge, and the Honorable Single Judge failed to consider their point that my action was after 37 years. First of all, it is not. But the question is that whether we will agitate this point in a mandamus appeal court or not.
But Mr. Bandhavan, this was not that it was not.
It is not a point in the
possible
petition.
for them to agitate this because this came in the order for the first time.
No.
It was not in their prayer beyond the entire scope of the writ.
I'll tell you, Lordship, why. What is their prayer? Their prayer was to set aside 4th June 2015, which is a 10 subsection 5 order. 4th June 2015.
Right.
They knew that the appellate authority order is of 1988. It was there in the rejoinder. Their challenge was 4th June 2015. So then, when they are filing the writ petition, they know that the delay of 37 years has already occurred. How can?
Yes, but no leave. You did not have any leave to implement that. Then there was a cause of action for them to challenge anything on this.
But what has not been read out? Kindly take page 227 of the stay application. Why this occasion arises? Why this balance of equity was required?
Yes, we were thinking in that line whether the writ code
why this was balanced?
There must be some logic. If there is some logic, we maybe.
Kindly see.
Yes.
227.
Yes.
This is after recording the petitioner's submission. During the course of argument, it has been categorically and fairly argued on behalf of the respondent authority, that is state, that the impugn notice dated June 4, 2015 under 10(5) of the Act was issued upon the petitioner on misconception of law. They actually have to proceed under section 1, subsection 1 of section 10 and thereafter subsection 3 of section 10 of the Act. Thereafter, they can follow or pass such said notice. By such, they intend to withdraw the said notice. It is not that the order has been set aside, but we wanted to withdraw that notice. And that is why the scales have been balanced and I have been asked to move from 10(1) on the basis of my submission. Because we did not put the parties as well as the court to the rigmarole of the Urban Land Ceiling Act statutory provisions that this has to be interpreted that way and that way. We came up in a very fair stance saying that my 10(5) is wrong because we missed the 10(3) part. During the course of argument, a memo was placed by the competent authority dated November 13, 2024 with the intention to withdraw the said notice being an incorrect one. Having heard the learned counsel for the parties and having considered the materials of record, the impugn notice has admitted to be improper in the eye of law and is hereby set aside. Then, Malad, the point of locus has been discussed in the next 2 paragraphs. And there,
Mr. Bandhavan, sorry, did you in the section 10(5) notice? Was there any mention regarding the appellate authority's order or no?
Malad,
can we look at that?
I'll tell. Malad, that is at page 100.
Just to get a context of this.
Page 128. 128. No, 4th June is. I'm sorry, Malad.
Not 128.
126. Yes. 4th June is 126. Whereas the vacant land described in the schedule below being vacant in the government of West Bengal free from all encumbrances with effect from 16 June 1983 by virtue of so-and-so under subsection 3 of section so-and-so of the Urban Land Ceiling Act or so-and-so. Now, therefore,
this 10(3) had been set aside.
Well, this 10(5).
No, in this case, the previous occasion that appeal court which went.
Malad, I'll tell you, Lordship. Malad.
Yes.
Malad, initially there was a notice.
Yes.
Under 10(5). That was challenged in a writ petition. that is 681 of 1983.
Yes.
Yes. Malad, in that matter, Malad, it was recalled. The 10-5 was set aside.
Set aside.
State filed, Malad, a recalling application, and court gave us liberty to proceed afresh. These documents are there on record. Then, Malad, we were given liberty to proceed from the appellate stage in the erstwhile proceeding. This liberty to proceed in the appellate stage was exercised while passing the order of 1988. Now, my lord, when the 1988 order was passed, the direction in the appellate authority's order was that you proceed from the stage of section 9 onwards. We took steps under section 9, that is on 22nd of May 1989. Another writ petition was filed in 1999. That was dismissed.
Oh.
Then, my lord, there was a transfer of ownership from the original owner, Paramananda Bose, to the writ petitioner, Fighter Logic. This, my lord, happened on 18th of December 2003.
So you initiated proceeding under section 9 in terms of that 1988?
Immediately. Immediately. Then, my lord, what happened? In the meantime, the transfer happened. Once the transfer happened, the writ petitioner applied for a NOC from the authority. When the authority saw that the NOC application is there, my lord, they found that there is a post-vesting transfer, post-10-1 transfer. Then, my lord, they sprung upon action because before the application for NOC, we could not know that there was a transfer between two private parties. The NOC, application for NOC, was the point when we came to know for the first time that there has been a transfer of ownership. And this happened, my lord, in 2013, this application.
So, but from
therefore, my lord, in this background, what I was trying to impress upon your lordship, my lord, when I started my argument, is that when the statute is not prescribed for any limitation, their entire case, appeal case, is on the doctrine of laches. That case had to be pleaded somewhere. So first, my learned friend will discharge this onus and show before your lordship where that case was pleaded in the writ petition.
But
when
it
these dates were known,
could not have been because there was no liberty given at this. There was no occasion for them to plead that.
Well, the
They
occasion
did not get the opportunity. For the first time, you argued, and the court passed. Learned single judge passed this order, granting you that liberty.
Granting me a liberty which is already there under the statute. Granting me a liberty which is already there under the statute.
But you were saying that they did not plead anything about this. Like, there was no occasion for them to, because this was not contemplated. They filed a writ petition for setting aside the 10-5. You did not file any writ petition to seek any leave.
My order, I cannot file a writ petition against myself.
But there was nothing on record, anything seeking leave to initiate the proceeding, or there was no section 10-1.
In my eye, the proceeding was already there. And
yes,
it culminated into a 10-5.
But you were saying, Mr. Bandhavata, that they did not make any pleading. There was no occasion for them to plead anything regarding this.
I'll just go back to the dates again, Mala. The date of 1988.
Where would they plead it? In the writ petition, there was no occasion because you had not yet initiated section 10-1.
It would have been their case. What is my case? That why I withdraw the 10-5 before the honorable single judge. My case was that in terms of the 1988 appellate authority's order, I have done section 5. I have done 10-1. But I have missed the 10-3 step. And I have directly jumped to 10-5. This we detected.
When was 10-1 done?
10-1, according to me, the 10-1 was done on 14th of September 1989.
So there is no limitation of statutory stipulation.
That my learned friend admits, my lord. No point in taking your lordship to that.
No.
My lord, dear lordship, my lord, may I be permitted?
Yes, I am sorry.
My lord, the 10-1 was not complied with. Only they issued a notice, that notification, that was not published in the Calcutta Gazette. My learned friend is, my lord, perhaps, my lord, saying that that was not notified in the Calcutta Gazette. Only notice was issued. Specifically says, my lord's provision, that should be in the Calcutta Gazette, notification should be made. Your lordship, kindly come to 10-1.
Yes. There's no Gazette notification on it.
That's why learned.
Anyway, so very well. So you say basically
so that is a point that the procedure mentioned under the statute has not been complied by me. It is not their case that the entire proceeding has lapsed, because what I'm trying to impress upon the is that when this 4th June 2015 is passed,
even here they are not arguing that it has lapsed by operation of any law.
No, they are
They are
saying
saying
after
the
so much
huge
time
delay, yes.
that the honorable single revived the proceeding. I'm saying no. This case was already there. When you have challenged 2015, you knew that the 88 order is existing. In their eyes, that 2015 order is coming after 37 years. The year is not changing by virtue of the liberty granted by the honorable single judge. What I am trying to say is that, my lord, the liberty granted by the honorable single judge is already there under the statute. When the statute does not prescribe any period of limitation,
A direction was given to you to initiate. Anyway,
but that direction may be treated as a liberty also.
try to do it. And they'll come up with a contempt.
Because there is no other.
No, you're right. You're right.
There is no one coming before the honorable single judge to implement that order, to execute that order. They will definitely not come.
Obviously, they won't come.
And there may be someone, my lord, who is adverse to the petitioner who may come.
Yes.
The, my lord, these dates and the delay, if any, was already there before the petitioners already knew about that. Yet, my lord, there is not a single word expended on the doctrine of laches or any laches delay, whatever it might be. Reasonable time should have been taken by the state. Nothing has been done. There is no pleading at all. Therefore, when we come up in the writ petition and we say we want to withdraw the 10.5 because it's a misconception of law by us, there the balance has been struck by the honorable single judge by giving us that liberty. Only point which has been decided by the honorable single judge may not be in my favor is the point of locus. Because we have also raised that point of locus. We said that after 10.1, you have transferred, so that transfer is barred by 5.3.
That has been held in their favor.
Right, that has been held in their favor. And thereafter that liberty has been granted to me.
Very well. Let us hear Mr. Sinha. Yes, Mr.
My lord, your lordship kindly have shown the pages as yet. The document.
Yes.
Lord, after the order was passed, what steps they have taken? My lord, your lordship kindly come to page 16 of the rejoinder. Only a notification was issued in the year on 14th of September 1989.
No, they have to start. The leave has been given to start from the 10th stage.
Yes.
It should be from the 10.1 stage.
10.1 stage. 10.1
So there is no bar in law. They can even initiate. And Mr. Sinha, another aspect is there. That was not exactly in thin air that the direction was given. They argued before the learned single judge that they rather submitted that we are withdrawing that. On the premise of that, virtually it has been passed. We are withdrawing that and we'll initiate fresh proceedings. That was the impression given by them before the learned single judge also, as we find from the order also at page 227. They admit that they will withdraw that. They actually have to proceed under subsection 1 of section 10 and thereafter subsection 3. Thereafter, they can follow or pass the notice, but as such, they intend to withdraw the said notice. On that premise only this order was passed.
That is the submission made from the bar. My lord, on record, my lord, your lordship kindly consider, I have challenged the notice that is specifically that has been passed.
If there is no limitation period, Mr. Sinha, if there is no bar in law, then where is the error committed by the court?
Your lordship kindly consider when the adjudicant authority adjudicated any matter and pass a direction to comply with that, my lord, your lordship kindly consider that statute, my lord, it is not a case that they are, my lord, issuing any, my lord, proceeding and statutory provisions will apply according to their, my lord, initiation of proceeding. When a matter has been adjudicated and order has been passed, this, my lord, statutory provision, my lord, that they will not
We will
come.
only ensure that even if they issue a fresh 10.1 notification, that has to be in compliance with the appellate authority, that order which you have annexed.
Yes.
It has to be in compliance with that.
My
It
lord,
will still be, even if today they start, that will have to be in compliance of that.
By way of this, by way of giving this direction, my lord, this is, my lord, against that will, my lord, prejudice to my rights.
How?
My lord, your lordship kindly consider.
They have been directed to give you opportunity of hearing and everything.
My lord,
that is, you are entitled in law that that has been given to you.
My lord, that my lord, direction cannot be given on my writ application. They did not approach before the appellate authority for extension of time. And that was not rejected or allowed, whatever.
It is not a reason for us to interfere in intercourtable.
Your Lordship
We'll
kindly
give the
consider.
context. We'll give the context. But Mr. Bandyopadhyay, this, if you now proceed, that has to be in compliance with this or
Correct. Just to correct my learned friend, my lord, no time limit was given by the appellate authority also.
No,
we saw that.
But that's
No,
only
that has
saying-
to be in compliance with the appellate authority. You cannot go beyond this appellate authority order because
Yes.
appellate authority directed you to prepare final draft and final statement on the basis of this.
That has been done. Section 9 has been complied with. Section 9, we have already taken steps. Section 9 is 22nd May 1989.
If they don't
already done.
comply with this appellate authority's order in that whatever order was passed, 651 square feet and meters and all, then you can in any event challenge the final the final steps also taken by them.
My lord, your Lordship, if you will
And subject
They have a
to
right in law.
Appellate authority has
right
dealt
in
with
law.
many properties.
My
We
lord,
are
there is-
dealing with only 21
There
Chetra.
is no explanation before the my lord learned single judge for
We'll
delay-
consider that. You have argued
for delay, my lord.
Right. That,
And
and my learned friend there.
that
Right. No explanation has been given by us. Right. Because the point was never agitated.
The present appeal has been preferred against an order by which the learned single judge, while allowing the writ petition filed by the appellants, challenging a notice under section 10 within bracket 5 of the Urban Land within bracket Sealing and Regulation bracket Closed Act, 1976, allegedly overstepped his jurisdiction and directed the respondent authority to initiate a fresh proceeding according to the direction of an appellate authority, passed in the year 1988, since the stage of section 10 of the 1976 Act. For some next parallel, counsel appearing for the appellant submits that the appellant, in the appellants, in the writ petition, had merely challenged the notice under section 10 within bracket 5 and no further. Full stop. It is further submitted that nor had the respondent authorities sought for a similar relief. Full stop. Sought for any relief to reinitiate proceedings under section 10 of the 1976 Act. Full stop. Hence, the direction, with which the appellant is aggrieved, was passed, dehors the pleadings and the reliefs sought in the writ petition, and as such ought to be set aside. To some next para, to provide some context to the argument, learned counsel for the appellant places reliance on the rejoinder filed by the respondent numbers 1 to 4 in the writ application, that is the state authorities, where an order of, this is November 16 to 88 or dated November 16 to 1988, whereby in a challenge preferred by the predecessor in interest of the present appellants, an appeal was allowed, thereby the competent authority being directed to prepare final statement on the basis of the measurements as given there and issue a fresh notification under section 10 within bracket 1 of the 1976 Act and to take subsequent steps accordingly. First up, it is submitted by the appellant that the respondent authorities suffered a long slumber and never took any steps pursuant to the appellate authority's direction. First up, by way of the impugned direction of the learned single judge, a new right has been created in favor of the respondent authorities to reinitiate the proceedings after more than 36 years having elapsed in the meantime. Full stop. Next para. Learned senior counsel appearing for the KMDA. Yes. No. Points out that the respondent number 1 has been wrongly impleaded as Kolkata Improvement Trust, whereas it should be the Kolkata Metropolitan Development Authority within bracket KMDA. Full stop. Next para. Learned senior counsel further submits that new documents cannot be relied on at the appellate stage, which has been sought to be done by way of the supplemented affidavit filed by the appellant. For some next para, learned counsel appearing for the state submits that In the four corners of the writ petition, the appellants never pleaded that the state authorities are debarred by any law from initiating a proceeding under section 10 of the 1976 Act. Whose of next para, it is submitted that there is no statutory limitation period for doing so. First up, it is further contended that pursuant to the appellate authorities order of 1988, section 9 notice was issued on May 22, 1989. First up, it is submitted that a notification under section 10 within bracket 1 was also issued on September 14, 1989. First up, it is thus contended that the impugned order of the learned single judge did not suffer from any illegality, but rather balanced equities. Full stop. Next para. In support of such proposition, learned counsel for the state places reliance on the relevant portion of the impugned order, whereby it was recorded by the learned single judge that the respondent authorities themselves had submitted that the impugned notice dated June 4, 2015 under section 10 within bracket 4 of the 1976 Act was issued upon the writ petitioners stroke appellants on a misconception of law. First up, the respondent authorities further submitted that they actually have to proceed under subsection 1 of section 10 and thereafter subsection 3 of section 10 of the 1976 Act, and only thereafter they can follow or pass a notice, they can issue a notice under section 10 within bracket 5. First up, as such, the the respondent authorities sought to withdraw the said notice. First up, it is thus submitted that there was sufficient reason for the learned single judge to pass the impugned direction. So next para, learned counsel appearing for the appellants controverts the allegation of learned counsel for the respondents. First up, it is submitted that the rejoinder, which has been annexed to the supplemented affidavit, was already a part of the records before the learned single judge, and as such, no new document has been sought to be produced. First up, next para, insofar as the submission of learned counsel for the state that fresh notification under section 10 within bracket 1 was issued on September 14, 1989, learned counsel for the petitioner submits that in the absence of any notification in the official gazette, such notice cannot be deemed to be a notification under the said section. First up, next para, learned counsel for the appellants further reiterates his previous arguments. First up, next para, upon considering the submissions of the parties, we find that the learned single judge did not make out a third case as such by passing the impugned direction, since the very premise of the impugned order was the submission of the state authorities to the effect that there was a misconception of law in issuing the impugned notice under section 10 within bracket 5 of the 1976 Act. Full stop. Next para. In fact, it was the respondent authorities had proceeded so far as to submit before the learned single judge that they have to proceed afresh under subsection 1 and then under subsection 3 of section 10 of the 1976 Act, and only thereafter they can issue a notice under section 10 within bracket 5. Full stop. Next para, the learned single judge took note of the said fact and allowed the writ petition, as a corollary of which a direction was granted to the respondent authorities to initiate proceeding according to the direction of the appellate authority since the stage of section 10 of the 1976 Act. First up, there are two aspects of the matter which are required to be considered. First up, the first aspect is whether there was any limitation, stipulated by statute for initiating such a proceeding. First up, however, it is not the case of any of the parties that there is such a statutory limitation in initiating a fresh proceeding under section 10 within bracket 1. First up, as rightly contended by the state, Even the order of the appellate authority dated November 16, 1988 did not stipulate a time-bound direction for a fresh notification under section 10 within bracket 1 being issued. Full stop. Next para, rather, comma, the tenor of the appellate authority's order was that only upon preparing a final statement afresh in terms of the measurements as given in the said order, comma, the respondents would be entitled to issue a fresh 10-1 notification. Full stop. Next para, taking into consideration the purport of such order of the appellate authority, comma, it was open before the respondent authorities to initiate a fresh proceeding under section 10 within bracket 1, full stop. The learned single judge has merely added a direction to such liberty, which was already available to the respondent authorities. Full stop. Next para, as such, comma, we do not find any miscarriage of justice or abuse of the process of court and or any patent illegality sufficient to prompt us to interfere in an intra-court appeal, comma, where the scope of interference is extremely limited. Full stop. Next para, in any event, comma, as insofar as the other aspects of the impugned order are concerned, comma, no grievance is raised by the appellants, comma, since the rest of the order goes in their favor. Full stop. Next para, thus, comma, there is no scope of interference in the appeal. Full stop. However, comma, we grant liberty to the learned advocate on record for the appellants to carry out the necessary rectification in the cause title of the memorandum of appeal and the connected application, comma, if any, pending, comma, by substituting the name of the KMDA instead of Kolkata Improvement Trust as respondent number 5 in the appeal. Full stop. Such corrections shall be carried out during the course of the day. Respondent numbers 5 and 6. Next para, in view of the above, comma, MAT 1425 of 2025 is dismissed on contest without any order as to cost. Full stop. Can 1 of 2025 is consequentially disposed of as well. Full stop. There will be no order as to cost. Great. Yes.
Item number 12.
I am for the petitioner.
Yes, Mr. Shara, what is the matter?
Before Lordship, I am for the interim order.
It's a fight between Panchayat Samiti and the district magistrate.
It's for the Panchayat Samiti.
I am for the.
Mr. Bhattacharya, you are for the Panchayat Samiti?
No.
State.
But I am for the Panchayat Samiti, writ petitioner appellant before Lordship.
Oh, Panchayat Samiti is before us.
Panchayat Samiti is the writ petitioner.
The writ petitioner, who is for the writ?
Panchayat Samiti is the writ petitioner.
So you say it's a dispute between the.
It's a fight between Panchayat Samiti and the district magistrate.
You are for the district magistrate?
Yes, in state. Number one.
High stakes involved must be.
Number two, Malad, I would take the point of maintainability.
Number one is not a point.
Malad, no. Malad, number one, Malad, the maintainability of the writ petition. Malad, since the learned single judge, considering this aspect that.
Maintainability of the appeal, you mean?
As also the writ, if writ petition is not maintainable, then.
Yes, why not maintainable writ petition?
Because this is the settlement of the Ferry Ghat, and that is under Manual 281, and that is under also Land Reforms Act, Section 52, and the rules.
So why not maintainable?
It is a specified act, and it should go before the tribunal.
Writ petition has been admitted, direction has been given. They have not preferred any appeal. So far, point of maintainability of the writ petition, possibly they cannot take up.
Malad, may I? Malad, I'm sorry, Malad. In presence of Mr. Shaharai, I made this submission. Perhaps Mr. Shaharai will not disagree. I made this submission, and the learned single judge has said, Mr. Dhar, I am not writing this, but you can still take this point because this is the maintainability on the side of the jurisdiction. I can take this point at any time in the proceedings.
You have taken the point. Take your seat. We'll hear you on merits later on. Yes, Mr. Hare. Address this point first and then
In terms of just before coming to the
really in your own way. Yes.
in terms of two government notification, one dated 7th of March 1979 and another 22nd of June 1987, the Panchayat Samiti has been maintaining
27th of March?
7th of March 1979.
Only 7th?
My lord.
Yes.
And 22nd of June 1987.
The first one is 7th of March, which
1979.
Year? 79?
First one.
Yes, and the second one?
22nd June 1987.
Yes.
Panchayat Samiti maintaining, controlling 6 ferry ghats within their jurisdiction by settling the same through e-auctions. If you want to kindly just 2-3 documents, kindly come to page 42. Since the year 1987, there is no dispute. Since the year 1987, we are functioning, maintaining. Kindly come to page 42. This is one of the notice inviting e-tender dated 15th of February 2019.
So once you are selected, it is notified. You are speaking of that notification.
I am the Panchayat Samiti. I issuing the e-auction for settling the same to somebody else.
Right.
And we are getting the revenues. That's
Yes.
our only case. That one of the ferry guards have been taken away forcefully by the district magistrate. That's the cause of action. Out of 6. Without any reason, nothing.
Taken away in what manner?
They have issued the e-auction in respect of this particular ferry guard.
Oh. You are challenging that e-auction notice?
That e-auction. Well, kindly turn to page 42.
42
This
years.
is one of the e-auctions in respect of, kindly see, 15th February 2019. Left-hand side, one Narkelbari ferry guard. This is one of the 6. I repeat, your lordship, out of 6, only in respect of 1 they have taken away. 5 still are running. Narkelbari ferry guard.
Only this.
My lord. Now kindly come to page 46. 2-3 documents I shall show to you. This is
Yes,
2020.
yes. That you have been doing this all along.
46, my lord. 17th March 2020. Same Narkelbari ferry guard. I want to show you, your lordship, this is going on since 1987. Need not go through all the auctions I have annexed, my lord. Kindly come to page 68. All auctions I have annexed. Page 68. In respect of other ferry guard, Gopalpur ferry guard.
Was it settled to you? Initially, is there anything to show that?
That I shall show. In terms of 2 government notifications.
Oh, those were the notifications?
Yes, that has been handed over. That I shall show. But other ferry guards I have also annexed. Page 68. Gopalpur ferry guard. And page 74 is the Kotai Baga, Shaktipara. Your lordship need not go through the same. Your lordship kindly turn to page 100. But in terms of the auctions, I have issued the work order to the concerned person who has become the highest bidder. That is, will appear from page 100. Page 110 is the other ferry guards. Did not go through the same.
Page 100 is Narkelbari.
My lord, Narkelbari. Settled in respect of with other Muhammad Faridullah Sheikh. This is 2019. Now, your lordship, kindly come to page 124. This is the money received by us since 2087. I have annexed all the documents in respect of all 6 ferry guards. Need not go through the same. Kindly turn the last such auction we have plotted at page 125, 29th of July 2024. Kindly take note of page 125. Nalkelbari ferry guard, 29 July 2024, 1 year. Kindly see the list period right hand side, first table from the date of issue. Then page 131 is the work order in, sorry, my lord. Page 131 is the work order in terms of that e-auction.
137.
My 131 is the work order. Kindly see the period 1st October 2024 to 31st September 2025. This is dated page 131, dated 25th of September 2024. The work order issued in favor of the highest bidder.
This is pursuant to page 125.
My lord. Kindly see the last date, 30th September 2020, validity period of the auction. Now the next page, the order impugned. This is the first communication without any deliberation, without any intimation. We are running from since 1987. Kindly turn to page 132. This is dated 17th of July 2025.
Yes.
The district magistrate addressed to my client, executive officer, Beldanga 2, Panchayat Samiti. Well, kindly read the subject. Restraint from further settlement of Narkelbari Ferryghat by Beledanga to Panchayat Samiti. It has come to the notice of the undersigned that the Narkelbari Ferryghat has been settled in favor of Shakti Common Mill by the Belghata to Panchayat Samiti. This act of settlement is irregular and constitutes an overreach of jurisdiction as per Rule 281 of the West Bengal Land and Land Reforms Manual 1989. It is categorically stated public ferries and non-public ferries, ferries which have been declared as public ferries under the Bengal Ferries Act shall be exclusively under the control of the district magistrate, subject to the direction of the commissioner. It is pertinent to emphasize that the statutory use of the word shall, which denotes as mandatory provision. Then paragraph 3, moreover, as per section 110 of the West Bengal Panchayat Act 1973, the management of any ferry may be entrusted to a Panchayat Samiti only if such power is delegated by the state government, and that too with the approval of the cabinet. That was not, this sentence is not in the statute, I shall show. In the absence of such explicit approval, no authority lies with the Panchayat Samiti to undertake the settlement. In the absence of explicit cabinet approval, take note of my lord, the state settlement stands contravention of the prescribed rules of the business of the state government. It is therefore directed that the practice of holding tenders or entering into settlement for such ferryghats by the Panchayat Samiti must cease forthwith. As such, actions are in clear violation of the West Bengal financial rules and may be led to potential losses of the constituted fund of the state, besides amount of the so-and-so. But we took a resolution and the executive officer wrote a letter requesting the district magistrate not to do the same, allow us to them. But before that, if you will kindly see, an email has been issued on 20th August 2025 inviting tenders by the district land and land reform officer, page 137. Pursuant to the order passed by the district magistrate restraint order, now the district land and land reform officer issued a e-tender on 20th August 2025 at page 137. This is for the general information that Narkelbari Ferryghat with Kolgari so-and-so under the subdivision Brahmanpur Sadar in district of Murshidabad, which is under settlement process of the district land and land reforms officer Murshidabad, will be settled for the period of next 3 years. We are conducting it for 1 year, now it is 3 years. You'll also kindly come to the bottom portion, 8 and 9. Auction start date 15th September, 10 a.m. Auction financial end and date of 16/9. It has not yet been opened. The last date of submission of the financial bid was 16th September. Now, Your Lordship, kindly come to page 143. But this has been issued by the additional district magistrate and district land and land reforms officer, which will be appear from page 143. Now, Your Lordship, kindly see the annexure A at page 145. Narkelbari Ferryghat. Again, I am repeating before Lordship, 6 ferryghats we are functioning, controlling. Out of that, only 1 ferryghat. Now, Your Lordship, kindly come to page 147. The executive officer wrote a letter to the district magistrate requesting him, last 3 lines, to allow the Panchayat Samiti to manage and control all the ferryghats as usually for the next 25-26 years as so on. This is a written letter by the executive officer of the Panchayat Samiti, annexing therewith the resolution. I shall show to Your Lordship 2 documents that so far the other Panchayat Samiti is concerned on the same vicinity. They are still now allowing, if Your Lordship kindly come to page 151, one of such documents. In respect of Nauda Panchayat Samiti, they have not touched. They have not touched also, my lord, my other 5 ferryghats. This is 22nd May 2025. Nauda Panchayat Samiti has issued the work order that has been being functioned. But I have shown to Your Lordship that 2 rules have been quoted.
Yes.
In the impugn order. First, I am placing before Lordship. Manual. The 11th portion I have brought also, Your Lordship, kindly see. I am handing over to Your Lordship. Manual.
And West Bengal Panchayat Act আমাদের আছে?
That I have also brought 3 copies.
তাহলে লানি রাখতে হবে।
I have brought 3 copies. Your Lordship, kindly come to Rule 281.
Yes.
That which has been quoted by the district magistrate.
Right.
Possibly at page 105.
Yes.
Or may I read, my lord? 281.
Yes.
Public ferries and non-public ferries.
Yes.
Ferries which have been declared as public ferries under the Bengal Ferries Act 1885 shall be exclusively under control of the district magistrate, subject to the direction of the commissioner. These are now under the administrative control of the Public Works Department. Other vested and small varies will be governed by sub-rule so and so. My lord, I am coming to that. So far the sub-paragraph is concerned. Then, procedure for settlement of ferries. Ferries should be settled by the district land and land reforms officer by public auction to be held at least 3 months before the date from which the settlement is to be have effect. But this has also not been done because within 1 month before the expiry, they have called in. But I am not taking this point just now. Now, Your Lordship, kindly see the Panchayat Act, which has also been quoted in the order impugned, section 110. May I hand over?
No, we have.
Section 110. This is my case. But in the impugned order, the district magistrate said that ministry approval from the cabinet is required. Kindly read, Malak, 100, section 110. State government may place the property under Panchayat Samiti. The state government may, from time to time, with the consent of the Panchayat Samiti, kindly take note of, place any road, bridge, ferry, channel, building, or other property vested in the state government and situated within the block under the control and management of the Panchayat Samiti, subject to such condition as it may specify. Subparagraph, provided that the state government may, after considering the views of the Panchayat Samiti, withdraw such control and management to itself, subject to such condition as it may specify. But in terms of this section, 2 notification has been issued by the state government. I am handing over to Your Lordship, which I have quoted in my writ petition also. First, my lord, 7th March 1979, I am handing over. আগের দিন দিয়েছিলাম।
So we find two things from section 110. One is that no cabinet decision is required. Secondly, your views have to be taken before withdrawal of control.
Absolutely.
It's the other way around.
Absolutely. Without prior permission or consent from the Panchayat cannot be withdrawn. And this is the notification I am placing before Your Lordship, whereby all these Panchayat Samitis all over West Bengal has been vested all the ferries. Kindly take note of, my lord, 7th March. Making over all kinds of vested tanks and ferries to the Panchayat institutions. But from 1 to 5 in respect of the Gram Panchayats. Kindly turn the page. Roman 6. In case any khas or vested tanks whose jurisdiction extends over more than 1 Gram Panchayat, such khas or vested tanks should be handed over to the Panchayat Samiti. These all 6 ferries
across Gram Panchayat.
2 Gram Panchayat.
Second half single.
And tomorrow single.
Monday.
But Your Lordship will not taken up this matter at Monday 10:30 because 30th is the last date. Otherwise, my lord, I shall face the.
My lord, I can assure, my lord, the first auction has failed because of the fact only one participated in that auction process. You can record, my lord, can record that.
Learned Senior Counsel, heard Learned Senior Counsel appearing for the appellant, full stop. Due to paucity of time, the matter cannot be, the hearing cannot be concluded today, full stop. At this juncture, Learned Senior Counsel seeks an early hearing of the matter, in view of 13th of this month being the last date. Last date for what?
The existing person who is running the ferry ghat, that will be expired on that day. Validity period of the tender.
Of the tenure of the present present entity which is running the ferry ghat at present. Who's the next para? However, Learned Senior Counsel appearing for the state submits that in the meantime, an e-auction has failed, and as such, the apprehension of the appellant is unnecessary. Full stop. Be that as it may, let the matter be treated to be part heard and be placed in the list on September 22, 2025 for further hearing.
Well, in the meantime, they should not call for any further tender because Puja vacation is coming. Your Lordship knows. Just record it, my lord.
My instruction
is, they should not finalize.
My instruction is if anything happens, that happens in the month of November, not before that.
So November.
It's not possible.
Your Lordship, kindly record it, ma'am. Kindly record it.
Learned senior counsel appearing for the state further submits that as per his instruction, comma, no fresh auctions shall be issued before the month of November 2025. Full stop. On the basis of such assurance, comma, we are not granting any interim order at this juncture.
I'm much much. I'm good. Matter to appeal.
Item number 1.
Finally.
Item number 2. Item number 2.
This is the third occasion when none appears for the parties at the time of call. First of all, last chance was given to the appellant to appear and argue the appeal on September 12, 2025. First up, in view of the absence of the parties, comma, even today, comma, SS 705 of 1965 is dismissed for default without any orders to cost. Interim orders, if any, stand vacated.
Item number 3 to 5.
3 to 9, na?
Or
To
3
5.
to 9.
Although the appeal is ready as regards service, comma, it appears from the office report dated September 17, 2025 that no informal paper books have been filed by the appellant till date. Push up next para. The formal filing of paper books is dispensed with. Full stop. The appeal shall be heard on the memorandum of appeal and the connected papers which are already on record. Full stop. Accordingly, let the matter be listed tomorrow for hearing.
Item number 13.
Lordship, for item number 13, I'm there for the petitioner. Your Lordship, the arguing counsel is on legs in courtroom number 38. If I may take
What is the contempt application, ma'am? Just tell us that.
Your Lordship, the contempt application is against an order dated 18th April 2024. If Your Lordship can just give me a moment, I'll just get the.
Please, please. Let's check up your file.
Yes, Your Lordship. Your Lordship has the contempt application.
Yes.
Just a moment. Yes, Your Lordship. So the contempt application is against an order dated 18 September 2024. If I may take Your Lordship.
September or April?
18 September 2024.
Achha.
In the writ application. Sir, Your Lordship, in the contempt application, it's page number 41, annexure P1.
Yes, what is the contempt alleged?
Your Lordships, on para 7 and para 8,
Yes.
there was an undertaking or there was a submission that was made where the port authorities had submitted that the tender had been uploaded on the Central Public Procurement Portal.
Yes.
My client, via his other associate, had filed an RTI. The RTI is on page 45 and 46 of this application.
Which shows it was not uploaded.
Annexure, it wasn't uploaded. And it was because of this undertaking only that I'm sorry, Your Lordship, yes?
No, please continue.
It was
This is just a posture, yes.
Yes, so it was because of this undertaking only that I believe that the stay order wasn't granted. I've just been briefed in the matter, Your Lordship. I want to
Thank you
find
very
my
much for whatever you have done. Just let me check up the. Take your seat, ma'am. I'll just check up.
Yes. Lordship, if I may, my wakalatnama.
Wakalatnama file it in the department. This might have been a wrong statement, but what is the contempt about it?
Your Lordship, so
They submitted that it was uploaded. Suppose it's a wrong statement.
correct. Your
And they were
Lordship,
directed to file report also enclosing all documents. They have
correct.
not filed it.
No, no,
So if they don't file, they have.
I'll take you through that, Your Lordship. That was just so the affidavit in opposition has been annexed over here. That's on page 49. On page 49, if you're, I just want to place everything before Your
The
Lordship.
difficulty is because if they don't, they have not filed any opposition in
No,
court.
they have.
They have given a copy to you. Or they have filed also in court. Let us check.
If so, Your Lordship, I'm not.
No, they have just given a copy to you. So unless that is before the court, we cannot proceed on that premise. No, there was no further occasion to file their opposition. They might have given a copy to you. We don't file any opposition on record.
There's I'm not.
We'll pass it over for because I'm not so convinced that contempt lies.
Correct, Your
So
Lordship.
because therefore I'll pass it over whenever somebody will be coming.
I believe so, Your Lordship. I believe he's on his way. That's what he said. Mr. Sinha Roy is appearing in the matter. I'm assisting him.
So let us pass it over for the time being. If they
I'm
don't
grateful,
come,
Your Lord.
Thanks. Yeah, pass over. Pass over tak hoye gela abar korbo.
Yes. Item number 14 to 36.
My lord, these are, my lord, applications taken out by my lord DVC in a batch of writ petitions. My lord, where the issue is with regard to, my lord, a challenge to, my lord, the tariff order for the control period 18 to 20. Now, there has been a change in circumstance. There has been a change in circumstance as a result whereof, my lord, we have taken the liberty of filing this
No,
application.
Mr. Doctor, the writ petitions were finally disposed of.
No, Lordship was pleased to initially pass an interim order directing DVC not to take any coercive action.
Right.
And thereafter, this interim order was extended from time to time. And it was ultimately observed by your Lordship that this will be till disposal of the writ petition. Reason being that a similar challenge with regard to, my lord, tariff order for control period 17-18 was, my lord, decided by this court. From there, my lord, there were two writ petitions. My lord, one was challenge to the tariff order, which DVC succeeded. Writ petitions failed. One was, my lord, challenge to disconnection notices issued pursuant to that order, which again was challenged. DVC failed. Writ petitioner succeeds. Both these, my lord, orders challenged before the, my lord, division bench by two sets of appeals, one preferred by DVC, one preferred by the writ petitioners who, my lord, were aggrieved. My lord, in that appeal, my lord, an order was passed, interim arrangement, and that appeal is still pending. Because the appeal was pending and it pertained to just the previous control period, Lordship felt partly the issues are similar in nature, and therefore, in the interest of justice, these writ petitions were being adjourned from time to time so that that appeal could be decided, and that would have decided the fate of the writ petitions also.
This is not an assigned matter.
Part heard matter.
Part heard. So what
my
is
lord,
the application?
This application today, I am seeking modification and or variation of
You are the
your.
DVC.
I am DVC
Mr.
of that order.
He's also
Mr. Kaur is representing the consumers.
what?
No, not the consumers.
Okay, he cannot represent it. Does not have locus
I'm
standi to
sorry.
represent.
No,
I am someone parallel.
Mr. Kaur is representing one of the my lord, consumers.
Yes.
Item number 30.
So, my lord, today,
Yes.
my application is for modification and a variation of that order by which Lordship said that no coercive action would be taken. Reason, my lord, there is an order of the APTEL now. APTEL order has, my lord, determined, my lord, what is the mechanism to be followed, how payments have to be made. This is pertaining to control period 18-20. Regarding control period 17-18, my lord, there has been challenges to this court, ultimately goes up to the Supreme Court, where there is a mechanism, my lord, formulated. The mechanism is this: as an ad hoc arrangement, 50% of cash has to be paid, balance 50% bank guarantee. Till such time the bank guarantee is furnished, within 7 days a PDC, bank guarantee once furnished, PDC will be withdrawn or PDC will be made over to them, and an order of injunction on the consumer, the existing consumer, not to migrate to another licensee company. This is, my lord, I want a similar relief. I am placing my case a notch higher today, my lord. My relief which I am claiming is, my lord, disbursal not 50%, entire 100%. And there are, my lord, two categories of consumers here in all these batch of writ petitions. The
100%
first
is paid. I mean that would be hearing the writ petition or sitting over sitting in judgment over the previous ad interim orders passed.
I would not invite your lordship to do that because I know my.
So what you are asking for is virtually the disposal of the writ petition
No,
in
no,
the garb of.
no. I won't. That's why, my lord, my prayer is that, but I indicated what is the arrangement that is subsisting. My lord, this
Seeking a leave to, my lord, file an affidavit.
No, I would be pressing for an interim order, my lord. I'm sure lordship would be, my lord.
Interim order, you are sure I'll be refusing that also.
I'm not sure about that, my lord. Interim order.
Interim order, grant of interim order, that would be modifying the interim order. That would be
Otherwise, my lord, kindly visualize the situation. Lordship has been, my lord, very kind to give them a protection, and that protection was continued.
No coercive action. Now you are seeking a variation of that. So unless we, if we grant any ad interim order on that, that would tantamount to allowing.
My final order is, my lord, payment of the entire 100%. I am asking for an interim protection today to the extent that the arrangement which all consumers, my lord, are being, my lord, imposed upon all consumers in respect of control period 17-18, which has been followed by the division bench of our High Court, order passed by APTEL, followed by division bench of our High Court, followed by single bench of our High Court, affirmed up to the Supreme Court. So why not these consumers? Otherwise, the difficulty
particularly
is this,
because that was the pendency of those were the reason for passing this course event.
Correct.
So
And
that has culminated in
has
that.
been extending the interim order because rightly lordship said that
Those
some issues are involved which are common in
Those
nature.
have not been disposed of,
Not
but
yet.
this interim arrangement
is continuing.
So similar thing should be
I,
here.
as an interim protection, my lord, I am seeking a similar protection here, similar order here, so that, my lord, at least DVC gets, my lord, what is happening is this. I'll give you, lordship, the practical, my lord, scenario. My lord, DVC is ultimately left high and dry, my lord, fighting with these consumers in realizing, my lord, the money. My lord, even after orders of injunction, if a, my lord, consumer, my lord, migrates, my lord, I have nothing else to do but to, my lord, sue the, my lord, consumer to realize my fund. My lord, we were, my lord, that's the reason why both division bench and
Course action for that period only, you are realizing the current amounts.
current amount, yes. But, my lord, now
Not
that
left
the
high
APTEL
and
has
dry.
determined.
Not left high and dry in that manner.
No, my lord, the
regarding this period only, yes.
No, my lord, why I said this expression has been, my lord, used by APTEL when APTEL, my lord, determined the tariff for the control period 18-20. And in doing so, APTEL has discussed how many consumers were there, what kind of.
Oh, achha,
My lord, that's the reason. From that, my lord, I draw inspiration. And I have, my lord, taken out this application because for all practical purposes, the consumers must also be treated at par. If control period 17-18, my lord, the consumers are, my lord, impose some condition and that is being continued, why a different, my lord, privilege, or why, my lord, this should not be, my lord, imposed, this condition not be imposed on these consumers for control period 18-20.
What is the arrangement? Where do we find that arrangement?
My lord, kindly sees one order, my lord, where this.
Yes.
No, I mean,
exactly the same arrangement is being followed by everybody. I mean, the single bench there. He shows the.
My lord, kindly takes the division bench order. Lordship will realize what is, my lord.
Supreme Court, what did the Supreme Court do?
Supreme
Reject
Court took
SLP.
the DB order, my lord, it went to no. Continues with one extension of time to, my lord, fund.
The same arrangement has been
made. I will show. My lord, kindly takes 345 volume 2 once. Just to cut short, my lord, what is the arrangement, my lord? 340 volume 2.
বলছেন যখন খেয়াল রাখতে হবে।
My lord, I am referring from this application is item this is the first item, item 14.
What other volumes you will refer to? Just can you?
My lord, there are 2 volumes only, volume 1 and 2. Lordship keeps both the volumes, for the time being takes volume 2.
Yes.
I mean, HP first item 14.
Mr. Kaur, you are some of the consumers, you said. One of the.
My lord,
Item number 30.
I am in item 14, but pages are, I am told, pages are same.
So all same.
345.
345, yes. You are for?
He is for all. He is for all. He is one and all, my lord, for consumers.
It was said about somebody that in that court, he appears for either the plaintiff or the defendant or both. Yes, Mr. Chakraborty, you are appearing for whom? One of the consumers, another consumer?
Some of the consumers. My lord, kindly comes to, my lord, page 345. Let me place this order, lordship. This will make things clear, my lord.
Yes.
At 349, it starts. These and this is, my lord, for control period 17-18. From there, my lord, an appeal where this, my lord, order was passed.
17-18 is our consideration also in this.
Our consideration is 18-20. So
yeah.
I am saying similar, my lord, conditions should be imposed. These applications have been filed praying for.
But the grounds of challenge were similar.
Yes.
That was the reason why we.
Yes. And this was also, my lord, passed on a modification application by the division bench after the APTEL had passed the order for 1718. That is why, my lord, I am saying, my lord, I should be afforded the similar benefit here.
But was this passed at the administrative stage of the modification application?
Yes. I will answer all, my lords.
Then yes.
That is why I was, my lord, not, my lord, agreeing to that affidavit thing. Of course, subject to, my lord.
No, we understand. I understand. Yes.
Para 1, my lord, 349.
Yes.
These applications have been filed praying for appropriate modification of the order and direction passed on 10th February. Operative portion reads as follows. For the above reasons, respective applications being can such and such are disposed of by modifying the earlier interim order by directing consumers appellants to pay 50% of the arrear based on tariff as determined in the order passed by DVC within a period of 60 days from the date of receipt of the server copy of the order, and balance 50% shall remain stayed, however subject to the condition that the consumer appellant shall give unconditional bank guarantee from a scheduled bank within 60 days from the date of receipt of the same. It is made clear that this interim order is subject to the final result of the appeal. The prayer sought for in these applications would tantamount to review in the matters which is not permissible by way of applications. Then, my lord, the submissions I am, my lord, skipping for the time being, kindly comes to page 350, para 7 onwards. After hearing the learned senior advocates for the parties for a considerable length of time, this court is of the view, since the consumers' appellants are ready and willing to pay remaining 50% instead of furnishing a bank guarantee without modifying the earlier direction, would only extend the time fixed to comply with the second part of the direction by granting 60 days time from the date of receipt of the server copy of the order. Well, pausing here for a moment, the first direction was 50% cash, 50%, my lord, bank guarantee. Modification sought for by some consumers was they want to pay the remaining 50% instead of furnishing bank guarantee.
The modification.
They sought. Then, my lord, kindly sees 351, para 8.
That's on a different footing. They sought it.
I know what is, my lord, traffic.
That's why
whether DVCs, it is on DVCs.
It was really granted to them, actually.
I will address that also. It will be open to the appellants, either to the consumer appellants to comply with the second limb of the direction as contained in para 11 to pay the balance 50% within the extended period. Up to para 8 is, my lord, at their instance, that modification. Then, my lord, kindly sees para 9 onwards. In order to safeguard the interest of DVC, the consumer applicants are permanently restrained from shifting to any other generating company till payment is made. It is made clear that the above direction will be applicable only to such of those consumers appellants who had filed applications before the court. If any other consumer seeks a similar relief, they have to approach DVC by way of a representation, which shall be considered. In addition to the order restraining consumer appellant from shifting to any other generating company, a post-dated check for 50% of the balance amount shall be given by the consumers to DVC, which shall be returned upon compliance of the condition, either by furnishing bank guarantee or payment of 50% within the extended time. This was not, my lord, modification which those consumers who filed the application sought for. They wanted to pay 50% cash in lieu of the bank guarantee. Court, my lord, considers to, my lord, balance equities. Or courts, my lord, division bench, my lord, balances the equity, protects the interest of DVC and safeguards to a limited extent. Apart from the 50% cash, 50% bank guarantee is to be given. There is a check to be furnished by 7 days, which shall be returned if, my lord, once the bank guarantee is submitted. Additionally, order of injunction restraining them from migrating to any other licensee company. And insofar as para
9 is, was not even prayed for by anybody.
No, but this order was tested before the Supreme Court. This was challenged again.
By them.
By them. My lord, kindly now sees the, my lord, Supreme Court
regarding
order.
that portion, that shifting to other generating company.
So the entirety of the order was challenged. My lord, I don't have the SLP copy, so I won't be, my lord.
No.
But kindly sees the order once. At the instance of two consumers, two writ petitioners or appellants there, my lord, this SLPs were filed. There are two orders. Kindly comes to the first order at page 368.
This restraint order is, why should they be restrained from doing it? Yes, to protect your interest, we can understand.
My lord,
otherwise, you have to realize.
My lord, crores. And what is,
public,
my lord, what is actually happening is they are, my lord, either going to, my lord, insolvency. My lord, my entire debt is being, my lord, claim is being wiped off.
So they cannot be restrained from doing that.
Can't, but my lord, some of the consumers may be genuine reasons, some not so genuine reasons. This scheme of the act, the insolvency and bankruptcy code is being used for the purpose of wiping of these kind of debts. and thereafter, my lord, coming
We
with
can
a
grant
clean
you a
slate.
similar relief as in para 11,
My lord is looking at the again
page
division.
351.
Yes, my lord.
For the other, the people other than the applicants.
My lord, this will not, my lord.
Because this governed only to those applicants who willingly went to the court for.
No, I would have understood if the order would have ended at para 8. This was at their instance. My lord, the court is looking at, my lord, this is, my lord, a writ petition where they want equitable relief. My lord, if you want equitable...
It is clarified that it is made clear that the above direction will be applicable only to such of those who had filed the applications before the court. It's restricted to para 10 and 11 together. So it is restricted to them, and that was in the context of their application. They showed their bona fides and all.
Yes.
But they sought a modification. They wanted to get rid of this burden, maybe.
No, but my lord, consumers who are in a similar situation in respect of that control period.
Maybe, but I could have understood, Mr. Dotto, if it was on your application that this was granted, then it would be on similar footing.
My lord,
they approached, they wanted to pay, court restricted it to them only, and the others have to approach DVC.
My lord, the kindly comes to the first page of the order, first para of the order, my lord, page 349.
349. Yes.
Lordship will find reference to the order of 10th of February 2025. This was at DVC's instance.
That was initially granted.
So, my lord, this is only a modification. I will show, my lord, the 10th February order also.
So you want para 1, that would do for you. Para 1, whatever.
The quoted portion.
The original
portion.
Original one.
In addition, my lord, the Supreme Court, what the Supreme Court has affirmed, my lord, kindly comes to, my lord, once, page 368.
Yes, 368.
Para 2, my lord.
Right.
The time to furnish the bank guarantee qua 50% amount is extended for a period of 6 months from today, subject to the condition that the petitioner shall not shift to any other distribution or generating company by terminating the contract with the respondent. Petitioner shall provide post-dated check as security.
That was in continuance of the order.
It was extension of time which was granted. The order.
Since it was extended, the whatever was granted initially, that was carried with the extension.
Yes. The other order, my lord, in respect of the other consumer.
Basically non-interference with the order of the.
Non-interference with the order. And then what is, my lord, standing, my lord, today, 10th February order to the extent modified for those consumers who applied, or those appellants, my lord.
Even without those modifications, that 10th February remained.
And, my lord, the observation in the 8th April order of the division bench that bank guarantee, till such time you furnish bank guarantee, provide me a security check, and once you give the bank guarantee, I will return you the security check. Plus, my lord, that injunction that you will not shift to any other.
Was my order passed before 10th February?
Lordship's order is before 10th of February.
Before 10th February.
Yes. Otherwise, Lordship would have taken into consideration that possibility.
You would have placed it, obviously.
Yes, of course, my lord, DVC would have placed it. Now, my lord, kindly takes, my lord, the 10th February order.
Yes. Back in 2 minutes. Yes. But this will be over by.
No, my lord, I will show, my lord, 2-3 pages.
He will show something.
And all in all is there, my lord. He is there.
All in all. Yes.
And no one.
All in all feels so.
My lord,
kindly, there no ones.
My lord, kindly comes to page 313. The 10th February order, my lord. It starts at, my lord, 319. My lord, the portion, my lord, the ordering portion, my lord.
Yes.
This application has been filed by Damodar Valley Corporation seeking for a direction upon the appellant to make payment of an amount equivalent to 50% of the area dues arising out of the order dated 5th May 2022. My lord, 5th May 2022 is the APTEL's order determining tariff for control period 17-18. And this application was taken out by DVC in the pending appeals, my lord, where, my lord, the challenge was 1 to your lordship's order by which lordship had dismissed the writ petitions to the tariff order and allowed the writ petitions to the disconnection notices. For the period 17.
Appeals are still pending.
Yes, appeals are still pending. And that is the, my lord, interim arrangement which has been framed continuing. We have elaborately heard the learned senior advocate appearing for applicant DVC and the senior advocate for the consumer. A small prelude will be required in this case. Appellants before us are classified under two sets. First set of appeals has been filed by DVC when the matter was heard by this court at the first instance on 19th April 2023. An interim order was passed, taking note of the fact that the appellants writ petitioners had the benefit of an interim order during the pendency of the writ petition. Considering the fact that the writ petitions were heard elaborately and a detailed judgment has been passed by the learned single bench, we thought fit to admit both set of appeals. We further directed, since in the first set of appeal filed by the consumers had the benefit of an interim protection during the pendency of the writ petition, we directed DVC not to initiate any coercive action against the consumers for recovery of arrears dues for 17-18. Similar was for 18-20. Taking note of the fact that DVC has also filed an appeal challenging the order passed in the second set of writ petitions filed by the consumers, and in order to ensure that rights of DVC are not in any manner impinged, we directed all consumers to file a letter of undertaking before DVC that in the event they are unsuccessful in their present appeals, they will be able to pay the demand made by DVC on account of arrears. In the light of the interim order passed, DVC was directed to restore the service connection subject to payment of usual charges. Subsequently, matter was heard on such and such, and matter was listed under the caption to be mentioned, which was recorded in the order dated 27th April 24. On 22nd August 24, the APTEL passed an interim order by which the earlier order passed by the tribunal of 1st July 24 was clarified by specifically mentioning that the earlier order extending interim order even to non-parties could not have been passed by the tribunal in exercise of its appellate jurisdiction under section 111 of the Electricity Act 2003. My lord, it was initially an order which was operating in rem. Even, my lord, consumers who were not parties to the proceeding or were not parties to the, my lord, association who had filed an appeal before the APTEL, but they were enjoying this order. And that it is only on its appellate jurisdiction being invoked by a person aggrieved, the tribunal would be entitled to pass appropriate orders in such an appeal. It was further held that interim orders passed in such an appeal in favor of the persons aggrieved cannot be extended to those who have chosen not even to invoke the appellate jurisdiction of the tribunal. Thus, it was said that the orders passed by the tribunal under section 111 of the Electricity Act cannot therefore be extended to persons who have not invoked its appellate jurisdiction. It was clarified that a list of members of the appellant, both at the time when the appeal was instituted and subsequent thereto, has been furnished. Order also restricts the interim order to such those members who were members in the first list given before the tribunal. Subsequently, tribunal passed an order of 7th October 24, further clarifying that in the light of the second proviso to Rule 29, namely the Appellate Tribunal for Electricity Rules 2007, it is only with respect to those members whose numbers were reflected in the first list can the interim order dated 21st June be said to apply, since that is the list which contains details of the members for whose benefit the appellant association can be said to have instituted the appeal before the tribunal. Thus, it is clear that the order passed by the tribunal stood restricted to such of those members whose names are being reflected in the first list. Then, my lord, there was a challenge. I am skipping this part from that order to the... Now kindly comes to, my lord, paragraph 6.
Yes.
In civil appeal, my lord, before the Supreme Court, when the challenge was made, in civil appeal, the Honorable Supreme Court passed an order on 22nd November, observing that considering the facts and circumstances of the case and also in view of the fact that similar matters pending consideration are coming up for hearing on 6 December, the appellant's power will be restored, subject to depositing 50% of arrear with DVC within a period from 1 week from the date of the said order. Appellant shall continue to pay current dues and the amount will be subject to outcome of the appeal. Thus, it is seen that in batch of cases which are pending before the Supreme Court, a conditional order of stay has been granted, even by which the Honorable Supreme Court has directed payment of 50% of arrears by consumers to DVC. DVC filed application before the learned tribunal for vacating the interim order granted by the tribunal on various dates, namely such and such. These applications were heard by the tribunal and an order passed on 17 January 2025. It was this is the APTEL order, 17 January 25. It was contended by DVC that it has been prevented from recovering legitimate tariff arrears, resulting in financial distress and operational challenges. Additionally, certain consumers had disconnected their services, leaving substantial arrears for payment. It was further submitted that these outstanding dues are becoming bad debts, thereby causing irreparable financial loss to DVC, which is further aggravated by regulatory limitations for recovery of such dues through tariffs. Further, it was contended that financial hardship arises directly from the continued enforcement of the stay order, highlighting the need for adjudication for the applications for vacation of stay in the light of change in circumstances. My lord, change in circumstances because the APTEL passed the, my lord, order determining the tariff. The applicants, namely the consumers, also made their submissions largely based upon merit of the matter which is pending. Learned tribunal, after elaborately hearing the advocates for the parties, crystallized the issue for consideration in paragraph 32 of the order of 17 January 2025. Pointing out that the main contention raised by the applicant is of changed circumstances after the order dated 18 September 2023 for financial year 17-18 based on actual audited figures, thus satisfying the requirements of second proviso to Order 39 Rule 4 CPC for modification of the stay order on the ground of undue hardship caused to DVC on account of non-recovering of past dues, and more so, no carrying cost had been granted for the period 1st April 2017 till passing of the impugned order, dated 5th May 2022. No restriction on the Learned Tribunal to review its stay order in view of the order passed by the Honorable Supreme Court dated 17th May 2024. Consumers, on the other hand, contended that there is no change in circumstances as APR order dated such and such has directed adjustment of the revenue gap of 782 crores or part thereof with the APR of financial year 2020-21 or any subsequent year. Therefore, tribunal order quoted the order passed by the Honorable Supreme Court dated 17th May 24, filed by the applicant challenging the order of 5th April 24 of the tribunal, and took note of the predicament of the tribunal in the order dated 5th April 24. Operative portion of the order has been extracted in para 35 of the order of the tribunal dated so and so. Then para 7. In para 37 of the order of the tribunal, crystallized the main issue which is to be decided by it. Ultimately, tribunal observed that instead of complete vacation of the stay and with a view to protect the interest of the appellants, the ex parte ad interim orders passed by this tribunal on such and such should be modified to the extent that 50% of the arrears based on the tariff as determined in the impugned order are to be paid within 30 days from the date of the order, and balance 50% shall remain stayed. The Learned Tribunal also took note of the submission of DVC that a few consumers in the past have left the distribution system of DVC subsequent to interim orders of the tribunal. Therefore, with a view to ensure that DVC is not left high and dry in case the main appeals were to be dismissed later, there was direction for payment of balance 50% of the arrear, which was directed to be stayed, and the consumers were directed to give unconditional bank guarantee of equivalent amount from a scheduled bank within 30 days from the order. Further, it was observed that the appellant's consumers shall comply with the direction of payment of full tariff as per interim orders dated such and such. It was clarified that the above interim arrangement is subject to the result of the main appeal, and accordingly the interlocutory application by DVC for vacation of the order of stay was disposed of. So, my lord, APTEL was considering this order was passed by APTEL on an application filed by DVC there for vacating the, my lord, interim order, blanket interim order. And this was the order passed by APTEL. The appeals have been directed to be listed so and so. Then, my lord, kindly sees para 9. Based on this finding of APTEL, what does the division bench hold in the 10th February order? The main question arises as to whether the prayer for modification filed by DVC has to be allowed. As noted above, there are two interim orders which were passed in a batch of cases. One dated 23rd September 24 and the other dated 30th September 24. Both these orders were passed after the order passed by the tribunal dated 22nd August 24, by which it was clarified that the earlier order was modified, restricting the benefit of the order only to those members of the appellants in the first list given before the tribunal. At that juncture, the court only took into consideration that the consumers had the benefit of the interim order in the pending writ petitions. To be noted that the writ petitions have been filed by the consumers, have been dismissed, and they are on appeal before us. Thus, what is required for the court to see at this juncture is whether, and I'm relying upon this part heavily, my lord, whether the balance of convenience is in favor of DVC, whether on account of the blanket interim order, DVC is put to irreparable hardship, and whether DVC was able to make out a prima facie case. In our considered view, these aspects were dealt with by the tribunal, pointing out these aspects of the matter have been taken note of the tribunal, and financial well-being of DVC was one of the facts which was taken into consideration by the Learned Tribunal. To adopt the words used by the Learned Tribunal, we refer the observations contained in paragraph 41 of the order dated 17 January 2025, wherein the Learned Tribunal has observed that DVC should not be left high and dry in case the main appeals were to be dismissed later. Thus, The learned senior advocates appearing for the consumers would submit the current consumption charges are being paid regularly. Consumers have no option except to pay current consumer charges, without which the electricity supply cannot be affected to their respective units. In the preceding paragraph, we have taken note of various interim orders passed by the Honorable Supreme Court, and in the order dated 22nd November 24, the Honorable Supreme Court has specifically pointed out, considering the facts and circumstances of the case, and also in view of the fact that similar matters pending consideration are coming up for hearing, there was a direction upon DVC to restore the appellant's power connection subject to payment of 50% of the areas with DVC within the time frame. It is also made clear that consumers shall pay current dues, and all such payments shall be subject to outcome of the appeal. Thus, in our considered view, the earlier interim order granted should be modified to be in tune of the order passed by the learned tribunal dated 17 January 25, in order to only maintain uniformity in the matter and also to secure the financial well-being of DVC, which had heavily borne in mind of the learned tribunal while passing the impugned order. Then my lord kindly comes to my lord para 11 at page my lord 330. For the above reasons, I'm sorry. Yes. 330 my lord, para 11. For the above reasons, the respective applications being can so and so are disposed of by modifying the earlier interim order by directing the consumers appellants to pay 50% of the areas based on the tariff as determined in the order passed by DVC within a period of 60 days from the date of receipt of the server copy of the order, and balance 50% shall remain stayed, however, subject to the condition that the consumer appellant shall give unconditional bank guarantee from a scheduled bank within 60 days from the date of receipt of the same. My lord, this is exactly, my lord, what the APTEL said after, my lord, the Supreme Court's initial interim order. It is made clear that this interim order is subject to final result of the appeal. My lord, against this order, there was an SLP. My lord, that is at page 353. This was dismissed from the 10th February order. And thereafter, some of them, my lord, came again before the division bench saying, please modify, instead of 50% covering that balance 50% bank guarantee, we want to pay. And that is why, my lord, till paragraph 8 of, my lord, the 8th April division bench order, that observation was made. But again, my lord, considering the previous 10th February order,
there was 3 stages. First, the division bench granted blanket stay.
Yes.
Second is this order.
Modification.
First
yes.
modification.
Yes.
That modification was at your behest.
And because, my lord, there was a determination.
APTEL and up to Supreme Court also. Supreme Court, the APTEL matter went to the
this matter. APTEL also, my lord, my lord, that APTEL order was also challenged. My lord, that interim order of APTEL was also challenged. That's also dismissed. I have disclosed that, my lord, 338. That order is also there.
Very well. Since this is these pendency of these were the premise of my interim order, so I should follow this also.
That is my respectful submission, my lord, that, my lord, this will balance the equities. My lord, they should not have, my lord, a blanket protection from the court, which they were enjoying, but now, my lord, there has been a determination. So I am, my lord, requesting your lordship to reconsider.
Factor also we can consider here.
And, my lord, both Supreme Court and our High Court takes into consideration, my lord, the situation which DVC will be faced with if, my lord, some kind of protection is also not afforded to DVC. And that is my respectful submission. I want, my lord, the court to, my lord, balance the equities here. My lord, give me just one moment.
Yes.
My lord, only one more. My lord, there is a order passed in respect of, my lord, the tariff period 1820. My lord, we have got it now. My lord, I have prepared a supplementary affidavit disclosing that, my lord. Kindly permits me to, my lord, file the supplementary affidavit. Madam, my lord, before showing the operative part, only 2 paragraphs, my lord, just to, my lord, draw my lord's attention to the circumstances which DVC faces. My lord,
what is this? This is the APTEL order.
This is the APTEL order for tariff period, a control period 2018 to 2020. And, my lord, the previous
18 to 2020 is before, in challenge before us.
Now, in these writ petitions, batch of writ petitions. My lord, kindly, the page number lordship will find at the foot of the page, right hand side, kindly comes to, my lord, internal page 3 of the, my lord, APTEL order.
Yes.
That's page 5 of the supplementary affidavit. My lord, just after the first 3 lines, In passing the interim order in IA number so-and-so in appeal number so-and-so dated 29 July 2022, tribunal adopted the reasoning given by it in its earlier interim order passed in so-and-so and had stayed recovery of arrears for FY 2018-19 and FY 2019-20, subject to the condition that appellant continue to pay its current dues. The second respondent applicant claims that in terms of the impugned order passed by WBERC, that's the Regulatory Commission, they are yet to recover a total sum of rupees 308.82 crores as tariff arrears from its for the financial years 18-19 and 19-20 from its consumers on account of the interim order passed by the tribunal on 29 July 2022, which included 217.40 crores from existing connected consumers and 91.42 crores from consumers who had availed supply of power from DVC but had subsequently disconnected themselves from the network of DVC. And this amount of 308.82 crores excluded delayed payment surcharge. Now, my lord, the operative part kindly comes to my lord. Internal running page table. My lord, this should be my lord. Internal page 37, running page should be my lord 39.
Yes.
The last paragraph, my lord, at page 39. Consequently, insofar as the 16 defaulting members of the appellant association are concerned, the interim order passed by this tribunal on 29 July 2022 would cease to operate, and the modified order which we have now passed shall not apply to these 16 members. Likewise, Messrs. Metsil and Surya Alloys have admittedly filed writ petitions before Calcutta High Court seeking a similar interim relief as is being sought in the present appeal. Doctrine of election would apply, and it is impermissible for any party to simultaneously seek the same relief between different fora. Since these two companies have approached the Calcutta High Court, suffice it to hold that the interim order passed by this tribunal on 29 July 2022 and the present modified order passed by us shall have no application insofar as they are concerned, subject to any order which the Calcutta High Court may have passed. It is open to the second respondent DVC to take action for recovery of all dues from these two consumers in accordance with law. My lord, I cannot take recovery action because I am, my lord, still governed by the interim protection that is subsisting. But the APTEL says, my lord, those consumers who are not there before the APTEL, my lord, they, my lord, will be governed by orders passed by the Calcutta High Court. Since no interim order is in force with respect to 16 defaulting members of the appellant association, it is open to second respondent DVC to recover entire arrear dues from them. Needless to state that the question whether the appellant association should bear the cost of restitution in case appeals were to be dismissed later with respect to these 18 members, 16 of whom have left the area of supply of second respondent DVC and 2 others who had simultaneously invoked the jurisdiction of Calcutta High Court shall be examined when the main appeal is taken up for hearing. My lord, this is the, my lord, situation. Now, lordship sees, my lord, some have already, my lord, disconnected 91 crores and odd against those 16 consumers who have, my lord, gone. And my lord, total, my lord, dues is 308 crores and odd. My lord, I am not, and my prayer now in the, my lord, CAN application, lordship would appreciate why I said, my lord, the entire 100% should be directed. Because of this, my lord, observation in the APTEL order. But for the time being, my lord, I am, my lord, satisfied with the, my lord, order which is subsisting so far as, my lord, other consumers are concerned. In respect of, my lord, the control period, my lord, 17-18, and, my lord, I say, my lord, the same benefit or the same protection should be afforded, my lord, to these consumers, should be afforded to DVC in respect of, my lord, the control period 2018 to 2020. My lord, now kindly sees the prayers which I have made in my application, my lord. Kindly now comes to the prayer once at page 22 of the CAN application in volume 1. My lord, kindly comes to page 22, prayer A. The order dated 11 July 2022 has extended from time to time passed in WPA such and such be modified and or varied by directing the writ petitioner to forthwith make payment to the applicant DVC the entire area dues arising out of the order dated so and so for the period so and so amounting to rupees so and so. And an order of injunction be passed restraining the writ petitioner from shifting to any other licensee without clearing the entire dues arising out of the. My lord, this is in line with, my lord, the observations which are there, my lord, in the 10th February order in the 8th April order, both passed by the division bench of our High Court, and my lord, the Supreme Court order, which my lord really extends the time for furnishing the bank guarantee, does not, my lord, interfere with the, my lord, operative part of these
Not
two
in
orders.
terms of that order, you have asked for the entire amount.
No,
but that is one of the alternatives there.
Final relief, my lord, I understand.
Understood.
But my lord, that is the reason, my lord, I am
That
happy.
was one of the options given to the opting parties who came before the.
Yes, that
Otherwise, it was not given, but 50% you are saying and rest bank guarantee.
Yes. My lord,
At least.
My lord, kindly permits me to, my lord, just rely on one coordinate bench, my lord, decision, my lord, passed in a writ petition filed by a consumer in respect of, my lord, the control period 1820. My lord, where, my lord, the similar arrangement was, my lord, followed.
That was after my order.
Yes, yes, yes.
Because by then these orders had come.
Yes.
You must have cited
Yes,
that.
yes. My lord, kindly takes this, my lord. Paragraph 2. The petitioner challenges the notice dated August 12, 2025, issued by DVC, whereby petitioner was directed to pay outstanding arrears on or as on June 17, 2022, amounting to rupees such and such, within 15 days from the date of issuance of the notice in terms of section 56(1) of the Act and clause 4.1.1 of the regulations. Then, my lord, kindly turns the page. Internal page 2, my lord, just after the, my lord, second paragraph. During the course of hearing, it was submitted on behalf of DVC that the electricity line has already been disconnected today as petitioner has failed to pay the final installment of the security deposit amounting to rupees so and so. Counsel for the petitioner has drawn the attention of the court to an order dated 11th August 2025 passed by APTEL, my lord, the order which I had relied in the supplementary affidavit, wherein certain other consumers have obtained following reliefs relating to the arrear dues for the control period. And my lord, kindly comes to page 3. My lord, last line, the learned judge observes that the benefit of the interim order of August 11, 2025, passed by APTEL should be extended to the petitioner. It is not in dispute that the arrears claimed herein arise out of the same period, 2018-19 and 2019-20. Petitioner cannot be denied the benefit of the said order merely on the ground that it was not a party to the appeal before APTEL.
Was it 2018 to 19 and 19 to
Yes,
20 or
yes.
2-year period?
My lord, 18-19, 19-20, 2-year period. Yes. Nevertheless, in order to secure the interest of the licensee company, order of the APTEL requires modification by directing the petitioner to deposit post-dated checks in terms of the directions of the Honorable Supreme Court in the matters mentioned above. It is hereby directed that the petitioner's electricity line shall be restored immediately upon payment of any shortfall in the security deposit. It is further directed that the line of the petitioner shall not further be disconnected, subject to the condition that the petitioner pays 50% of the arrears claimed under the impugned notice dated August 12, 2025 and furnishes a bank guarantee for the remaining 50% within a period of 3 months from date. In addition thereto, petitioner shall deposit post-dated check covering the balance 50% till submission of the bank guarantee within 7 days from date. Next page, my lord. Needless to mention, upon the petitioner furnishing the bank guarantee within the stipulated period of 3 months, the post-dated checks shall be returned to the petitioner. It is further directed that the petitioner shall not migrate to any other licensee company unless and until the petitioner complies with this order. And my lord, the writ petition was disposed of. So my lord, the point I'm trying to make is there is an uniformity with regard to the arrangement with all consumers, my lord, defaulting consumers in respect of control period 1718 or 1820. Therefore, my lord, I am, my lord, requesting your lordship of
There are
being...
18 to 20, there are 2 orders, one by the APTEL and one by Justice Chondo, this one. And regarding 17, 18, 19, 18, 19?
Regarding, my lord, 17, 18,
Only
my lord, 17, 18, there is an order of APTEL, there is order of division bench 10th February, there is order of 8th April. From 10th February, there was a challenge to Supreme Court,
Both
dismissed.
10th February,
And
yes.
from 8th April, again, my lord, no interference. This is the position, my lord. So
And
I am...
there was another challenge against the APTEL also, which failed.
Yes, previous one for control period 17-18.
17,
Yes. My lord, Mr. Mukherjee was leading me just in case he wants to add anything, my lord.
I'm 100% sure, my lord, my learned friend would have indicated, my lord, I'm getting bad with my estimation, my lord. I thought I'd be on time, my lord.
Well, it's all like this.
My lord, I'm sorry, my lord.
But I took the liberty of Mr. Mukherjee just in case it gets called to start, my lord.
Yes, yes.
No, I told him that he must, my lord, and this is the way, my lord, that my
Right,
lord,
right,
we'll- my
absolutely,
lord,
absolutely.
I can't be there, my lord, for every matter that I'm engaged. My lord,
So that is whatever.
yes, and my lord, your lordships would have noticed that whenever the issue, my lord, about, my lord, the challenge to tariff came up,
Yes.
my lord, first was, my lord, 17-18 was pending, my lord, before your lordship, so your lordship, my lord, the matter got adjourned because the issue, my lord, the main matter was pending before your lordship. My lord, 1780 needed to be decided first. That your lordships, my lord, struck down the challenge. It went to, my lord, the appeal court. Then, my lord, again the matters got, my lord, adjourned because, my lord, the matter was pending before the appellate court, my lord, because it would have a bearing here. That is still pending. The challenge to the tariff is still pending. And, my lord, initially when your lordships passed the order that, my lord, no coercive steps, my lord, that was, my lord, the order which was operating in our division bench. Then, my lord, came aptel orders. Then, my lord, when we issued disconnection notices, my lord, your lordship said, sorry, aptel you are not issuing disconnection. Everybody has to be treated correctly. So your lordship stayed, my lord, the disconnection notices. Then, my lord, we went and sought, because the matter was before the division bench by then, we went and said, kindly, after these orders which are being passed, particularly that earlier in rem order, my lord, which got, my lord, altered, my lord, and the matter went up to the Supreme Court. Supreme Court formula was 50% cash, 50% bank guarantee. That's what was followed. And then our division bench added, when we said, look, these people have enjoyed this interim order and have now migrated to others. How am I going to at all realize these? And because the true-up exercise is also on. My lord, so, my lord, really, my lord, the books of DVC today, my lord, would show, my lord, it's insolvent, my lord, in effect. And now, my lord, true-up as far as this is concerned, my lord, is also done. My lord, January. So, my lord, we are facing this problem. That's one. These are, my lord, also subsequent events to ask for a modification.
And you are continuing the undue hardship also,
Correct.
as
Yes.
considered by one.
Correct.
Connected consumers, item number 18 also.
My lord, these are for, my lord, the consumers who are still connected. My lord, there's a series, my lord, who have run away. My lord, where, my lord, we have another application.
Only distinction.
That's
is
item
100%.
18, my lord. There, my lord, there we've asked for, my lord, entirety, my lord, to be, my lord. Because they enjoyed the benefit of a court order, my lord.
They've migrated now.
Yes.
আমি enforce করবো order পেয়ে গেলে
My lord, I can, my lord, that's different, my lord. They are, my
But
lord.
that is also covered by these matters. 18 is 14 to
Yes,
36.
it's covered.
Yes.
So only in 18 that.
18, only 18.
No, there are
My lord, I'll give you a lordship.
আমরা 18 আছে
My lord, I'm in 18. My lord, there are, my lord, six, my lord, matters. There are 16, 18, 19, 20, 24, and 29. And my lord, rest up to 36, my lord, are, my lord, who are connected, and my lord, are enjoying, my lord, an unconditional order.
So you are both of you are appearing in the disconnected matters.
14 and 18.
One disconnection, one non-disconnection.
That's unfair, but yes.
So covered both.
I'm not complaining, my lord. It's not fair, my lord, to appear, my lord, in all. My lord.
No, very good. Yes, sir. You are in 18.
No, Lord, I am in 30.
30.
Lord,
So you have not yet disconnected, not yet shifted.
not only disconnected, I am one of the Lord prime customers of DVC, and Lord, I have remained Lord with DVC for Lord more than a decade now. Now, Lord, the issue is Lord not really connected to Lord payment, non-payment, securing, and all that issues. Lord, 2017 and 18. It's the control period which was under challenge. The contention was that under the Electricity Act, the control period can't be for a period of 1 year. It has to be more because of the provision. Your lordships negated that argument. The matter is pending before the division bench. Now, Lord, for the next period, there has been an assessment between 2018-19 and 19-20 for two period. This control period of 2 years. This is again under challenge. But Lord, the issue today is that Lord, before this, all these matters, your lordship has decided one other matter for the period 2006 to 9. 6 to 9? Where your lordship said that the delayed payment surcharge can't be imposed till the tariff comes into play. And Lord, for that period, there was a direction on DVC to refund this amount. DVC has preferred an appeal without a stay. That matter is pending. Now, Lord, today the issue is, insofar as my client is concerned, the raised bill shows 20 crores as GPS.
Roughly, I'm not really, my lord, I'm on the figure. I'm saying that we have substantial amount to recover, which I want to place on affidavit, because, my lord, this is a time where, my lord, I can always ask for set off. The amount that I am entitled to under order of court, I can always, my lord, ask for set off.
DPS was set aside by me.
Yes, lordship.
But that was challenged. That is under challenge.
That is under challenge in the appeal court without any stay. For the last 2 years, without any stay. And this is not a money which is my money, which is lying with DVC.
That logic is applicable to all of these respondents, all of these petitioners.
I am not aware about the others. Lord, I can talk about only Surjo Alloy, because, Lord, I am representing Surjo Alloy. And, Lord, I can file an affidavit placing on record that order, and, Lord, also the bills that has been raised from time to time.
Surjo Alloy is 30.
Item 30, item number 30. I am only, Lord, addressing your lordship with regard to item number 30.
The others have been served. All have been served. The respondents. All have been served. Respondents.
So far as 30 is concerned, Lord, I am willing to give an undertaking also that, Lord, I have no intention to go out of DVC. I have been a dedicated customer. I'll remain a dedicated customer till your lordship decides the issue.
Very well.
Now, Lord, the question is of equity that my learned friend was arguing, that Appel has passed certain order.
You have a set of point also.
I have a point of
that is for a different period, 2006 to 9.
6 to 9. But, Lord, this has accrued to you by reason of an order passed by your lordship. So, Lord, that is the reason why principally I said that, Lord, I want to file an affidavit. I want to file an affidavit, Lord, raising this point before your lordship. All right. Now, Lord, with the other point is, of course, Lord, the payment and Lord, bank guarantee. This is, I am saying that I need to ask for set off for this period.
But what about the other period?
But this period.
This period,
18 because
what about the other arguments?
I am already paying, Lord, whatever the current dues are. I am paying. It is only, Lord, adjustment of payment for the arrears.
So your special point is that you are entitled to set off in the sense that
yes.
So
far as
order to that.
1718 is concerned, I have complied with the order of court. I have paid, Lord, 50%, and, Lord, I have secured, Lord, 50% by bank guarantee.
Oh, okay.
So, Lord, 1718, their arrears have been taken care of.
Then these applications are filed for whom?
For 1820, 18 to 1819, 1920.
Right.
And there, Lord, I did not exercise my power of set off. I did not. I paid, Lord, the money which was payable, 50%, and, Lord, I have given a bank guarantee also for 50%.
But if you did that in that, I mean, you did not take this point despite being...
I did not at that stage. But, Lord, my right has not gone away because the litigations are pending. Today, Lord, we are at a stage, the DVC can adjust the money. The money is lying with them. DVC can adjust the money. I just wish to place on affidavit.
If that is due to you, then who is to pay to whom? If that is set off?
That is set off, then, Lord,
they have to pay to you.
To the extent of that adjustment.
Not that much.
No, that to the extent of the adjustment that I am.
If the adjustment is made, then the DVC has to pay to you.
No, DVC has
till
to
the balance is above. You have to pay more.
No, I don't think I will.
If 50% is given and bank guarantee regarding the rest 50, that 50% is more than 20 crores or whatever is due from them.
That 50% will cover the money that is lying with them. I'll not have to do an exercise
like the tenant getting an eviction against the landlord. gives you the connection and pays you.
Lord, I can place that on affidavit. I can place the calculations also on affidavit because these calculations will come from DVC's bill.
So insofar as you are concerned, at best, for the present, before affidavits, you will not migrate. That is one aspect of the matter.
Yes. And Lord, I come back.
And if 50% covers your amount,
yes,
the rest 50% you can put in bank guarantee and this PDC bank guarantee, whatever format is. I'll copy paste from that this previous set.
Post-dated checks we will give. Because, Lord, the 50% for the 50% amount, we'll give a post-dated checks. I mean, like a monthly check which
So
was
the
the
arrangement is bank guarantee
or
till bank guarantee is given post-dated check.
post-dated check.
Post-dated checks may, I mean, ultimately they're not so sure. If it's a bank guarantee, it's a bank's guarantee.
Kindly give me 1 minute. So কি করবে bank guarantee দিয়ে
একটু টাইম লাগবে স্যার মানে এক্ষুনি আমরা একটা এত বড় অ্যামাউন্ট 30-40 ক্রোজে হবে 30 ক্রোজে দিয়েছি এক্ষুনি দিয়েছি 32 ক্রোজ দিয়েছি
I believe
What will be the dates of the post-dated checks?
every month
Everyone says post-dated checks, but this was apparently 7 days to cover that period before they give the bank guarantee.
I am told that 50% we can not pay.
Achha, you will pay.
By
getting the
bank guarantee. Oh, sorry. By bank guarantee. The bank always they bank guarantee.
So then the same arrangement as them within 7 days, PDC within 7 days till bank guarantee is given and then bank guarantee.
Very well.
bank guarantee 6 months লাগবে
Very, very. Because the other 50%, yes, you.
I'll let me
set off.
come back with an affidavit.
Mr. Chakraborty is appearing with you. You are appearing in all the matters.
no মানে some
Only 30.
no there are other matters also
So what is your argument on the? Mr. Court is not taking any further responsibility.
I am briefed only in attempt that I really don't know the facts of the other matter.
HR is what the bottom well 29 is one of the consumer which has migrated
You are appearing in which matters? Give a list to me. It will be proportional to that. At a cow's din.
well, item number 29 I'm appearing which is
This is তোমার এগুলো
That will not be sufficient.
1431
বলে কি ভোটারের ইয়ে নাকি?
in addition to
কি ওগুলো ভোটারের ভোটারের কোথেকে কাগজের কিসের থেকে এসছে? ভোটার স্লিপ নাকি?
এইটা কি আছে
কোথেকে জোগাড় করেছেন? আমরাই তো জোগাড় করেছি। That is insufficient. That slip.
28, 29.
well, that was additional I was not appearing
My lord, maybe my learned friend is feeling embarrassed. My lord, there's so many.
No difficult.
well, the
There's a
issue is,
tendency among clients to brief the same person. If I mean, you are acquainted with this branch of the
not acquainted
this branch of the orders, I should say.
My lord, more than acquainted, my lord, with this.
He's the architect of many of the woes of
Yes.
DVC.
Yes.
Yes, Mr. Chakraborty, what is your argument on this? 50-50. It seems to be universally followed. So why not me? I feel lonely now. I mean, so everybody else is following. I'm left behind.
there are facts man I cannot improve on the fact there are consumers who has left like item number 29
Yes. No, migration, yes, it's a
But there are
absolutely appeals to the logic also.
no but there are no current dues because all has been secured
Current dues, nobody is eligible.
no, recovered from my security deposit all
Then it's all the more necessary for it to bind you. It had to be realized from your security deposit you're not
current
paying.
dues no current dues have been secured but there that's why I said they have been
Current and dues as
well, only the remain is well, the HR is for
you're paying the current amounts for
I have
current consumption.
well, I have migrated once I have migrated to another license
Oh,
so current dues has
then
been
you have to pay 100%.
not kind of do today my lord they have started proceedings under NCLT
Maybe.
my lord kind just
That was precisely what we were apprehending.
no they have started DVC has started
Oh, achha, DVC has started.
it is not by other kindly consider that submission was made that we are exposed to IBC it is on the verge despite there being orders of this court but they have initiated proceedings under NCLT
Not IBC.
IBC NCLT yes
Oh, achha, IBC.
they have,
Yes, sir.
DVC has initiated proceedings
Then they are seeking a double remedy. I mean,
well, not only they have also well, in some cases they have invoked arbitration clause mediation where the arbitration is not there they have invoked because they know well, this
no, but
liability
they can do that. I mean, what's the part?
Question is liability has not attended finality these are all interim management whatever the orders my lord
But this is universal. Supreme Court has done it in 2 cases.
today my lord question is my lord today like HR is part my lord, although you have migrated if my lord calculation is get I am going to get a refund what happened was my lord kindly consider this for the period 6 to 9 and 9 to 13 while luckily Mr. Mukherjee was appearing for the consumers he cannot say
Don't
anything
put your hand on his shoulder. He is much senior.
well, I tender
in your
Sorry, sir.
passion, you don't do things which you will be
I take an
regretting.
apology to the court and Mr. Mukherjee also. Sorry.
Yes, you're trying to reach his feet. Try to do that. It would be very interesting to see you go down that far. Physically, it will be difficult for you. So yes, what is the distinguishing feature? Why should you be special? I mean, everybody is. All the forums have done it, up to Supreme Court, Division Bench, Appeal.
But for consumers, there are consumers for both.
No, there is a logic behind what Mr. Mukherjee and Mr. Dotto have said. That is, the premise of my granting this interim order was that 17-18, that challenge was pending, similar challenge.
Yes.
So if that is the premise, if this is being done there, why shouldn't a similar thing be done?
Would be for HR Ispat also. HR Ispat also, who has migrated, there will be a set off. There will be a set off where.
Which item?
29.
29, 30 setups.
30. What happened? The question, just there.
What about the rest?
I'm telling. 2006, that period, DPS, very interesting. 2006-9, all consumers were entitled to refund. Admitted positions, my lord had recorded in its my lord's order.
No, Mr. Chakraborty, even if you are entitled to set off, that cannot exceed, might not exceed the 50%.
No, what happened was there was a direction for interest. They had set off my interest component with the DPS.
What would be the amount?
It has to be, exercise has to be gone into. Today, my lord, kindly consider this. My lord, these orders have been there
50%, at least 50% you have to secure.
But 50%.
By bank guarantee PDC.
We will give 50%.
In those two matters only, where you are claiming set off. For that DPS for 2006 to 9.
Most of the cases.
Subject to hearing them. I mean, just I'm opening my mind.
Most of the cases, that has to be, because I have to put this on record. I have to put this all.
29-30, yes. But regarding the rest, if there was no challenge to the 2006-9, then you cannot get that advantage. There is no question of any set off.
No, if that is so, obviously. And I'll be honest, in HR Ispat, there is, we had approached this honorable court after Lordship's direction, and there is, as DVC was not enforcing any DPS, so the court has said direction for affidavit. So there is no interim order also. But there is a set off. If Lordship's order is to be taken into consideration, I am entitled to refund. And there is
that order is under challenge, although no stay order is there.
No, last 3 years there is no stay. They have never paid.
Till the arguments of Mr. Court, it was 2 years. Within 2 minutes, it has become 3.
2022, the appeals were preferred. These are batches of matters of 2023. Those were 2020.
Different batches, yes. What about the other matters? Why shouldn't you pay up? And whoever has left, migrated, they should pay the 100%. The formula is, Mr. Chakraborty, who have migrated, those who have migrated, if they have a set of claim, if set of claim is there, 50% will be kept in abeyance for the time being. I'm speaking aloud, thinking aloud. Rest 50% bank guarantee. In the meantime, PDC. Those who have already migrated, then we are looking at a scenario where it's 100% should be paid. So then 50% you have to pay right now.
But 100% at a time, I don't think it is possible for any of the companies.
No, we are not directing you to do that, but 50% you have to pay. 100% will give you some time. Till then, whatever mode bank guarantee or something like that. 50% you will have to pay. That was the direction also. All these authorities.
Yes, ma'am.
Within 3 months. 3 months is sufficient.
3 months?
3 months, yes.
The Supreme Court ultimately has extended 6 months. After 50%.
Supreme Court will extend in this matter also. You have not paid during the entire this 3 months plus 6 months. Because you did not have that. They did not have the advantage of this.
50% payment and 50% bank guarantee period was extended. Supreme Court has extended. And my lord,
so 29-30 you have a set of claim.
31, my lord.
And who have migrated? Which ones you have
At least a chapter original set. Appellate set list
Lord, item 16, 18, 19, 20,
yes,
24,
yes,
and my lord 29.
They have migrated?
Yes.
At 29, I submitted migrated. I had submitted I migrated.
What have you submitted?
I had migrated HR Ispat. I said it is one of the consumers which has.
When did you say to whom?
Lordship. I submitted before Lordship.
Now today?
Yes.
Yes, who is denying that?
Oh, no.
It's not about you only, Mr. It's about the arguments, the law. There are many other things.
Sir, 28 of migrate করেছে 28 paid in security 28 paid 28 has paid
30 has not migrated. No, Mr. Kaur said that he would not.
মিডসিলটা কত নম্বর 31 মানে 31 আমাদের টোটাল ডিউ কত এটা 31 এর ডিউটা কত এটা কতগুলো শূন্য এটা কত টাকা হবে এই অঙ্কে
11 crore
11 crores মিডসিলে কত টাকা বাকি আছে আজকে যেটা সাপ্লিমেন্টারিতে দিল সেটা
4.37 crore 4.37.
So the rule of thumb is, Mr. Chakraborty, if you have migrated, then if you have not migrated, then it's 50% that formula, whatever has been done in the other matters. 50% within 3 months and 50% first PDC, then bank guarantee, whatever. And if you have migrated, then you have to pay 100% subject to that set of point. No PDC.
এনার্জি বিল আছে এটা ক্লিয়ার আছে মানে for Metsil I have been told my lord which is item number 31 my lord the security deposit is about 11 crores 30. And the 4 crores is the 18 area dues of 1820
Security deposit is 30 crores
30 crores কোথায় আছে
29 and 30 you have a set of claim, we can consider that.
30 crores.
My lord, Metsil, my lord.
Metsil is 31.
31. 30 crores is the security deposit. And my 31, and they have said my energy bill, which my instruction has been paid, that is 11 crores. ADR dues is 4 crores. If I shift also, I'm entitled to 15 crores from them on the face of it. My 30 crores is a security deposit, kindly see.
Keep it with you.
30 crores is a security deposit. And they have in the supplementary affidavit as
so you say nothing would be due to them
Metsil, nothing. And Metsil, if I'm not wrong, 6-9 একটা কোনো মামলা pending আছে Metsil 6-9 and if I'm not wrong 6-9 also is pending for Metsil. If
Which
I'm
one?
not, for Metsil 31 it's pending but I'm not sure
But that security was subject to correction, my lord. It is against the consumption of against the current dues, my lord. My lord, I don't know what would be his consumption for the current month.
But if I said but I think
let
but
them secure the amount, my lord. If there is any excess security upon amount, my lord, they had also asked for disconnection, my lord. My lord, I have also disclosed.
That's why I said, but I have said I want to if I want to migrate today, DVC is not very affected. 4 crores is the total.
They have a different equation. If they disconnect today, then there's no scope of your retaining the security deposit or having any apprehension on that.
I'm entitled to refund.
I'll return, my lord. But today, my lord, till the date of disconnection, I am not aware what are the.
If they've applied for disconnection, which you are also saying,
yes, my
then also if they disconnect today, then also they say money will flow from you to them.
My lord, I don't know, my lord. There are two.
It's reverse osmosis sort of.
My lord, there are two bills which will be outstanding. One is of the previous month, and
we want to have the dues. Otherwise, it is very difficult at this stage to pass any order on that.
No,
at least regarding Metsil.
Point set off, my lord. I was only addressing on the point of set off, my lord. What they are saying, my lord, they are saying that my excess security is lying with them. My contention is, my lord, those are against the current dues, my lord. The current
that will cover 100% as per them.
That is against the current dues, my lord. My current consumption, they're still consuming. Till the time, my lord,
you don't understand. They won't be still consuming if their disconnection application is allowed.
Time they are.
If we cannot adopt a dog in the manger policy, we restrain them from migrating, and they have dues, and you will go on adjusting that security amount.
My lord. But if
at the same time you saying that security amount is lying with that security amount is against current. If they want to disconnect, then we'll permit them to disconnect, and that security dues will be adjusted.
Madam, can you clarify that they will pay off the entire dues?
No, but we don't know unless we get the actual figures. We won't be able to adjudicate at this point of time. Won't be able to.
I was just humbly beseeching my lord. My lord, if my lord makes an observation that subject to payment of all the dues, they can leave.
No, we'll take affidavits from there and then decide. Whatever interim order is there, is there. If they migrate in the meantime, then it inures to your benefit in the sense that you have that security deposit which will set off their amount. We need not restrain them from migrating.
I am not asking my lord, restraining them from migrating, but
That is also one of the prayers made by.
my lord, my lord, that's the subsequent cause of action, my lord, which they had pleaded, my lord, by a subsequent letter, my lord, they had asked for disconnection, my lord. And I was humbly beseeching, my lord, will kindly secure the interest of DVC, and my lord, thereafter they can migrate, my lord. And that's all, my lord.
It's already secured as far as Metsil is concerned. That is what they're saying.
Yes, ma'am. Kindly see, my lord. Kindly see.
They say that you have more security than is due to them.
30 crores is a security. Okay. They can-
Than is due from them to you.
30 crores is a security.
They are saying that you have in your hands more security from them than they owe you. That is the difficulty. So without getting the figures, we cannot pass any direction on them right now. Migrating will be counterproductive for them. Restraining them from migrating would be counterproductive. You have the security. If they migrate today, you have that security in your hand.
No, my lord, we'll release immediately, my lord, subject to clearance.
They say that will be adjusted. If adjusted, that will be more than what is due to them. So why ask them to pay 50% and ask you to return the security? That would be a futile exercise.
It is their letter which says the dues is about 15.
Anyway, so let us say have the numbers. So instead of we'll pass a similar order, Mr. Chakraborty, and I'm proposing to do that subject to what they say. Now, in 16, 18, 19, 20, 24, there is no set of claim, nothing. You have already migrated.
My lord, I was the advocate on record, my lord, in all those matters which Mr. Mukherjee has placed that they have migrated, my lord. Since 2023, I have no instructions. I don't know whether they have migrated also or not, despite.
But they know, you know, versus you not knowing.
My lord, because they are the my lord.
They would know best.
Yes, my lord.
If you were the advocate on record and if you are not the advocate on record now, how do you know?
My lord, for all intents and purposes, my lord, on paper I am, but I have written them communications to give me instructions. I have not received any instructions from them, despite writing them several letters, my lord, and those are 16, 18, 19, my lord, if my lord would note, my lord.
Then regarding the payment, we can withhold it subject to hearing them again. 50%, about 50% you have to secure at least by bank guarantee. Everybody has to right now.
My lord,
what about that?
My lord, the clients that I have no instructions from, my lord, I cannot place anything on their behalf, my lord.
You also cannot deny that they migrate. If they say,
my lord, I'm not.
I'll record their submission that they migrate.
Absolutely, my lord. I'm just saying, my lord, I don't have instructions and I'm in no place to make submissions on their behalf.
Fair enough. So 16, 18, 19, 20, 24?
My lord, also 21. My lord, I am seeing the ones I don't have instructions from.
21 has migrated.
My lord,
no, this is about the migration.
Achha, migration, my lord, DVC would be in a better position to answer that.
So these people have migrated already. 29 has also migrated. Very well. So regarding the rest who have not migrated, restrained from migrating, they pay 50% within 3 months.
28 days.
28 has been secured. I'm appealing for 28. 28, both the periods have been secured.
Secured means?
They have paid. Or bank guarantee or paid for something. But their DVC do not have any.
Don't understand.
No. DVC has not filed any application for vacation. As per my. So, 28,
there's no application, my lord. I'll tell your lordship, my lord, in the matters where there's no application.
Yes, please do that.
Yes, my lord, that's 15, 26, 28,
yes,
and 33. Now, my lord, over and above that, my lord, in item 27, my lord, the company has gone into liquidation. Therefore, my lord, we have not even made an application. So that's a additional, my lord, 5 matters where we've not made applications.
So no question of passing in order.
Any orders on those?
What about 1 to 14? They have not migrated.
1 to 14.
My lord, those are not our matters. My lord, 14 onward.
Start from 14. What about 14?
My lord, 14 is, my lord, not paid. They are connected, not paid.
There, we have paid.
So let us have the numbers. 14 connected, not paid.
Not paid.
17. What about 17?
My lord, same. Current dues not.
Like
my lord,
14. Like 14.
Like 14. My lord, current dues are being paid. My lord, no cash.
Similar for 21, 22, and 23 also.
And 25.
And 25. What about 26?
My lord, 30 is, my lord, Mr. Kaur's client.
No, 26. 26 and 27.
My lord, it's no application, I indicated, my lord. No
Oh,
application.
I'm sorry.
15,
Yes,
26,
26,
28,
29.
33, no application.
Right. So then 29, Mr. Chakraborty, 30, Mr. Kaur, 31 and 32.
My lord, 31, my lord, I believe, my lord, is Metsil, my lord, submission, taito. So,
Man, I'm confused with so many names.
It happens when you become busy.
my lord, 30, 31, my lord, out of the normal, my lord, who remain connected and have not provided any security, my lord, 30 and 31 are, my lord, the ones who are claiming set off.
Set off, right. 29, Mr.
And 29 is a disconnected,
But
my
set
lord,
off.
who has, my lord, migrated, my lord, is, my lord, my lord, migration list is 16, 18, 19,
20, 24, 29.
29. And there, my lord, they say, my lord, that they are entitled to, my lord, a set off in 29.
And 32 to 34.
My lord, they
33
fall
is
under.
covered. 33 is covered. They have no vacating application.
My lord, 32, no instructions, my lord.
No instruction. That's your problem. No instruction means we have to pass interim orders.
Yes, ma'am.
32, 34 and 35.
35 and 36 are also the same.
35 I appeal.
Oh, এতক্ষণ চুপ ছিলে।
No, we are not taking an appearance list.
No.
It's about those who have not migrated. So very well.
35 migrate করেছে 35 has not migrated.
But has no
Not
security.
migrated. That
Not
is what it is.
migrated.
Not migrated. So, but they, apart from then 31, 29 has a set of claim. 30 has a set of claim.
Yes.
31 is Metsil.
Metsil as a
So more than you have a counter claim. Well, apart from 29, 30 and 31, those who have migrated, we can ask them to pay 100% would be very difficult to implement. I mean, we don't know.
No, your lordships can, my lord, direct.
50% right now,
my lord,
within 3
50.
months.
Yes, my lord.
Then similar direction.
Yes, and my lord, the balance, my lord, thereafter in installments, your lordships can provide that. Another 3 months or 6 months, my lord, whatever.
Yeah, so that can be universal for all.
All.
Those who have migrated and not migrated.
Yes, the first portion, my lord. 50% cash.
50% cash within 3 months.
Yes.
And rest 50%.
My lord, those who have not migrated, my lord, bank guarantee. Those who migrated, my lord, should pay.
Yes. But why not bank guarantee for them also? Bank guarantee is as good as money. So bank guarantee because.
My lord, I can't show it in my books, my lord. That's the problem.
No.
My lord, a true up exercise is already over, my lord. My lord, and my lord, your lordships aware, my lord.
Interrupting Mr. Mukherjee, my lord, sorry, sir.
You,
there is a 2 days back, Aptel has passed an order in favor of the consumers. If that calculations, my lord, just 2 days back, it has been passed by Aptel. If my lord, that calculation is on paper, my lord, the experts have been asked to, possibly there is a refund to all consumers across board, all consumers.
Anyway, at present we have only these orders.
We cannot have that because.
So 50%, what is the difficulty? Because that should apply across the board.
Let them deposit in.
If they put in, no, bank guarantee will suffice.
My lord, kindly see, my lord, they've taken advantage, my lord, of court orders.
Maybe, but Mr. Mukherjee, there was no restraint order. They might have migrated, might not have been purely to avoid the liabilities. Maybe for other reasons also. We are not sure on that. But bank guarantee is as good as, because whatever you are saying, you cannot reflect it in your record. That applies to the others also who have not migrated. So we'll put them on similar terms. Just because they have migrated, we cannot penalize them unnecessarily. But those who have not, then we can restrain them.
Okay, kindly do that.
So, Mr. Chakraborty, your passing orders regarding 29 and 30. 29, 30 and 31.
Yes.
We are directing 31, you are claiming more than 30 and 29, Mr. Kaur. Can we just ask you to put in that 50% within 3 months payment? No, you have a set of it.
Yeah, bank guarantee, Lord.
So then bank guarantee for the time being.
Yes. And Lord, for the balance, Lord, may I file an affidavit, Lord?
Yes, that will direct. We'll direct affidavits across the board, but for these people, other people who don't have a set of claim as such, or no instruction, for them, we'll direct affidavits, but we'll pass the payment direction all the same.
They have not
Right.
reported that they have not
একটা অর্ডার আচ্ছা আমি না আমি আইটেম নাম্বার বলে বলবো যেখানে যেখানে আইটেম নাম্বার আছে দেখে ডব্লিউপিএ নাম্বার করে নিতে হবে ওটা। হ্যাঁ, কারণ এখানে আমি আইটেম নাম্বার দিয়ে করেছি, তো আমি বলবো আইটেম নাম্বার সাথে সাথে তুমি আইটেম নাম্বারটাই লিখবে, ট্রান্সলেট করে দেবে ইয়েতে, ওটা টাইম লাগবে, করবে। In the present set of matters, interim orders were passed restraining the DVC from realizing the arrear dues for power consumption for the period 2018 to 20.
Yes, 2018 to
19 and
20.
For the periods 2018-2019 and 2019-2020. Full of next para, learned senior counsel appearing for the applicants in the vacating applications contends that several authorities have passed order to the effect that the stay order was made conditional on 50% of the arrears claimed under the impugned notice was directed to be paid within 3 months from the date of the interim order, grant of interim order. In addition thereto, post dated checks covering the balance 50% was directed to be paid within 7 days from that date, subject to bank guarantees being furnished for the rest 50% within 3 months. Full stop. Upon the furnishing of the bank guarantee, the post dated checks were to be returned to the respective writ petitioners. Full stop. Next para, learned senior counsel places reliance on orders to that effect passed by the appellate authority. What is the full appellate tribunal for electricity within bracket APTEL bracket closed in respect of the period 2017-2018 and 2018-2020. Full stop. Similar orders were also passed by APTEL for the period 2018 to 2019 and 2019 to 2020. Full stop. Insofar as the period 2017 to 2018 and 2018 to 2019 is concerned, a division bench of this court, while hearing a bunch of challenges to orders passed by the writ courts, also passed interim orders in similar tune, which was upheld by the Supreme Court, by extending the time for putting in the deposits and the bank guarantees. For sub next para, learned senior counsel points out that the very premise of grant of stay in connection with the present set of writ petitions was the pendency of a similar challenge in respect of the period 2017 to 2018 and 2018 to 2019. As such, it is argued that the interim orders and the arrangement made in connection therewith in respect of different matters before different fora in respect of the said period should have a material bearing on the present writ petitions as well. Similar orders are sought for in respect of the present vacating applications. Next para, learned senior counsel further points out that taking undue advantage of the interim order passed by this court, some of the consumers who have preferred writ petitions have been migrating to other distribution companies. Is it transmission company or distribution? Distribution companies. Next para, to prevent the same, it is pointed out, the different fora as referred to above have also been passing orders restraining such consumers from migrating to other distribution companies in the interregnum. Full stop. Next para, it is suggested that for consumers who have already migrated, comma, the direction, the modification to the impugned order of stay should be to the effect that the stay order ought to be vacated and or the entire amount of dues ought to be directed to be paid, subject to the outcome of the writ petitions. Full stop. Next para, learned senior counsel appearing for the consumer in item number 30 submits that the said entity is one of the most loyal consumers of the DVC and has no intention to migrate to some other distribution company. Full stop. Next para, insofar as the dues claimed by the DVC is concerned, comma, it is submitted that the said consumer has a claim of set-off against the DVC in lieu of payables in respect of directions passed by the writ court with regard to the period between 2006 and 2009. Full stop. Next para, a similar submission is made in respect of item number 29 as well by learned counsel appearing for the concerned consumer. Full stop. Insofar as item 31 is concerned, comma, learned counsel appearing for the writ petitioner stroke consumer submits that taking into consideration the security deposit lying with the DVC, comma, the even if the entire dues which have been stuck up in view of the stay order passed by this court were to be paid, comma, the same would be less than the amount of such security already deposited by the writ petitioner in the said matter. Full stop. Next para, such contention is, comma, of course, comma, controversies by learned counsel for the DVC in item number 31. Full stop. You are not in 31, Mr. Mukherjee. You are not in 31. 31, learned counsel.
I'm not there in 30, 31, 29, my lord. I'm not there.
So therefore, senior is replaced by counsel.
Item number 29 is migrated, my lord. My lord, recorded possibly 29 I have submitted, it is migrated. HR is for.
No. No. We are now on set off, not on migration. So next para, it is submitted by the vacating applicants that the writ petitioners in item number 16, 18, 19, 20, 24 and 29, the consumers, the writ petitioners have already migrated to other distribution companies, thereby putting the DVC to the peril of non-realization of the dues, if ultimately the writ petitions go in favor of the DVC, are decided in favor of the DVC. Full stop. Next para, in respect of item numbers 15, 26, 27, 28 and 33, no vacating application has been filed and, as such, there is no occasion for this court to decide on the issues argued above. Full stop. Next para, upon considering the orders passed in similar tune by the division bench of this court, as affirmed by the Supreme Court in respect of the period 2017 to 2018 and 2018 to 2019, which the pending appeals in respect of which period was the very premise of the grant of interim order by this court at the inception, it transpires that it has been universally decided by all fora, including the APTEL, that the arrangement as indicated by the vacating applicants is to be maintained, to balance equities between the huge loss being suffered by the DVC, particularly reflected in the truing up process, TRUING-up process. And on the other hand, the predicament of the writ petitioners. Full stop. Next para, as such, this court is of the opinion that with regard to the writ petitioners, comma, in respect of which writ petitions, vacating applications has been filed, comma, there ought to be uniformity with the other similar persons, other similarly placed persons, comma, in respect of whom the orders indicated above has been passed by the appellate authority as well as the division bench and the Supreme Court. Full stop. Next para. Insofar as the writ petitioners which have not migrated in the meantime to other distribution companies, comma, to ensure that the DVC is not put at the risk of non-realization of their dues if ultimately the writ petitions are decided in their favor, comma, there ought to be an order of injunction restraining the writ petitioners from migrating to other distribution companies. Full stop. Insofar as those writ petitioners who have already migrated are concerned, comma, no useful purpose would be served in passing such restraint order. Full stop. However, comma, with regard to those writ petitioners, comma, the arrangement regarding payment by installments ought to be passed. Full stop. Thus, comma, in respect of item numbers 14, this is regarding the migration injunction. 14, 17,
But if your lordship permits, my lord, I can indicate, my lord.
yes, please. Otherwise, it will be very difficult.
14, 17,
14, 17, 21, 22,
21,
22,
22,
23,
23,
25.
25, 30, 31.
No, 30 has
30
not migrated. Yes, 30.
Yes.
30,
My lord, Mr.
31.
Kong said he will not migrate. My
But
lord.
still, we'll pass that injunction.
Yes,
We have
30,
recorded his bona fides.
yes,
Yes.
30, 31,
Yes.
32, 34, 35, and 36.
They have not migrated.
Not migrated.
For 31, we have applied for migration. I said,
এখনো করোনি।
We will injunct you. For the timing, we will injunct you. This will be ad interim till disposal of these applications, vacating applications.
টাকাটা এখনো দিচ্ছ না।
These orders are being passed till disposal of the vacating applications.
Yes.
We'll direct you to file affidavit in opposition in all the vacating applications. If you are satisfied that the balance is more on your side, then we'll leave that injunction. Till then, don't. আচ্ছা তাহলে লিখলে কিগুলো না বলে দিই একবার item numbers in respect of item numbers 14 17 21 22 23 25 31 32 34 comma 35 and 36 comma the writ petitioners shall remain restrained by an order of injunction from migrating to any other distribution company than the DVC during the for power consumption during pendency of the vacating applications, the respective their respective vacating applications. Full stop. Next para. The above writ petitioners as well as the writ petitioners in item numbers 16, 18, 19, 20, 24, and 30, no, 30 of claim set off, 29 has claim. And 24 is stop karo, comma, the writ petitioners shall pay 50% of the amount dues for the period, for the relevant period, that is 2018 to 2019 and 2019 to 2020, comma, within 3 months to the DVC. Full stop. Next para. Regarding the balance 50%, insofar as the balance 50% of such dues is concerned, comma, bank guarantees to cover the said 50% shall be furnished by the writ petitioners within 3 months from the date, full stop, next para. In the interregnum, comma, within 7 days, comma, post-dated checks to cover the said balance 50% shall be submitted by the writ petitioners to the DVC, shall be deposited by the writ petitioners with the DVC. Full stop. It is made clear that upon furnishing the bank guarantees as directed above for the balance 50%, comma, such post-dated checks shall be returned by the DVC to the respective writ petitioners who furnish such bank guarantee. Full stop. Next para. Insofar as the writ petitioners in items 29 and 30 are concerned, comma, 29 and 30 also similar orders. 29 and 30. 31 we are excluding for the time. You have a claim of set off.
Yes.
As a very well. 21 only 50%.
Yes. 50%.
Insofar as writ petition is in item 20 and 30 are concerned, comma.
29 and 30.
So 29 and 30 are concerned, comma. The writ petitioners shall pay 50% of the dues for the period 2018 to 2019 and 2019 to 2020 within 3 months to the DVC. Full stop. Further orders with regard to the balance 50% shall be passed at the time of disposal of the vacating applications. Full stop. The writ petitioner in item 31 shall, comma, for the time being, comma, furnish a bank guarantee of bank guarantee to the tune of 50% of the amount due for the period 2018 to 2019 and 2019 to 2020 within 3 months, and in the interregnum, comma, shall furnish post-dated checks to cover the said amount within 7 days. Full stop. Upon the bank guarantee being furnished, comma, the post-dated checks shall be returned to the writ petitioner. You will not have to pay that 50%, which the others are paying. Full stop. Next para. It is made clear that all the above payments and furnishing of bank guarantees, etc., shall be subject to the outcome of the vacating application. Full stop. The writ petitioners, that is the respondents in the vacating applications, shall file their respective affidavits in opposition by. Can you do it by within 1 week from the reopening?
Fortnight from
Fortnight. By November 14, 2025, full stop. Reply, if any, shall be filed by November 28, 2025, full stop. The applications shall be listed for, the vacating applications shall be listed for hearing in the monthly list of December 2025.
But may only request one thing.
Yes.
But only I'm concerned with item number 31.
31, yes.
But if there's supplementary affidavit, just they are filed, just one letter, just one letter thereafter. Their supplementary affidavit DVC has filed. Just one letter.
Letter?
Page 44. Just kindly consider just page 44.
Article adequate supplementary affidavit filed today be kept on record. Supplementary affidavits along with the affidavits of service filed today be kept on. You have not yet filed. You will file.
One filed, one or others are. One we have already filed, others are here.
One you have filed. সেটা কোথায়?
The first matter which was moved, my lord, with Aptel's order, my lord.
Oh, achha.
11th August. My
yes,
lord.
yes. Yes, got it. Page.
My lord, kindly have a look at Metzel's affidavit. I think that's,
Metzel affidavit.
my lord, I don't know what the contents of that.
Yes. Which page?
Page 44, my lord. My lord, their DVC is writing to us. Thank you for your communication regarding the proposed surrender of your power connection. Thereafter, they write in the next page, whatever the liability is, they have written. Kindly see, this is the 15 crores. And I'm showing the bill here and now. Security deposit is 30. But the difficulty is I have already proposed, I have made my 15 crores and 30 crores is with them. But equity has to be, balance of convenience has to be in this matter. 30 crores is security deposit. 30 crores.
And what would be their amount? 50%?
15 crores. That is what they have written. 15 crores something. 45 next page. 15 crores, 83 lakhs. And 30 crores is lying with them. My area is only 4 crores 63. 4 crores 63 and current dues 11 crores 17 lakhs. And outstanding is total 15 crores 83. On the face of it, it's something on the face. This is the bill, security deposit of 30 crores.
Yes, what do you say to that? Then we will not pass this order regarding 31.
I will kindly appreciate, this does not include the current consumption charges.
This is their
for
own
2 months.
This is their own
This
dues.
is
I have
not their-
already written. They have also
The
accepted.
current consumption
If
charges
today, if today I have not come to court, I would have got this money back. If I have not come to this court,
Then we are not passing any injunction order. Let them disconnect. Then they'll be entitled to the entire security deposit today. They've already applied for disconnection. Disconnect.
Surrendered, I have applied for, and let them adjust this money and return.
আচ্ছা যেখানে 31টা যেখানে ইউজ করেছি না 31 কথাটা insofar as item 31 is concerned যেখানে আছে সেই 31 এর জায়গাগুলো বাদ দিয়ে দেবে 31 কে বাদ দিয়ে দেবে এবার আমি 31 নিয়ে অর্ডার পাস করছি এটা একটু টাইম কনজিউমিং হবে টাইম নিয়ে করো insofar as item number 31 is concerned comma by placing reliance on the supplementary affidavit filed by the DVC itself comma learned counsel for the writ petitioner points out that the writ petitioner has already applied for disconnection of electricity. First up, the DVC has acceded to that by their email as annexed at page 44 to 45 of the supplemented affidavit, comma, even from which it is evident that the total outstanding dues from the writ petitioner as per the DVC is rupees 15,83,59,673 / whereas the security deposit already lying with the DVC comes to about rupees 30 crore. Full stop. Thus, comma, prima facie, comma, the amount lying with the DVC far exceeds the amount due from the writ petitioner, even if the writ petitioner loses the present writ petition. Full stop. Next para. Keeping in view such fact, comma, at this juncture, comma, no interim direction for payment is being passed on the writ petitioner in item number 31. Full stop. Since the writ petitioner has already applied for disconnection, comma, the DVC would be at liberty to disconnect the electricity supply of the writ petitioner, comma, subject to adjustment of the total outstanding dues as per the DVC, comma, which will be in turn, comma, subject to the outcome of the present vacating application and the writ petition. Regarding 31, that is an exception. The others.
May I? Sorry.
As regards 30,
yes,
Lord, my understanding was that we will put in Lord bank guarantee within a period of 3 months, and Lord the payment issue your Lordship will consider Lord, we pay Lord 50% and bank guarantee issue will your Lordship.
No, we are putting on a similar footing as them as the others.
No, your Lordships have directed that
We have directed to pay the bank guarantee. Putting the bank guarantee. Only the bank guarantee. So that remains. Yes.
My lord,
Mr.
may I-
Mukherjee.
yes, my lord. Only thing is, my lord, several places where your lordship said, my lord, 2017-18, lordships also added 18-19. The first
Oh.
control is only, my lord. So that might be a universal change which your lordship might have.
2017, it will be only.
It's 2017-18 is just that.
Oh,
And
oh.
wherever it's 18-19, it's 19-20.
Oh,
My lord, otherwise the order, my lord.
Yes, absolutely.
My lord, 7 places it's happened. I was counting.
Thank you. যেখানে 2017 থেকে শুরু করেছি ওটা শুধু 2017-18 হবে কথাটা বুঝতে পারছো কি বলছি কয়েক জায়গায় আমি বলছি 2017-18 আর 18-19 আবার কোথাও কোথাও বলছি 18-19 আর 19-20 যেখানে 2017 কথাটা পাবে শুধু 2017-2018 আর 2019-20 টা অ্যাড হবে না বা অন্য কিছু অ্যাড হবে না তাই 18-19 হবে না 2017 to 2018 যেখানে বলছি সেখানে শুধু 2017 to 2018 হবে আর অন্য জায়গাগুলো যেখানে 2018 to 2019 বলেছি তার সঙ্গে 19 to 20 মানে 18 যেখানে বলেছি সেখানে 20 পর্যন্ত থাকবে আর 17 যেখানে বলছি শুধু 18 পর্যন্তই থাকবে বুঝলে তো? ঠিক আছে।
And these arrangements, my lord, are all relating to the arrears only, because current is being realized by the.
Yes, we have not touched that. Because that was a part of that.
And my lord, all the orders made that a condition to enjoy, my lord, the stay. My lord, so
আচ্ছা একটা লাইন অ্যাড করে দাও। It is made clear that the stay order granted previously shall continue subject to the compliance of the above directions by the respective writ petitions.
obliged, lord. Chalo, chalo.
Pass over to the.
Pass over item number 13.
Yes, Mr. Sinal.
My lord, this is contempt application arising out of the
Yes.
order dated 18th April 2024.
Right.
The contention of the writ petitioner was that the publication of the particular NIT was not.
What was the page number again of that order?
49.
My lord, that is 41, annexure P1. Contention of the writ petitioner
Yes.
was that the following the provision made under the General Financial Rule 2017, the advertisement were not made, and it was submitted.
Oh, submitted that it was uploaded on the that
Yes.
portal,
Yes,
but they had not uploaded.
it was not uploaded because the authority is saying so. I am not saying so, my lord. That is at page 45.
That right to information.
Right to
Why should this be contempt, Mr. Sinal?
Yes.
At best, suppression of material fact.
Through the Milord, this is not only they have said so in their affidavit, Milord. The affidavit has already been exchanged and it is recorded by an order dated 7th. What is 7th?
This cannot be civil contempt. Civil contempt is a deliberate, willful, and deliberate violation of a court's order. This is not violation of any order. Either it could be perjury, but does not amount to the level of perjury that it will.
It is the
affect-
interference of the justice.
Then it will be
deliberate
criminal
system.
contempt. Then I have to draw a contempt rule and send it to the division bench. This is not of that stature.
Yes, Milord.
At best, suppression.
Milord, if this is the suppression, that is also, Milord, attracting the section 2C of the Contempt of Court Act 1971, Milord. And
how,
Milord? I am showing your lordship the affidavit first. Yes, yes, I know. Report in form of affidavit.
We have directed them to file a report also disclosing these facts only.
Yes.
So if they,
Milord, if that is not so, Milord.
if they don't file the report, they have not yet filed given any copy to you.
The report has been filed. That is at page 48 of my.
Oh, that also shows us.
Yes.
That is at page?
That is at page 48.
Page 40.
48.
Para
48.
6 is the relevant para.
And Milord, the para 6 is the relevant para. Here,
Yes, said.
Milord, I submit. That is at page 50.
Duly published in the portal, they have said.
Yes.
That
And Milord, the NIT speaks is different, Milord. NIT emphatically states that the e-procurement should be made through Inivida. That is not, Milord, Jim. That is at page 70.
They say also in the portal called Inivida.
Yes, Inivida.
The report.
The
report they say.
Inivida, but JEM, that is, Milord, JEM, it has not been published in JEM. That is the, Milord, the report.
No, they say that it was posted and duly published in the central public procurement portal.
But it is my information that
Photostat copy of something has also been annexed. Let us see what is that.
Yes.
Yes, it is there. Published. Page 53.
This is not, Milord, this is a false document.
You have not even alleged that it is a false document. You say that they had not uploaded,
Milord,
but they had stated that they had uploaded. But they show something.
Milord, this is a false document, Milord. Let them come and clarify the.
No, for that contempt does not lie.
Milord,
Perjury may lie. Contempt does not lie.
Yes, Milord, this is specifically interference of the.
No.
If this submission.
Where have you made the allegation that this is a false document?
In this competition.
Where? Which paragraph? They have produced the printout from the portal And you're relying on some vague information given by some authority.
I'm not on.
This is the best proof that it has been uploaded.
No, this
Informations are often wrong. If you take
this is
information,
actually
today an information was shown to me of our court, which says that Justice Sugata Mujumdar passed an order in long before his elevation.
Milord, this is not Milord. This is not the uploading system, Milord. If this has been uploading, Milord,
Where have you stated this is a false document?
Yes.
This is not contempt.
Yes, Milord. It is required to be mentioned in this context. That is page 7, paragraph 7, page 18.
Yes.
Milord, although Milord 1, 2, 3,
File a
4,
report.
5, 6, 7, 8 line. Although the said report was filed on behalf of the respondent, but was affirmed by Subhrata, superintending engineer, having its officials deposed that the purported notice inviting tendy comes within the classification of the works conduct. However, the deponent.
Different thing. Not that it is a manufacturer.
Yes. Thereafter, Milord, it is apparent from the page 268 of the P2 annexed P2 of the manual that the procurement of the such and such.
That requires a hearing.
And
this
Milord,
is not contempt.
No, Milord, this is Milord.
Contempt has to be on a far higher footing.
Milord, I'm just.
They produced documents, they filed a report. If you want to use an exception to that report, did they give you leave?
I have already, Milord.
That will be considered at the time of hearing of this application of the writ petition.
No, Milord, section 2C of the
Read it out. Not a civil contempt, criminal contempt maybe.
Yes.
But this does not amount to criminal contempt. How can we infer
But
that
criminal contempt means the publication, whether
what contempt?
Criminal contempt.
Yes, this is.
Milord,
No.
this is actually Milord interference with the justice, Milord. I am relying on the unreported judgment of the Madras High Court.
Rely on that.
Where is those? কোথায় ছিল? এখানে তো ছিল।
There is no allegation in the affirmation in the contempt application as to that document being manufactured.
Milord, it is specifically stated, I am coming to this, Milord, that
you have filed your objection to the report.
yes,
That's on record.
yes.
So we'll consider that when you take up the report.
Milord,
Not
actually, this is as because I have not got the order of injunction, Milord, as because your lordship was under impression that this they have
produced a document showing that it has been uploaded. You are relying on an information slip obtained from where? Information slip obtained from?
Obtained from Milord Jim. This is the information slip. This is the Milord. The name is
Page.
That is at page 45. 45 is my application.
Yes, she was placing that.
And Milord 46. Applicant name Pawanwala, Shama Prasad Mukherjee Port Trust, Kolkata. A question is Milord, text of application that the period of 10 years tender was not found on CPP portal. As per the information received from NIC HOD, deemed PIO and custodian of information in reply, the said RTI application is as follows. Tender mentioned in the RTI has not been floated using NIC e-procurement system. It appears to have been floated in KOPT Inivida. The key information called metadata has been metadata has been mirrored in the central procurement portal. This is simply a mirror, but this is not Milord. This is an impression, mirror impression. But they have not uploaded. If the system has been uploaded, my lord, the entire bidding system could have been gone through that. Bids are to be uploaded there, tender to be uploaded there. Thereafter, my lord, that is the my lord, that is the bidders technically qualified or not, financially qualified. Everything will be there. But those are not there. This is a mere mirror impression has been given in the CPP portal to.
What is the meaning of mirrored impression?
Just an information, my lord.
Mirrored something. What did it mirror? It was a reflection of what? There must be some reality for it to be mirrored.
Mirror is the mirror, my lord. Mirror is the impression only. Yes, we have just.
It's a mirage.
No, it's not mirage, my lord. I'm coming to the particular document, my lord. What the document speaks.
It mirrors what? I don't understand.
As per information of the deemed PIO custodian, the RTA application as follows. The tender RTA has not been floated using e-procurement. It appears to have been floated in eVida. The key information called metadata has been mirrored. Mirrored?
Oh, you're borrowing from here, this language.
Yes. That is page 46. Mirrored in central procurement portal. There is no specific tender ID.
Where is server notice this? We have not directed service as yet. Appearing for the first time.
For further details, may be contacted respective tender inviting authority in case you want to go for further appeal related to this and this. Milord, this is that's why, Milord, this is disposed of.
This is not criminal contempt.
Milord, I am coming to the notice inviting tender. And they have categorically speaks, Milord, that
given a wrong impression at best, it could be perjury.
Let assume, Milord, before this court, Milord, to prevent my client, I have made a critical submission, Milord, making beyond that is that then, Milord, when my lord will discover
interference with the administration of justice.
Yes, my lord will discover, my lord will either send me to the bar council or issue rule against me.
That's an example, not him.
Yes.
It's astonishing.
This is an example, my lord. So, my lord.
The other side.
Yes. Now I am
bad example.
Yes, bad example. So this I could have got the order of injunction if this has not been submitted. And if this impression, this is a mirror impression, merely.
You don't even know the meaning of mirror impression. Keep shut. These are technical terms. Neither you nor I know. Mirrored, apparently, they want to mean that the key information has been also reflected. That's why mirrored. And reflected in that sense mirrored.
When
they forgot reflected, they said mirrored.
Yes.
It was uploaded in NVIDIA or whatever. NVIDIA is a graphic card, though. But NVIDIA. So that was mirrored. They want to that was also shown in this portal.
Yes.
But it was not up.
But the transaction could not be made from there.
No, not at all.
Milord, let them assign reason, Milord.
No, we'll decide when we decide on the report. When we decide the writ petition, we'll decide on the veracity of this report. But this is not criminal contempt at this stage.
Yes, Milord, let them come and say so, Milord, why this mischief has been made by them. Because in there, Milord, come to the page 70 of my contempt application. Mode of tender. Even the documents speak otherwise, advocates speak otherwise.
That is always happening in my.
And Milord, in the affidavit itself speak otherwise.
No, two otherwise is the same.
Two otherwise are same.
Out of these three, you said two otherwise is the same.
Same, but the documents speak
otherwise. Others were otherwise. Other than wise.
Milord, documents speak otherwise. Milord, mode of tender. E-procurement system online part 1.
Oh, which column? Mode of tender?
Milord,
yes, got it.
Page 70, notice inviting tender. Mode of tender, e-procurement system online part 1.
It has to be put up on the e-NVIDIA only.
NVIDIA, but this is in violation of the GFR, General Financial Rules. That is our contention. That is the writ petition was filed. And we could have gone, because we have filed the writ petition.
Very well. Serve copy. You have succeeded.
Yes, grateful.
The allegation made in the present contempt application is that the alleged contemners are guilty of criminal contempt inasmuch as the administration of justice was interfered with by giving a false impression to this court that the advertisement in question regarding the tender, which is the subject of the writ petition, was alleged to have been published in the Central CAPSE, Central Public Procurement Portal, bracket CPPP, bracket closed, whereas, from an information obtained from the appropriate authority, the petitioner has come to know that there was no uploading on the concerned portal, that is using the NIC e-procurement system, টা ছোট হাতে পিটা বড় হাতে, system, and that the key information called metadata has been mirrored in central public procurement portal where there is no specific tender ID. Full stop. Next para. It is submitted by learned counsel for the petitioner that the premise of not granting injunction, not granting interim protection to the writ petitioner stroke present applicant in the order dated April 18, 2024 was the submission of the alleged contemners that such publication stroke uploading was made in the CPPP, which also finds place in the report subsequently filed by the alleged contemners. Puts up, however, comma, since there is palpable contradiction between the information obtained from the appropriate authorities and the information furnished by the alleged contemners, comma, it is argued that the alleged contemners interfered with the administration of justice by preventing this court from passing appropriate interim protection upon giving a false impression to the court. Push up next para. At this juncture, comma, it would be premature to form an opinion as to whether an act of criminal contempt has been committed by the alleged contemners. Push up, even if such finding is arrived at by this court, comma, the court is conscious that the matter is required to be referred to a division bench to issue a rule and take up the matter subsequently. Push up next para. However, comma, at this stage, comma, before forming such an opinion, comma, the alleged contemners are required to be heard. Push up accordingly, the petitioner shall serve copies of the contempt application on the alleged contemners. What the alleged contemners? How many? Several?
Several alleged contemners, my lord. I'm coming. That is, my lord, from
Very well. All those official, all the officials.
all the officials.
Alleged contemners indicating that the application shall next be listed in the monthly list of November 2025 for passing orders. Full stop. An affidavit of service shall be filed on the returnable date by the petitioner. Well argued, Mr. Sinara. You convince the court otherwise.
Thank you.
And reverse the view. Yes.
Item number 37.
The paper book. Huh? Skeleton paper book মানে এটাই পেপার বুক পেপার বুকে আবার স্কেলিটন হয় নাকি স্কেলিটন রেকর্ডস হয় স্কেলিটনের মতো দেখতে এটা আসল পেপার বুক এটা এক্ষুনি শেষ হয়ে যাবে শুনে দিলেই হয় None appears for the parties at the time of call. Full stop. Let the matter stand adjourned for the day.
Item number 38.
এত রোগা বেঁচে নেই বোধ হয় অ্যাবিলিটি রমাপতি রায় বেঁচে নেই কেউই বেঁচে নেই যাই না None appears for the parties at the time of call. Adjourned for the day. Same order. কি কোনো আগের অর্ডার আছে পরেরটা কি আগের অর্ডার আছে দেখি একবার অর্ডার শিট
Item number 39.
একসঙ্গে করে দেবে পেপার বুকের সঙ্গে সেম অর্ডার
Item number 40.
অর্ডার শিটটা থাকলেই হবে, পেপার বুক থাকলে একসঙ্গে করে দেবেন। দেখি একবার ঘুরিয়ে দিন, এদিকে ওখান থেকে ঘুরিয়ে দিন। হ্যাঁ, সেম অর্ডার।